Good morning, good morning, good morning, and hear ye, hear ye, hear ye. We are here today together on this Friday, June 13th. It is the day for closing arguments. The court had told everyone to be prompt this morning and on time and ready to go, had called the jurors and asked them to come in early and wanted to start closing arguments promptly at 9 a.m. Eastern Standard Time. Well, that hasn't happened this morning, so we are going to go to court and see what happened when they went on the record, because they have not begun closing arguments. There were 31 days of evidence, 8 weeks, and the court granted the attorneys an extra 15 minutes for closing. So we'll see how that goes. And yesterday I had talked about the normal process for closing arguments. However, I forgot that nothing is normal in Massachusetts and that closing arguments are not prosecution, defense, prosecution, rebuttal. They are defense first and then prosecution, rebuttal. I have wiped it from my mind that it's just the one and then the one, but we will see the defense go first whenever they start closing arguments, and then the Commonwealth. The court will do a few opening instructions to the jury, then they will hear from the lawyers, then there will be a quick lunch break, then the court will read the hour of closing arguments, and then the jurors will go back to deliberate. The court had asked if they could stay late today for deliberations, so make sure you have the Law & Order app, because I will let you know when we know something or if something happens in court or if we are going live. And we will be sending those out a little bit earlier because yesterday, with all the things going on with outages around the internet, they were getting a bit delayed. So we rather have you get those notifications just a bit early than a bit late, because I hate it when I see in the chat, oh no, I missed it. Just flooding into the chat. So we're going to make sure that you do not miss it. We are going to go to court. I just want to make sure all my audio is in the right place. We are going to go to court and see exactly what happened. And then we are going to wait together. We'll answer some questions. We'll talk about last trial versus this trial if we have time. And then we'll get into closing arguments together whenever they begin. So we should just go to court. This is first thing this morning. Don't worry, we've got Zoom room and we need it.
You are unmuted.
They unmute everybody. Lawyers are in court. Audience is in court.
Agree with that? Oh, that's complete garbage.
And immediately what I hear is Brennan say, I think it's Brennan, do you agree with that? And somebody said, no, it's complete garbage. Did you hear that? I don't know if that's Lally, but listen again and see if that's what you hear and tell me.
Do you agree with that? Oh, that's complete garbage.
No, we'll be maybe seated.
Jurors on their way?
No, we need to be heard.
I think it's Lally that says, no, that's complete garbage.
Unfortunately.
Okay, come over to sidebar, please. The jurors are on their way.
We need to be heard, unfortunately. The jurors are on their way. Do I know what that's about? No. Can I guess? I can guess. I have to wonder if it is about either the verdict form or if it is about the special instruction that the defense asked for yesterday. It was a strong special instruction. I said I thought that the court might modify it, and I wonder if it's one of those two things. I'm not saying it is. I wonder if it is, because those are the only things at this point that I think the prosecution is going to have such a strong reaction to. Verdict form, special instruction. And complete garbage leans towards special instruction for me, but that's purely speculation. We do not know if that is true. We do not know if that's true. But it sounded like Lally saying that's complete garbage. The prosecution is at counsel table with their laptop, it looks like. Let's see. Is defense is also in a huddle? You guys let me know where you're coming in from. I've got a cappuccino here in Middle Tennessee. The defense is also in a huddle. Everyone stood up. I presume that's for the jury coming in. But then look at how long they are on the fan. Look at how long they are on the fan. The lawyers are out or at sidebar. They're on the fan. Like we got from fan to courtroom with the lawyers seemingly at sidebar. So the court comes back out.
You are unmuted.
Court comes back out. Court had gone back to chambers for something.
Can you set this up?
Thank you.
Evidence here, I need to see that flash drive.
Court comes back out
Now opening may be
Here, I
seated.
need my mouse, too.
talking about the flash drive. Let's see what they do.
All right, so why don't I see counsel over here at Sidebar? I've got my computer up.
Why don't I see counsel over here at Sidebar? Back to Sidebar. This whole morning. And let's see where we're at. And that is where we live. It seems that the lawyers are still at Sidebar. There are computers back and forth. There is tech team going on. I wonder if they are reviewing closing arguments. So, yeah, this morning, what has happened? This is what has happened this morning. This is it. So we are going to just stay in real time. I don't know if the defense is editing something. I don't know if the videos that might be played in closing are an issue, or some of the slides played in closing are an issue. That's possible. It's possible that there are objections to some of the slides, but there we go. Karen looks like she's editing on something on the computer. I 100% agree. So here we are together again, and we're in real time waiting for court to start together. So we're going to answer some questions. We're going to chat about the things. Did I play the intro yet? I don't think I did. I can't remember. Let me know if I did. If I didn't, I'll just play the intro. I don't think I did. So let's play the intro. We're in real time. We're going to do kind of a wrap up of this trial, yes trial, this trial, last trial. And then I'll do a bit of a summary of how many days we had and the rest of it last time, because here we sit together to do this. But can we take a moment to appreciate the fact that there are now microphones on the jury stand facing into the well? So if the lawyers wander in front of the jury for closing, there are microphones pointing that direction. They didn't have that last time. They have it now. So let's roll the intro. I'm going to turn into Mr. Alessi like everyone else. Let's roll the intro. Let's talk about last trial. Let's talk about this trial. Let's answer some questions. Because what could be more important? And maybe eventually we'll have a trial and some hearings. Maybe we won't. Who knows? But maybe we will. But I'm so optimistic about those mics now. If they don't turn them on, I'm going to fucking lose my mind. But I'm so optimistic at this moment. Emily, you started out this trial really optimistic too. I did. I'm not going to let anything change that optimism. We're leaning in. Law nerds, let me know where you're coming in from. What you're drinking, what you're eating, what you're doing. Are you trying to zoom through this because you got to work, or we crafting, we gaming? What are we doing this morning? Let me know. Let's go. Hey there. I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. Emily, how fun is it to just wait for court? Well, it's miserable, but we get to talk to each other. Guess who it's more miserable for? Yeah, the jurors. Can you imagine? The court calls you up. Hey, juror number 7, could we be a little early today? We're going to get started right on time. You're going to get this case today. You're going to get closing arguments. You're ready to go. We're ready to go. And you get to the courthouse early. And let's see what time it is. And the jurors have been now sitting, waiting for at least 45 minutes. At a minimum, 45 minutes. They've been waiting. Are you just done if you're the juror? You're just like, you bring me here early, And now we're just going to sit and wait for another 45 minutes. The judge told the lawyers to be there a half hour early so they could be ready. They were there. Everyone was there. And now waiting. The waiting is the hardest part. Now waiting. Now waiting. That's it. So frustrating for the jurors. So frustrating. So the Drea said she wasn't early. The judge took the bench before 9 a.m. So they were early today. But the jury is supposed to be there. The court said we're calling the jury up, and whatever issue they are dealing with at sidebar, which probably has to do with closing arguments, whatever issue they are dealing with at sidebar has been taking quite a bit of time. Oh, the lawyers are going back to their spaces. Oh, and they're getting ready for closing. Jackson is like, where would I like the podium? Here is the podium. Where's the camera? I'm teasing. No, I'm not. Jackson said hi to us. Where's the camera? Where is it? Is it there? I rewound it. Good morning. Yeah, we're here too. All of us. 100% here too. So maybe...
All rise for the court, please.
What? So maybe we're getting ready to go. So maybe we're ready. Nope. No, we're not. All right. Well, the court is off the bench going back to chambers. The jury might be coming in. Maybe. Let's cross our fingers that the jury's coming in. Let's give a quick by the numbers as we all wait for this to come in together. I was like, the jury? Do we have a jury? Maybe? Maybe not. We're going to keep this rolling. Rolling. Emily, it's too early. No, it's never too early. We're going to keep this rolling. I'm going to keep court on screen with us because, here, I'm going to make that a little bit bigger. I'm going to keep court on screen with us. We just need our comfort court. For this morning, we just need our comfort fan. We're so ready. We just need our fan. Let's do a little quick by the numbers of this trial, last trial, shall we? Yeah, Emily, why are we doing this? Because I went through and looked because I was curious. So this trial, the Commonwealth called 38 witnesses. The defense put on 11 witnesses. That is more for the defense, less for the Commonwealth than last trial. 31 days of evidence, 8 weeks. Last trial was 9 weeks. So we are really just about a week less than the last trial. And I remember Brennan being like, we're going to streamline this shit. Well, they streamlined it by about a week. The jury deliberated for 5 days last trial, including over a weekend. And the jury came back with questions, but it wasn't for a few days. So there were days of waiting on the jury that we heard absolutely nothing. And then we started to see those questions from the jury. The court's hope is that the jury starts to deliberate today. We will see how that goes. They're going to have some amount of time. What amount of time they're going to have is kind of unknown to me at this point because, well, the court had hoped to start opening about a half an hour ago. They're already going to do a shorter lunch. And I realize we have a lot of new law nerds in the chat. I do not poll as to things that are in the purview of the jury. I haven't for any trial. I'm not going to for this trial. I do not poll. And if you ask the jury to just do like or if you ask the chat to just do a straw poll on the jury, I will 100. Well, the yeeting will be swift. So I do not poll. It is the jury's job. We will poll on other things. I do not poll on that. It is based on the jury. The jury gets to decide. We will talk about things later. We will talk about whose closing argument you found more persuasive. We will talk about whose arguments you found more helpful. We will talk about other things, but we will not poll, and I will not poll on things that are for the jury. And yes, after the verdict, we can poll on some of those things. So do not worry. We will talk about it. But no, how the internet feels the jury might vote and how the jury might vote are not the same. We also don't know all the charges just yet, right? We do not know what lesser includeds they have added. We don't know if they have added a DUI. We do not know. Oh, are they going to unmute? I see the closed captioning saying that they might. Nope, we're still muted. We don't know exactly what the charges are for count 2. We just do not know yet because the defense is asking for just a plain OUI DUI in addition to the other counts in count 2. Let's give us a little overview of what happened yesterday. Yesterday, they had the charging conference. We have a case brief up on it if you want to watch, like not the whole stream, but just the summary of the stream. The defense withdrew their necessary witness, missing witness motion and said they're not going to argue that. They're not going to cover that. And so we aren't going to see that given to the jury, and the jury told they can make an inference from it. The defense can argue, look, who didn't get called? But they cannot get an instruction on it. They withdrew that motion. They also were fighting for their Bowden defense. We know that they were. What is the Bowden defense? That is not third-party culprit. The defense, though they talked about it a lot elsewhere, the defense did not ever put forward a third-party culprit defense. They talked about it a lot, but they never got a third-party culprit instruction, and they never truly argued a third-party culprit defense. That means some other dude did it, and this is why. They did not do that in this case. They did not do that in the last case either. The Bowden defense is look at what law enforcement should have considered, should have followed, leads they should have looked at, things that would have made sense to follow up with that they didn't follow up with. And that makes sense. Venko said the defense didn't get to. They did not ask for a third-party culprit instruction last trial. They did not meet their burden. And I don't think they were able to meet their burden, and they weren't able to meet their burden this time. They did not meet their burden. So they did not ask for the instruction. And last time, they put on a bunch of evidence, and they still didn't ask for the instruction. And it's because they didn't meet their burden. But the Bowden defense, I think, is a stronger argument for the defense. The Bowden defense is look at all the things the police didn't look at. Look at all the things they didn't investigate. They zeroed in on, I almost threw my glasses off my phone. They zeroed in on Karen Reed and they looked at nothing else. I think it is an easier argument for the jury to understand. I think it is a stronger argument for them to make. It requires less logical leaps for a jury. Look, shortest distance. Yeah, look at what the police didn't investigate. Yeah, why didn't they ask about that? Yeah, why didn't they ask about that? Exactly. Why didn't they ask? Why didn't they ask? So let's continue on. We will see the Bowden arguments in closing. We'll see what else we'll see in closing. We're going to see lots of Karen Reed's clips. We know that's coming in closing. And then whenever we get to it, I'm sure we'll hear the judge apologize to the jury. Ladies and gentlemen, I'm so sorry to keep you waiting. I promise the things that we have done is to streamline today. Well, the jury's now been there for almost an hour waiting to be streamlined. So there is that. Let's get into some of your questions. For those of you just popping in, the order of closing arguments is defense and then prosecution. I completely forgot that Massachusetts does not split up the prosecution closing. Again, my brain just defaulted to what the majority of jurisdictions do, which is prosecution, defense, prosecution. Massachusetts is like, no, you each go once. Prosecution goes second. Okay, sure. Oh, Octo, good to see you in the chat, friend. Friday the 13th. I think Friday the 13th can be a lucky day, but it is a Friday. It is the end of 8 weeks. This jury is, I think, probably pretty done, right? I always chuckle with the YouTube notification live trial analysis. We're going to have to change that next trial to commentary. The cutoff is brutal. Live trial commentary. We're going to have to change it to like live trials legal or something. Because if that's how it's getting cut off, we're going to have to change it. But we did call the live trials podcast live trials because it gives us all the coverage of the live trials. And I think this week we were number 6 on YouTube, like on all of YouTube in the US for podcasts, which is wild. You guys are the best. Let's see. Congratulations to all the law nerds. And let us continue. Oh, one of the things I noticed in the defense motion for jury instructions yesterday, I went through and found those. What I noticed is the defense did include the standard jury instruction that the juror in seat 1 would serve as the foreperson, which is apparently incredibly common, not just in this courtroom, but in many courtrooms in Massachusetts. It's in the jury instructions that juror number 1 will now serve as the foreperson. So it seems that juror number 1 is the foreperson just because juror number 1 is the foreperson. Bixo, thank you for the gifted memberships. I appreciate it. Let us continue. Laura said, will there be a members live today after yesterday's internet yeeting? It's going to depend on how today goes. We will, over the weekend, be doing a behind the scenes podcast recording for sure. But it really depends on today because if we are on verdict watch, we will not be doing any streams until the jury goes home. And then I have to check in with the kiddos. So juror number 1 will be the foreperson. A lot of you are saying, what if juror number 1 gets selected as the alternate? Well, if juror number 1 gets selected as the alternate, juror number 2 would move to seat number 1, and then they would become juror number 1. Wendy asked, how do I get a gavel? Those are for the members, and we've had so many of you gift memberships this morning. It's been incredibly kind. So either through gifted membership or through membership, that is where those come from. They change colors with how long you've been a law nerd. I can confirm I giggle at that daily. Well, we've had 33 days to giggle about Emily calling it live trial analysis. But it's really funny. It's really funny that it clips that way. Next trial, we're changing it because I can hear Warren in my head going, yeah, we're changing that immediately. We're changing that immediately. Holly, thank you for the gifted memberships. A lot of you are saying that there were some new things this morning. Let me go look. Diana said, what if juror number 1 doesn't want to be the foreperson? Well, they get volunteered. Sometimes you don't want to bring the cake either. And that's what you're getting. So let me see if, let me see what I can find. I want to make sure that we keep the fan up on the screen. Are y'all okay if I go through the motion and talk about it with you and leave the fan up on the screen? Or do you want me to bring the motion up? I can bring the motion up, but I'm going to have to keep looking at the fan. I want to know like the second that fan moves. Y'all are fine with it if we leave the fan? Okay. We're leaving the fan. Let me check for new motions. Look, chat is bae. When you guys are part of the live stream, you get to decide how it's going, right? You get to decide. All right. I know we're all grasping our emotional support fan. This morning, the defense filed a motion that is titled, well, the defense always titles their motions in such a sassafras way. We should swoop since we're going to be here for a minute and we're going to need it for the timestamps. Look, live trials with Emily D. Baker as determined by the chat. We're just here hanging out. I just want to drink my coffee while it's hot. I thought we were going to have some I'm going to be out of coffee before we start closings. Damn it. This is dated from yesterday. So this was a motion from, no, this is dated today. This is Friday the 13th. Defendant's motion to ensure transparency and alternate juror selection process. Comes now, defendant Karen Reed. The right to a fair and impartial jury is protected by the Constitution. The selection and seating of jurors, including alternates, it says, is integral to the safeguarding of a defendant's process. Ambiguity in the alternate jury selection process could undermine the integrity of the entire trial. The defendant requests the court issue an order setting forth the method by which the alternative or alternate jurors will be identified. The court normally does it by like draw. So you should just do the draw in front of the attorneys. But the court's not going to issue an order on that. Like the court's not going to issue an order. They're just going to do the draw with the attorneys, as they should. The defense then says...
All persons have any business before the honor...
Oh, we're here. The defense then asked that it be done in open court. The court denied it. I think the court probably denied it because the court's not going to issue a formal ruling on that. The court should do that where the attorneys can see it. So hopefully we will see the alternates get picked. The alternates will get picked after all of the jury instructions are read to court. All right. I stepped on the hear ye's. We're going to back up the hear ye's. We're going to hear the hear ye's and we're going to get going. We're going to get going. So let's go to court.
All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court and before the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning, jurors. We were just working up here to streamline things.
So I have started far too many mornings by saying to you folks, I apologize for the inconvenience, having you wait around so long. I appreciate your patience. I didn't want to do that today, but I had to do that today. Everybody has worked so hard on this trial, the jurors, the lawyers, the witnesses, that everything has to be right before you hear it. So I needed to do that this morning. I apologize. I do have to ask you those
three questions.
Were you all able to follow my instructions and refrain from discussing this case with anyone since we were here yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear,
the court's
or read
away from the
about
mic,
this case since we left here?
And that's why it's tough.
So as you know, it's time for closing arguments. And when I was a trial lawyer, I never liked it when just before closing arguments, just before I stood up, the judge would say, jurors, remember, closing arguments are not evidence. But it's true.
Jurors,
Closing
remember,
arguments are not evidence.
closing arguments
Lawyers aren't witnesses.
are not evidence.
Because they're not evidence, I need you to put away your notebooks because you can't take notes on them. But the reason it
I'd be
used to
so
bother me
annoyed.
is because I sensed that it made it sound like they're less important than anything else in the trial, and they're not. They're certainly a very important part of the case. And we've all noticed that you've paid very close attention to this case, and we know that you'll do the same to the closing arguments. A couple of things I want to say, and you'll hear more about this in greater detail.
I'm going to try to gain her up just a little bit.
First is, you folks are the fact finders. So it's what you find from the test.
Normally, the judge gives these instructions seated at the bench. She's just standing looking at the jurors. So I'm going to gain this up as much as we can. These instructions are part of the jury instructions. She's standing up and telling them to the jurors, but these are those instructions you get before closing starts. And every single time they are told opening statements and closing arguments are not evidence. That is just facts.
Testimony, your memory of the testimony, this has been a long trial, but your memory of the testimony, not the lawyers and not mine. So if the lawyers or I say anything that doesn't square with your memory, it's your memory that serves. Secondly, there are very important constitutional rights that I hope that you understand, or constitutional concepts that you need to understand. First, again, the burden of proof in this case is proof beyond a reasonable doubt and to a moral certainty. And the Commonwealth bears the burden of proof. Right? The burden of proof is on the Commonwealth to prove beyond a reasonable doubt and to a moral certainty.
Court wasn't even rattled by that.
In Massachusetts, because the Commonwealth has the burden of proof, the Commonwealth goes last in closing arguments. I've given each lawyer an hour and 15 minutes, and I'm not going to stop them. So we'll start with the defendant's closing arguments. So, Mr. Jackson.
Do you remember last time she stopped Lally? Last time she cut Attorney Lally off. She cut Attorney Lally off and was like, "You're out of time, my guy." If he walks up to the microphones, I'm going to keep it gained down. If I need to turn it back up, I will. Ladies,
there was no.
We know where he's starting, don't we? It's time for closing arguments. Let's go. Let's go. It's time for closing.
There was no collision. There was no collision. There was no collision. I want to take a minute.
Thank you. And
start off with thanking you. I want to thank you for your attention. I want to thank you for your patience. I want to thank you for your diligence. This is not an easy undertaking. Most of all, I want to thank you for your courage, because courage is what this moment demands.
Oh, it's like a rallying cry.
Not just to listen, but to stare directly at injustice and say, not here, not now, not on our watch. That's what you're being asked to do. Stare down injustice. I want to start with a simple truth. You folks, not us, nobody else in the courtroom, you folks are the last line of defense. The last line of defense between an innocent woman and a system that has tried to break her, that falsely accused her, that tried mightily to bury the truth. This case was corrupted from the start. It was corrupted by biases and conflicts and personal loyalties that you heard about. And most fatally, it was corrupted by a lead investigator whose misconduct infected every single part of this case from the top to the bottom.
Now we're here.
In our opening comments to you a few weeks ago, we told you what to watch for. We warned you what to watch for. We begged you what to watch for. Watch for the physical evidence. Pay attention to the medical facts. Pay attention to the science and the physics. But also pay attention to the integrity, the very essence, the integrity of the investigation. But you also saw something during the course of the trial that none of us might have expected, something that should sadden us, something that maybe would anger us. On full display, you saw the lengths to which some police officers will go to protect their own at the expense of the rest of us, at the expense of Karen Reed, an innocent woman. Before we examine the evidence in the case, which we will do, we need to understand the very foundation of the entire system of justice in which we operate. It's the bedrock on which this entire system is built. Reasonable doubt. This isn't just a technicality, and it's not a slogan. It's a constitutional shield that protects the innocent.
The defense team's
and
looking
prevents
at him
the government from
while he's
punishing
arguing
without proof. The Commonwealth has the high burden to prove every single element of every single charge beyond a reasonable doubt and to a moral certainty. As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice. In our system of justice, Karen Reed sits here today presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands firm unless and until the Commonwealth clears that high bar, the highest bar the law provides.
Just go back to
proof
Jackson.
Beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, you know what, maybe that's true. It might be true. Then you vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks it's likely
That's a good
true,
point.
or even very likely to be true, your vote is not guilty. It's because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of
Right.
those meets the extraordinary burden of beyond a reasonable doubt and to a moral certainty. A moral certainty means a level of confidence so strong, so incredibly unshakable, that you could go home, you would go home, look your loved ones in the eye and say, I am certain. Not probably, not likely. I'm morally certain, and my certainty remains unshakable. The law defines moral certainty as the highest level of certainty known in all human affairs.
It's a
Think about
strong
that.
instruction.
You must be that certain about the entirety, not part of, the entirety of the Commonwealth's case. As we discuss this case, you'll see that the Commonwealth comes nowhere near, nowhere close to reaching that extreme burden of proof. Ladies and gentlemen, on January 28th, 2022, it was a Friday night. John O'Keefe and Karen Reed made plans to meet up with friends, go out for drinks. You saw through video evidence and eyewitnesses that they were affectionate, they were loving, they were in good spirits throughout that evening. They started off at C.F. McCarthy's, which you've heard about, and eventually made their way over to the Waterfall Bar and Grill. When they got there, the Albert family, they were already there, and they were already drinking. The Albert family, it's been established as a very well-known family in Canton. They've got quite the reputation. Brian Albert was at the Waterfall, a longtime Boston police officer. His wife, Nicole Albert, was there. She was with him. His brother, Chris Albert, who was a Canton board selectman, he was there. His wife, Julie Albert, their daughter, Caitlin, and his sister-in-law, Jennifer McCabe, whom you met, and her husband, Matthew McCabe, whom you did not meet. They were all there drinking before John and before Karen ever arrived. But also present at the Waterfall that night was Brian Albert's friend, Brian Higgins. We know that he had a romantic design on Karen. That becomes an incredibly important fact as we discuss the facts of this case. As the bar was closing around midnight, the Alberts invited everybody back to their house. They wanted to keep the night going. But the evidence revealed something interesting, that the invitation to John O'Keefe appears to have been for a different reason, an alternate reason. Think about the video of Brian Higgins and what Michael Proctor in his investigation completely and utterly ignored. Higgins was agitated after a day of drinking, agitated that it was John and not Karen.
We knew we'd hear about Higgins.
John with Karen, not him. Recall that ominous text that he sent to Karen with her and John standing just feet away. Well? He got no response.
But John did
And then we
kiss
see
Karen on the
this.
face. John kissed Karen on the forehead. Is this going to be the forehead kiss?
That's what Brian Higgins was confronted with following his well text. What of all things
Sure,
starts
that's
going
clear.
through Brian Higgins' mind? Where does his mind go? What is he thinking about after seeing this, after witnessing this? He shows you. And if Michael Proctor had been the least bit interested, this video would have shown him too. Take a look.
That video is John and Karen kissing, and John kissing her on the head. And then we've got the, I don't think it was described as grab-assing this trial, but the grab-assing. I hope it's clearer in court too. But the freeze frame was John kissing Karen on the head, standing closer to the bar, Higgins being closer to us, with Higgins with the Harley Davidson on his sweatshirt. And the two of them. What did Trooper B call this? The rear thrusting? Something
Sparring,
like that.
practicing, fighting techniques.
Peacocking.
Where was Brian Higgins' mind?
Showing off.
What was he thinking about?
And acting like 13-year-olds.
And then what happens?
To get a girl's attention.
Before you look at the next video, think about what you're going to see. This
I
next
don't think
video
they're
is after he
practicing.
sees John kiss Karen on the forehead, after he sends that aggressive text to Karen with her standing just feet away. Watch closely, and this is what you're going to see. This is what Michael Proctor and his investigation completely ignored. Higgins is very clearly upset. He's agitated. Chris Albert tries to control him. He tries to talk to him.
You know what this is? This is as awkward as those fucking text messages. That's what this is. This is look at me, look at me, look at me. Look at me and my buddies. They're not practicing. This is as awkward as those goddamn texts. Now, when he gets grabbed on the arm later in the video, that I find more powerful. This, I think they would have a much better argument saying he is trying to get her attention. He wants her attention. He is messing around with her friends. Look at me, look at me, look at me. And then John kisses her on the forehead, and then his friend is grabbing his arm. This is not a practice fight. This is attention-seeking behavior. That's as cringy as the texts.
Calm him down, perhaps. Chris forcefully grabs Higgins' arm. You'll see that in the video that you're about to watch.
not see
it
this
appears that
as
Chris
that.
is trying to calm him down from something. Brian Albert's standing right there with the other two men, but Brian Higgins is having none of it. He appears to be hyper-focused on one person and one person only, John O'Keefe. In an instant, Higgins angrily jerks his arm away from Chris. Higgins rubs his brow, and he directly gestures at John.
Yeah, show that.
A gesture that looks a lot like, let's step outside. Let's go outside. But John looks at him, takes a swig of beer, completely ignores him. Take a look.
This is a better point. He's trying to get her attention. He doesn't. She's kissing John. And then his friends are like, let it go. Let it go. But whatever. And then I imagine they'll get to Higgins' text. Higgins texting John, are you coming with us? But Karina Kolakithis is sitting right there with Karen and doesn't say anything's out of place.
Michael Proctor,
doesn't
the
say
lead
anyone's
investigator
upset.
in this case, had all this footage, but he did nothing. He had access to the exact same thing that you saw. Why did he do nothing?
And that's a good argument.
A few minutes later, Higgins then texts John directly.
That's a
You
good
coming here?
argument.
3 question marks. It's now 12:20 a.m. These guys are not good friends. They barely spoke or even acknowledged each other when they walked into the bar together, other than a quick greeting. So why was Higgins coaxing John over to 34 Fairview? You coming here after this? And why not text Karen? Because at that moment, he wasn't interested in Karen. He was interested in John O'Keefe. This is about 5 minutes before John gets out of the SUV and walks toward the house. About 5 minutes before Karen sees him alive for the last time. So what happened inside that house, or that basement, or that garage? What evidence was there for the investigators to look into? What did they ignore?
That.
Laceration over John's right eyelid.
That's the Bowden.
Black eyes. A large dog at the home. An obvious dog bite on John O'Keefe's right arm. A head injury from falling backward onto a hard surface. Alleged surface. A text from Higgins, one of the last people to ever communicate with John O'Keefe. You come in here? Those words now echo in the wake of John's death. But Michael Proctor, he didn't listen.
That's the Bowden argument.
When John didn't come back outside, Karen, very oblivious to what had happened, thinking she was just left alone in the car, out in the cold, in the middle of the night, she got frustrated and she drove home. She arrived back at home, and her Wi-Fi connected to her car or phone connected to John's Wi-Fi at 12:36 a.m. It's an important time, 12:36 a.m. She left John voicemail after voicemail after voicemail. He was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got.
As one
The
does.
voicemails reflect that frustration after the fact. That's the frustration that you hear in her angry voicemails. She uses harsh words and foul language. She's obviously upset. She's obviously irritated because he didn't come back out of the house and he wasn't responding. But Karen did not know what you know. She didn't know what the investigators should have known. She didn't know what was happening with Higgins and Albert and with her boyfriend, John O'Keefe. When he didn't come home at about 5 a.m., Karen went looking for him in a panic. As you know, her worst fears were realized when she found John beaten, battered, bloody, and left in the snow in Brian Albert's front lawn. At 6 a.m., when Karen found John, you heard about the scene. It was described in detail. It was chaos. To use Mr. Brennan's word in his opening statement, it was bedlam. The screams for help by Karen, the yelling and the hollering, ambulances, emergency lights, fire engines,
Nobody
ladder
comes
trucks,
outside.
paramedics, patrol vehicles, patrol officers, all of them swarming all over the lawn just under Brian Albert's bedroom window. And of course, as you learned during the course of this trial, Brian Albert, a sworn peace officer, a first responder trained in being a first responder, never came out of the house.
Least
Never went
curious
outside to help a
cop to ever
fallen
exist.
fellow officer who was laying on his own property. Never came out. And you learned through the undisputed evidence that the lead investigator, Michael Proctor, for his part, never went into the house. The Commonwealth has struggled to try to prove that John O'Keefe ended up in Brian Albert's front lawn because he was struck by a vehicle. They have failed. They cannot and they will not ever be able to prove that John was struck by a vehicle beyond a reasonable doubt and to a moral certainty, because the science does not lie, the medical evidence does not lie, the physics do not lie. Their investigation was flawed from the start because their investigator was corrupted from the start by bias, personal loyalties.
Notice how he keeps saying their investigator.
Folks, they cannot prove a collision.
Theirs.
John O'Keefe was not hit by a car. There was no collision. So let's start there. I want to take a minute to discuss the actual science, the actual physics, and the actual medical evidence that was presented in this case.
If you give me
The
physics
science,
equations,
it's an old
going to
saying,
yell.
is known as the silent witness. It doesn't lie, it doesn't forget, and notably, it doesn't take sides. If there was no collision,
Brennan's going to use that.
what are we doing here? In order for there to be a collision, there has to have been an impact site. The vehicle had to have struck John, period. I want to remind you of some of the most important testimony in the entire case, and it comes from the Commonwealth's own medical expert, Dr. Irini Scortibello, the Commonwealth's medical examiner, someone governed by law to make these decisions. We know that a person struck by a vehicle suffers massive trauma, broken bones, fractures, soft tissue damage, torn ligaments, contusions, soft tissue injury, severe tissue injury, crushing blows. None of that was present with John. None of it. Not anywhere on his body, including his right arm. Not one bruise. Nothing. The fact is, the injuries are not from a vehicle impact. Not his head injury, not those scratch and bite wounds. Not a single medical expert, think about this, not a single medical expert called by the defense or called by the Commonwealth has testified that John was hit by a car. Not one. Think about the irony. Not one.
It's a good point.
That's not just significant. It's literally the most important point in the entire trial. Listen again to Dr. Scortibello's words. Question. You did not include in your autopsy, in any fashion, any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident. Did you? Answer. No.
Right.
I did not. She told you, quote, I did not see any evidence of an impact site, end quote. She was talking about John's body. The Commonwealth's own medical examiner, Dr. Scortibello, performed the autopsy. She did it personally. She's the only one to have personally examined John's body, and she found no evidence of an impact site on his entire body. That in and of itself is reasonable doubt. You don't need anything more. The Commonwealth's case is done. It's cooked.
Undetermined.
Their own experts said there
Seriously?
is no evidence of a collision.
He almost said collusion. It's cooked. The chat's all going to be like, let him cook. AJ, it's cooked. How young is this jury when you're working and it's cooked? Somebody he's looking at this jury going, it's cooked. I'm living. All right, I backed that up a little to let him say it's cooked one more time. Oh, the parlance.
Is reasonable doubt. You don't need anything more. The Commonwealth's case is done. It's cooked. Their own experts said there is no evidence of a collision, no evidence of an impact. If you want to know what an impact looks like, take a look at this.
Oh, this is going to be from
This
Welcher's
is what a body
report.
looks like after being struck by a car.
Thank you, camera.
25 miles an hour. And this is what a car looks like.
I have to pause him to point out that the images from Welcher's report of the car and of the victim of that example case would never have come into evidence if the Commonwealth had not brought them into evidence. Those images, had the defense wanted to bring them in, would have been objected to and it would have been sustained. This is why the defense didn't object to Welcher's report coming in. Welcher's report didn't have to come in. They didn't object so they could use this. It wouldn't have been an evidence for them to use in closing if they had objected. And if they had tried to bring it in, it wouldn't have been allowed. That's the pictures they're showing the jury. The pictures of the test case victim and the car. So when we talk about strategy, you don't always object when you can for moments like this. So they can use it. They could have kept it out and they didn't. For this. That's the strategy.
After hitting a person at 25 miles an hour. These are exhibits from
Right.
Dr. Welcher,
Right.
the Commonwealth's expert. John didn't even have a bruise. Make no mistake, Dr. Scortibello was presented with the Commonwealth's theory of the case, the same case that you've been presented with, and she refused to conclude that John's death was a homicide. She flatly refused to conclude that there was a collision. And you know who agrees with that? That silent witness, the science, the physics, the data. Dr. Wolf and Dr. Rentschler, you just met them recently.
Undetermined.
They explained they were not initially hired by the defense. They were asked by another agency to conduct their analysis. They looked at the evidence from both sides, not taking a side for the defense or the Commonwealth, completely independent. They looked at the damage to the SUV on the one side of the coin. They looked at the injuries to John O'Keefe on the other side of the coin. Both PhDs, both engineers determined there was no collision. I'm not saying it. The science says it. That SUV's taillight was not damaged by striking an arm, and John was not struck by a 6,000-pound SUV. Period. Full stop. Dr. Dan Wolf did the testing on the taillight. Actual testing, not some ridiculous blue paint kindergarten project. He did lab testing. He did field testing. He did data testing. Actual impact force analyses. In every single test at every single speed, the taillight damage was inconsistent with striking an arm. In every test, the taillight damage was inconsistent with damaging the shirt, the sweatshirt. Remember that severe internal damage to Karen Reed's taillight. Not just the outer lens. The internal diffusers were completely smashed, completely shattered.
It's a great point.
ARCCA testing established that all the internal components of every single test taillight, especially the diffusers, remained completely intact. Conversely, on Karen's taillight, the diffusers were almost completely gone.
Right.
Folks, understand something. If any part of that diffuser portion of the taillight is broken, there is no light. It doesn't illuminate at all. It's just black. Let's take a look at a couple of photos.
Right.
At 5:07 a.m.
I was wondering if they were going to
at One
bring
Meadows.
this up.
That's the photograph on the left. What do you notice about the right taillight? It's completely illuminated. Later, at 4:12 in the afternoon, photograph on the right. It's lit up. How can that be? How can that be if the Commonwealth claims that those diffusers, the portion that lights up the light, were already scattered all over 34 Fairview? That's their theory. But don't believe your lying eyes. The taillight's completely lit up.
We've gone well
That
back
would be
from Gen Z
impossible.
with that. A lot of you asked, why didn't he hammer on that point more about the diffusers? Why did they ask 1 or 2 questions about it and move on? This is why. They wanted to highlight it in closing. They didn't want Brennan to ask a lot about it on closing, so they got the 2 questions in and then they scooted right along, hoping that Brennan wouldn't ask more about it. Scoot, scoot. That's why they just asked 2 questions about the diffusers. And all of you in the chat were like, wait, it's not going to light up if the diffusers are broken.
Dr. Andrew Rinchler, a PhD, a biomechanist, explained that at those speeds,
Saved it for closing.
the other side of that coin, John's arm would be basically destroyed. Contusions, swelling, torn ligaments, hyperextensions, dislocation of joints and bones, fractured, broken, and shattered. But as you know, John's arm was pristine, save those dog and claw bites. He didn't even have a bruise.
We saw it in the x-rays.
Think about this. Think about that photo of those x-rays as you deliberate. You can manipulate a
X-rays.
taillight fragment. That's not that hard. You can't manipulate a bruise. If they claim the car was going fast enough to shatter the taillight and shatter the diffusers, then it was also going fast enough to destroy and shatter John's arm, and it simply did not. How do they square that? They don't, and they can't. So they spent nearly $400,000 of taxpayer money to hire someone to dress up and look like John and paint his arm blue,
Oh boy.
which told you exactly nothing. The ARCCA testing, conversely, also established that it is impossible for John's sweatshirt sleeve to be damaged by an impact with the taillight. The Commonwealth's theory is that the sleeve of John's hoodie
The
sweatshirt was
shade
damaged by
is
flying shards of
wrong.
taillight slicing through the shirt and through John's arm. I have 3 questions. Number 1,
We have
John's
questions
arm had
too.
about 36 abrasions. How did 36 shards of acrylic go through 9 tiny little puncture holes? How'd that happen? Somebody needs to answer that. Number 2, why are there no slices or cuts in the hoodie? All the defects are punctures. Punctures that you might get from, say, I don't know, canine teeth. And number 3, if the shards cut bloody gouges into John's arm, that's their theory, why is there no blood, no skin, no tissue on a single shard of taillight that
It's a real
they
good
claim
question.
came in contact with John's arm?
I'd really like someone to tell me.
The Commonwealth cannot answer a single
It's that
one of
one
those
for me.
questions because John's arm was not impacted by the taillight. It doesn't make sense simply because it didn't happen. Compare and contrast the ARCCA experts and their actual testing to Judd Welcher. He came to you in the Commonwealth's case in chief, and he told you that for the better part of $500,000,
That
he'd
LARPing
come in and
was the thing?
testify that John was tall enough to touch the taillight with his elbow. That's it. And even in that basic demonstration, he had to lean in to manipulate it, to get the results that he wanted.
He also had to dress up like John, apparently.
Dr. Welcher then claimed that the reason he didn't do the reconstruction, the actual testing, think about what he said.
There's too many unknowns.
There isn't enough evidence to determine what happened. I beg your pardon? What happens when there isn't enough evidence, in his words? You vote not guilty. That's what happens. That's out of his mouth, not mine. The Commonwealth also used the same company, Aperture, to try to establish a time of a collision that never occurred. The Commonwealth called Shannon Burgess, the supposed expert from Aperture. There is a cardinal sin for experts, folks, a cardinal sin. It's called confirmation bias. It's when you decide to change your opinion to fit a theory. The most important takeaway from Shannon Burgess' testimony was how brazen, how shameless he was in trying to change the data to try to suit the Commonwealth. Remember Mr. Brennan's opening statement. He made some promises.
Too many
He
B
said,
names.
this case is about the data.
He did.
Stressed it over and over again.
Data, the science.
They've had 3.5 years to get this right. The Commonwealth has had this case for 3.5 years to get it right. So his top expert, Dr. Welcher, prepares a report. And that report says that John O'Keefe was struck by Karen Reed's SUV at 12:31:38. Note that time, 12:31:38. He was struck, he was immediately incapacitated,
clock
he was
drift.
immediately unconscious. So says Judd Welcher and the Commonwealth's theory. But there was a huge, huge problem with that. And somewhere in the middle of trial, somebody must have realized it. They must have realized that the very data they produced unequivocally establishes that they are wrong about a collision. It could not have happened. Why? Because John was interacting with his phone after 12:31:38. Remember, the collision immediately incapacitating. How could he be interacting with his phone afterward? He was on his phone, opening his phone, checking his phone, reading texts on his phone, and locking his phone. All of it.
He opened his
after
phone with Face ID.
12:31:38, which is the time Welcher clocked for the moment of the impact. And he was taking steps and walking with that phone after 12:31:38 also. That's what their own data showed, and it devastated their case, and it devastated that false theory. There must have been panic, I'm guessing, in the room. What do we do now? The data shows John wasn't struck by the car. What do we do? Enter Shannon Burgess. Question. Can you believe him? Can you believe Mr. Burgess? He came up with a brand new
Oh
story
man, Shannon.
right in the middle of trial. You might
Shannon
ask
with the
yourself, would
one
an
N.
expert actually say something he knows not to be true? Would an expert actually say something he knows is not supported by fact? Would an expert shade the truth? You don't have to look any further than Shannon Burgess's CV to answer that question. That was a shame.
They're so happy about that.
Even with the pull and push and stretch,
That was a shame. The lies. That was a shame. That was the biggest gift anyone could drop on an attorney's lap. That was a shame. We're backing that up again. Oh, Shannon with the one N. Can you trust him? Look no further than his CV. That was a shame. The fact that he didn't giggle when he said it is amazing to me, because never has there been a greater gift than an expert not being accurate with their CV. Never has there been a greater gift. That was a shame. The lies. So disappointing. Oh boy, we had to see it again.
than Shannon Burgess's CV to answer that question. That was a shame. Even with the
Such a
pull
good
and push
moment.
and stretch and manipulation of the time data that Mr. Burgess came in here and told you about, it still shows that John O'Keefe was very much alive and walking around after they claim he was hit and incapacitated. Think about that. Matt DeSogra looked at Burgess's report and told you that in 30 out of 30 scenarios of the possible time skews that Shannon Burgess identified, he came in the middle of trial and identified all these other time skews that he called it. In every single scenario, John was alive and walking after they said he was hit. And that's a problem for them, because there was no collision. Just look at Mr. Whiffen's data, Ian Whiffen. John
That's just a
O'Keefe took
time
31
slip.
steps at a steady rate, about 83 feet. And then think about this. In a westerly direction, that would be right toward the house. Remember, it's 78 feet to that garage door. That's not a coincidence. The Commonwealth's witnesses, or the Commonwealth's witness, Mr. Ian Whiffen himself conceded that he has reasonable doubts about the accuracy of John's location data. You remember that question and answer on cross-examination by Mr. Alessi. Do you have doubts? I do. Are those doubts reasonable? They are. And remember, it's still the Commonwealth's burden. If their own cell phone expert has a reasonable doubt about John's location,
Alessi asked that.
So should you.
Over and over again.
John O'Keefe was inside, and the phone battery temperature further proves it. This is not speculation. This is science, and it's irrefutable. It tells us that he was not laying outside in the cold. He was inside somewhere a little bit warmer. Ian Whiffen told you that when the iPhone is exposed to freezing temperatures, think about these numbers. When the iPhone is exposed to freezing temperatures, it will drop from 81 to 21 degrees in 15 minutes. 15 minutes. That's a 60-degree drop in 15 minutes. Now look at John's
control
phone.
your experiment.
It was laying, according to the Commonwealth, it was
Under
laying
him.
directly on frozen ground.
Under a body.
He arrived at 34 Fairview and his phone dropped only 20 degrees over the course of an hour.
Under a body.
Then inexplicably, it stayed steady, never dropping below 50 degrees for the next 4.5 hours. Never dropping below 50 degrees for the next 4.5 hours, basically through the entire night. He was not outside. He was someplace warmer, like a basement or a garage. Dr. LaPosada confirmed that John O'Keefe did not have hypothermia. No telltale signs, no telltale Wisniewski spots, no frostbite on any extremity. He did not die of hypothermia because he wasn't outside.
And the defense doesn't have to prove it. They have to
Dr.
make the jury
Wolf,
question it.
Dan Wolf, Elizabeth LaPosada, Judson Welsher, Andrew Rinchler, all agreed. Every expert agreed.
Does it raise a question?
This is how John O'Keefe died.
The head
A
injury.
rearward fall from a standing position.
No, I hope that's not his head injury. Okay, good.
What could make you fall
That's-
straight back like that?
The dummy falling.
Let's just think about that for a second. What could make you fall from a standing position as Judd Welcher just showed
Slipping.
us? Standing up, falling straight back. Add a laceration to the right eye consistent with a fist or a punch, and you've got your answer.
A dog jumping on
He
you?
certainly didn't sustain that wound on the back of his head by falling backwards onto a lawn. Dr. LaPosada told you that the patterned injury on the back of John's head could only be produced by hitting a hard, ridged, or ledged surface, like a concrete stair or step. What's just through that garage door? Michael Proctor never stepped down in that garage to find out.
He doesn't know.
What a shame.
Neither do you, ladies and gentlemen. He didn't find out. So
And
we
look
can't
at the
tell
arm.
you.
Just look at John's arm. You don't need the top experts in the country, but you had them. You don't need the top medical minds on the planet on this issue, but you had them. These are dog bites and scratches. These are animal wounds. Not one witness has been called in their trial. Not one. 8 weeks and counting. Not one witness who actually disputes that John O'Keefe's arm injuries are from a dog. The Commonwealth could not find a single medical expert, a single medical witness who would come in here and tell you those are inconsistent with a dog bite or a scratch. And it's equally clear that there was no collision. Dr. LaPosada told you in probably the clearest voice in the entire trial. You remember her testimony. He didn't get hit by a car.
You think Brennan's regretting not bringing a rebuttal case right about now? Or no? Because the defense can comment on who they call and who they don't. They didn't bring a single person in here to tell you that that's not from a dog. Welcher said Mike could. You think Brennan's sitting there going, well, we knew that was coming.
Her words. He just didn't get hit by a car.
I'm going to back that up for the smoothness of his sentence.
Dr. LaPosada told you in probably the clearest voice in the entire trial. You remember her testimony. He didn't get hit by a car. Her words. He just didn't get hit by a car. You remember the question that was posed by Mr. Brennan, did you consider the speed of the vehicle? And she said, speed didn't matter because he didn't get hit by a car.
Rentschler said
She
it
repeated
too.
it 3 times because it's true, not just because she says so, but because the medical evidence proves it. The medical science proves it. There was no collision. Dr. Rentschler told you unequivocally and just as firmly he didn't get hit by a car. The Commonwealth has not met their burden. They cannot meet their burden. The Commonwealth hasn't called a single medical professional, not one, to testify that John's wounds came from being hit by a car. Not Dr. Scortibello, not Dr. Isaac Wolf. Contrast that with the caliber and the quality of the experts who came in here to tell you
we knew that was coming.
what is obvious to anyone with common sense. Those wounds on his right arm are from a dog. This was not an oversight by the Commonwealth. It's just that there is no one out there, no matter how big a check you write. There's not a medical expert who's going to disagree with that. The fact is, this is the central fact in the case. The only fact that matters is literally uncontested by every medical expert. Uncontested, undisputed. There is no evidence that John was hit by a car. None. How much more reasonable doubt could there be? This case should be over right now. Done. Because there was no collision. So given all that, how did Karen Reed end up sitting here? Why is she even here? Why is she in that chair? Why is she in this courtroom?
Good
There is a reason for that.
topic.
And it's a reason they don't want to tell you, and it's a reality they don't want to admit to. The reason we're here is because the system, the very system that was meant to protect her, that was meant to protect all of us, that system has failed badly. So now let's discuss the facts that were and were not presented by the Commonwealth in this case. Over the next few minutes, I want to talk about the utter failure of the police to investigate this properly and to investigate this
More to
fully.
Bowden. Will we hear
And what you're
Proctor's
going to see is that
texts?
Michael Proctor, the lead investigator for the Commonwealth, did nothing to actually and properly investigate this case. Let's start with the house. That's the most logical place to start. I think you'd agree. Brian Albert's house, where John's body was discovered lifeless in the lawn. A man, a police officer, is found dead on the front lawn, and no one secures the scene. No tape, no preservation of evidence, no crime scene log, no search warrants, no
crime
consent
scene log
searches,
is
no
huge
photographs
for
of the
me.
house interior. They didn't treat the house as a crime scene, and shamefully, they didn't even treat the yard as a crime scene. The lame excuse offered by retired Lieutenant Gallagher, it was really cold and windy,
He did say that.
and I didn't know if there was a crime that had been committed.
Right.
What?
Right.
You didn't know that a crime had potentially been committed?
So they thought it was an accident too.
You have a man laying dead in the yard, and here are the undisputed facts that those officers were confronted with.
Well, the
Black
ME agreed
eyes.
with them. I don't know if
Obviously, black eyes are consistent with a fight. Bloody nose, also consistent with a fight. Bleeding from the face, consistent with a physical altercation. A cut over the right eye, consistent with a punch. No coat in the freezing cold, not dressed for outside, dressed for inside, and one shoe on. I wonder where the other shoe could be. I don't know, maybe in the house 30 feet away. And then you find a broken and shattered drinking glass next to him, the type of glass that you might find, I don't know, let me think about this, in a kitchen in a house 30 feet away. And John's phone was tucked neatly under his back shoulder.
That's a stronger point.
Lieutenant Gallagher actually claimed he did not know it was a potential crime that
Right.
needed investigating. The neighbor across the street, Detective Lieutenant Kelleher, had a ring camera that was pointed at the exact direction where John O'Keefe would have been hit, and nobody bothered to secure it.
That's a good point.
Nobody bothered to secure it. Nobody even bothered to look at it.
It's just for packages.
Of course this was a potential crime scene. Of course it was. Let's not forget, this was Brian Albert's house,
He's
and
a
that
Boston
comes with
cop
privileges.
too.
Quote, is the homeowner going to catch any shit? Nope. He's a Boston cop too,
Right.
end quote.
Good segue.
That quote starts to make a little more sense now, doesn't it? Michael Proctor wrote those words just hours after John's body was found. He sent this in a private chat, in a
Great
private
segue.
text he never, ever believed would ever be revealed. He sent that text in a series of messages that now belong to you.
Go
You
read
weren't
them.
given the opportunity to hear from Michael Proctor, but you can read his thoughts for yourself.
Ding, ding,
And I
ding.
urge you, go read them. They're in Exhibit 209, 209, in case you're wondering. But here are the highlights. Proctor starts the conversation.
You didn't hear from Proctor. Go read his texts. They're number 209. Yeah. Sit down and read them. Read them all. Because nobody called him to testify. A excellent point and a great way to keep highlighting to the jury they never called Proctor. Great way to argue it. Great way to argue it.
Quote,
Oop.
all the powers that be
That was
want
me.
answers ASAP. He's getting pressure, obviously, to get this done. His friend then asks what Proctor's probably thinking at the time. Quote, I assume you guys are out to make it cut and dry since it involves cops. Something stinks.
These are the texts.
Proctor responds, yeah, to the something stinks. And then he goes on, but there will be some serious charges brought on the girl. Think about that. Hours into this investigation, there will be some serious charges brought on the girl. She's a whack job cunt.
Oh, damn.
Yeah, she's a babe. Weird Fall River accent, though. No ass. No ass bitch. She's got a leaky balloon knot. Leaks poo. Zero chance she skates.
Well,
She's fucked.
shit's out of the horse now.
And up to this point, Michael Proctor had done zero investigation. Nothing.
He looks pissed.
Save talk to a grand total.
He did a very good job, I think, of not act. The theatrics are a 10 for me. He's done a very good job of showing the jury how angry they should be about those texts without himself getting actually overly heated where he loses his point. He's done a great job of showing them how mad they should be about those horrific text messages. You didn't hear from Proctor, but this is what the fuck he said. Are you furious yet that we're here? You should be. Great, great point. All right, I had to back him up a little.
Michael Proctor had done zero investigation. Nothing. Save talk to a grand total of 3 people,
Jen McCabe.
all of whom were named Albert or McCabe. That's it. And this was his mindset.
We knew he was going to say,
This
see you
is the
next
same
Tuesday.
lead investigator who sent the group chats that you heard about with Sergeant Buchnick. Late night, sitting at his office, rifling through Karen's phone, bragging about looking for naked pictures of her. That text wasn't sent to his buddies or his friends.
Sent to his
That
bosses.
text was sent to his supervisors at the Massachusetts State Police, for God's sake.
Yup.
And what was their response? Sergeant Buchanan liked this conduct with a big old thumbs up. He encouraged it. Ladies and gentlemen, a lead investigator is every investigator is supposed to be objective, an objective fact finder. No bias, no agenda. Michael Proctor went far beyond just insulting Karen Reed.
I mean, he called her no ass
dehumanized
bitch.
this woman.
Yeah.
He betrayed her as a human being. He was fired for this blatant bias. If the Massachusetts State Police can't trust him, how can you trust him with this investigation and with your verdict
Bing.
and with Karen Reed's life? The lead investigator in a murder trial was never called to testify.
Bing.
Think about that. That should stop you in your tracks. Wouldn't you want to hear from Michael Proctor? Wouldn't you want to hear from the lead investigator in the case?
Yes. Everyone is screaming at their screen. Yes. Yes. Everyone, the 20+% of you that never saw this case, all of you are like, where the fuck is Proctor? Yes. What bites the Commonwealth in the ass more, calling Proctor or not calling Proctor? Because if you call him, you don't have this argument. But is it better to argue it than to actually call him? It might be. But this is why the defense doesn't want to call him. They can argue his text, and they can argue, what did the Commonwealth not show you?
The lead investigator in a murder trial was never called to testify. Think about that. That should stop you in your tracks. Wouldn't you want to hear from Michael Proctor? Wouldn't you want to hear from the lead investigator in the case? Don't you have questions? The Commonwealth did not present their own lead investigator to the jury, the very jury who is charged with judging the investigation.
Right.
Michael Proctor clearly is radioactive, and the Commonwealth stayed away from it.
I'm going to start singing Imagine Dragons in about
Michael
4
Proctor
seconds.
is no longer a Massachusetts State Police officer. He wasn't transferred. He didn't go on sabbatical. He didn't retire. He didn't resign. He was fired.
Fired.
Terminated for cause. The Massachusetts State Police investigated him, found him guilty of dishonorable conduct, not just for those text messages, folks, for sharing confidential information with witnesses, and for bias. Not just any bias. Bias in this case. Fired.
Fired.
This is the man who touched every single piece of important evidence in this case.
And they asked
all
it.
the evidence that was brought before you in this trial went through his hands one way or
Let's
another.
just moving those.
The shirts, the shards. Remember that when Mr. Brennan gets up and gives his closing argument. The shirts, the shards, all in Michael Proctor's possession. Mr. Brennan and the Commonwealth, I think, have pinned their hopes on some microscopic pieces of, or close to microscopic pieces of plastic that were claimed to have been scraped from the hoodie
Well, actually, they're not
several
exactly
months after the
microscopic because you
fact.
can still see them by the eye.
What he failed to ask every single every single witness is who had access to that shirt and who had access to those taillight fragments. And the answer is it was Michael Proctor. Not for days, not for weeks, for months on end, for months unaccounted for. Before they were submitted to the crime lab, before they were ever scraped. Just go look at the chain of custody documents. You've got them. Why
The
didn't
ones that
Michael
exist.
Proctor give those clothes to Maureen Hartnett with the crime lab when she was at Canton PD just days after the fact to receive those solo cups?
That's a
Remember
great
that?
point.
Just a few days later, she was there. She drove up. She did the driving to take the photos.
That's a great point. She took the pictures. She went to go swab the solo cups. Why didn't they give it to her then? That is a great fucking point. Yeah. Why not give it to her February 2nd? Why wait till March 14th? Right?
Solo cups in the grocery bag, which has a ridiculous aspect to it in and of itself as well. Why not just give her the shirts as well? Give her the taillight fragments if any were found at that point. Why hold on to them? What could possibly be a reason? Why wait until March to book those into evidence? Now let's talk about some of the other problems with the Commonwealth's
Great
evidence.
point.
As I indicated, there was no blood, no skin, no tissue, no DNA found on a single piece or shard of the taillight that the Commonwealth claims cut and sliced into John O'Keefe's arm. Where is that trace evidence? Where is that biological evidence? The DNA. Where is it? They've got nothing. Not a single piece that the Commonwealth wants you to believe cut up John's arm. How is that possible? It's not possible. The only way it's possible is if those shards never touched his arm. Because it was a dog.
Damn.
Oh, and the one sample of DNA that they did find, by the way, was found on the outer smooth part of the housing. Not any shard. It was the outer smooth part of the housing. Nothing that they claim actually came in contact with John O'Keefe. Number two, that sample had DNA of two other men, two other unidentified males. That tells you that that DNA had nothing to do with a car strike. that DNA would be expected to be, John's DNA would be expected to be all over that car.
Right.
Inside, outside, he had access to that car for months and months and months. He was in and out of it all the time.
Right.
Show me some blood, then we'll talk.
It's his girlfriend's car.
They can't, and they won't because it doesn't exist. That SUV never hit John. The hair found on the bumper. The Commonwealth really stretched its own credibility on this one. That magic little hair on the SUV supposedly survived a 37-mile drive in 47-mile-an-hour winds. But that little magic hair just clung there, just hung.
I don't know if the hair is a persuasive point to me. The fact that it was clinging there is more persuasive, but it's like, okay, there's a fucking hair on the car that's parked at his house that belongs to his girlfriend who he was with that night. The fact that it's still there, I think, is more impactful.
On. That same hair that moved in between photos in the Sally Port. Remember that? There were 2 photos taken, and it was either the breath of the photographer or just the movement of walking by the hair. It literally moved between the 2 photographs.
I don't
but
think
that
the
hair
hair
is
moved.
supposed to have hung on in a 37-mile drive in a blizzard.
Right, that's a fair point.
The only thing that hair proves that the Commonwealth is embarrassingly grasping at straws. That hair has nothing to do with anything.
That's a better point.
But it doesn't stop there. There was another revelation at trial, a big one, a huge
That's the
one.
good point.
And it came from a very unlikely source. Christina Hanley, the quiet, reserved criminalist who told you something the Commonwealth.
The chart with the glass, the chart with the glass, the chart with the glass.
Likely did not want revealed because it's devastating to their case. Absolutely devastating. And it's this. The glass on the bumper didn't match the cocktail glass. None of it. Remember, February 11th, Michael Proctor, without any other person with him, no witness, no supervisor, no other person with him, claims to have found a single piece of glass at the scene. February 11th, single piece of glass, Michael Proctor. Keep that in mind. Interestingly, the glass on the bumper that didn't match the cocktail glass, one piece did match one other thing. The Proctor glass. Those 2 go together. The only 2 things that go together from that bumper are the Proctor glass. We know that there's no glass in the taillight. We know that nothing else was shattered on the vehicle. Therefore, that glass had to be placed there. Didn't come from a crash. Didn't come from a cocktail glass.
Didn't come from the
So
taillight
how did
anywhere.
it get sprinkled on the back of the bumper?
Like fairy
Whose
dust.
proverbial fingerprints are on that glass?
Tinkerbell with the magic
The
hair.
only thing it matched was Michael Proctor. What about the Ford Edge and that snowplow driver, Brian Loughran? He observed that Ford Edge parked outside Brian Albert's house at 3:30 a.m. That vehicle was moved directly in front of where John's body was found sometime between 2:30 and 3:30 in the morning. The only person connected to a car of that make and model, Brian Albert. Michael Proctor did nothing to investigate that point. Did nothing to investigate whose Ford Edge was parked in a spot specifically to block the line of sight in the exact position where John's body would be later found by Karen Reed. No one, not Michael Proctor or anybody else, checked it for evidence. No one even asked any questions about it. That Ford Edge, Brian Albert's Ford Edge, completely ignored.
When did they talk to
Michael Proctor failed to
The plow
interview
driver?
obvious witnesses in this case. Why?
When did they talk to him?
Why didn't he want to speak to the snowplow driver, Brian
When was
Loughran?
it?
Why did he falsely claim that no one plowed the roadway that morning? When police dash cam video, you saw the dash cam, it shows plows going back and forth all morning. Why did he wait so long, years even, to interview Heather Maxson and Ryan Nagel, individuals who were literally outside 34 Fairview at the exact same time John and Karen arrived at Brian Albert's house that night? Brian Loughran, had he been investigated or interviewed, would have told Michael Proctor that he drove past the lawn multiple times on January 29th, and there was no body on the lawn. He would have had a perfect view. Remember, the weatherman told you there was only enough snow at that time. I think he said
Cat's
a very
track.
charming phrase.
Cat track.
Only enough snow to track a cat. I think that was it.
Yes, it was. You know it was.
There was
I
no
think
body.
it was. You know the fuck it was.
Heather Maxson and Ryan Nagel would have told him that they arrived at 34 Fairview shortly after Karen and John pulled up behind them.
Delightful.
And they would have told Michael Proctor at least Heather would have told Michael Proctor that when she left 10 minutes later, she drove past the SUV
I loved
and
that weatherman
observed
witness.
Karen Reed in the driver's side, dome light on, passenger seat empty. So where was John? Wasn't outside, wasn't sitting down, wasn't laying down. There's only one place he could be. We could all say it together if you could talk with me. He was in the house.
Throughout the case, Jackson
Michael
has
Proctor
done
did
that.
not want to have those answers. He did not want to have to disclose.
The defense has done this well throughout the case. There have been moments where you all want to answer back. And most of the time, it was Proctor. Who collected that evidence? Who did this? Who did that? And the jury said in their head, and y'all said out loud, unless you're at work or at the dentist, Michael Proctor. It was Michael Proctor. They have done it throughout the case, letting the jurors answer to themselves, which they will remember more than if you tell them. It's been consistent.
Those answers. He didn't want the truth. The Commonwealth has presented a shred of evidence of when Karen Reed consumed her last drink that night. Think about that. It's critical information that the Commonwealth has to prove beyond a reasonable doubt and to a moral certainty. They have to prove
drunk driving.
when her last drink was that night.
Right.
They have to prove it. We don't have to prove or disprove anything. Every single witness who was asked
They're gonna
and
use
who had an
words for
opportunity
that.
to observe Karen that night said the same thing. She wasn't drunk. She wasn't stumbling. She wasn't slurring her words. She was, in the words of Ms. Kolakithis, completely normal. Even Jennifer McCabe,
Which is
grudgingly,
powerful.
had to admit that fact. It's on video. Instead, they used Yuri Buchanan to try to come into court and count sips of alcohol, which he admittedly got wrong. According to Ian Whiffen, the Commonwealth's own expert, the location data, using location data on John's phone, showed Karen driving lawfully. She was driving safely. She was under the speed limit. She was slowing and stopping at stop signs, slowing around corners. And Ryan Nagel corroborated that when he saw her make that left-hand turn
That goes to count
onto
two.
Fairview.
It's
The
important.
Commonwealth has an incredibly high burden to prove that Karen was driving under the influence.
Right.
They have failed to prove that beyond a reasonable doubt and to a moral certainty because it depends on when she had her last drink. What happened after she got home and she was upset with John for not coming back out of the house? That would answer that question.
Right.
As you well know, no one searched the house for signs of a struggle. Not that night, not the next day. I'm talking about 34 Fairview. Not ever. Not once. Not with a warrant, not with consent. They never went into the basement, the stairwells. They didn't look at the walls. They didn't look in the garage. Nothing was ever examined. Nothing was checked for blood. Nothing was checked for DNA. They didn't look for a ledged or ridged surface. Zero. You'll remember how surprised Jennifer McCabe was to recall that there was a garage door even on the house. Except this was her sister's house. She's been going to that house since she was 5. She's seen that house. She's been in and out of that house hundreds of times, maybe thousands of times. She's been going to that house her entire life, and yet she acted surprised when I asked her about it. Remember Jennifer McCabe's answer when I asked her whether there was a door to the garage? I was asking her about the front door, the side door, and the garage door, and her answer was, oh, actually there is a garage door right there. Investigators never opened that door. Let's change the scenario.
That goes
What
to
if it
Bowden.
wasn't the house of a Boston cop? What if it wasn't
What
the
if it
house
was
of
your
Brian Albert?
house?
We can be certain that investigators would have torn that house apart to get answers about why a fellow police officer was laying dead on the homeowner's lawn. You can betcha. But because this was Brian Albert's
That's when
house,
no cap would have worked,
a
though.
Boston cop, nope. And
We need
because
the
he was a
Yannetti
fellow
note.
cop, an insider, they didn't even open the door. That is not justice, folks. That's just pure favoritism. Each of these facts is more than a question mark. They're failures of duty. They're blank spots on a map where justice is supposed to live. And every single one is a reason why you cannot convict Karen Reed. reasonable doubt abounds. If the Commonwealth failed to investigate every reasonable alternative, how dare they come in here and ask you for a verdict? They didn't investigate the case fully, and yet they're asking you to take the easy road and do their job for them. These facts do not represent reasonable doubt. Nothing does. Every one of these facts that you're seeing that we're talking about represents reasonable doubt.
Right. If this isn't reasonable
Everyone.
doubt,
The police and the
What
prosecution
is his
are in a
argument?
position to take people's liberty. It's the most dire and consequential act a civilized government can take against one of its citizens. Their obligation is not just to try to get it right. They have to convince you to the highest degree of certainty known in human affairs. They have to do it all, every bit of it, beyond any and all reasonable doubt. And they have not done that here. And how about
not every court you could get away with arguing beyond any and all reasonable doubt. Massachusetts instruction says to a moral certainty. It's higher than you will see, and it's more strongly worded than you will see in most jurisdictions. So in some jurisdictions, that would garner an objection because it is placing the burden too high. But in Massachusetts, reasonable doubt and to a moral certainty. I think it is probably the strongest reasonable doubt language in the country. So he can argue it because that's the standard in Massachusetts. It is a very high bar and the language is very strong. So he can argue that. Other states, that might be objected to for overstating the burden. Here, it flies.
the homeowner himself? The host, the first responder, the Boston cop, Brian Albert, who was sparring and practice fighting with Brian Higgins just minutes before John O'Keefe appeared at his house, 34 Fairview. Brian Albert, who was watching Chloe that night, the German Shepherd. Brian Albert, whose phone and his wife's phone were never secured. Brian Albert, who never came out of the house.
That one.
But that doesn't mean he wasn't awake. It doesn't mean that he wasn't on his phone. Think about this. Jennifer McCabe claimed that her sister and Brian Albert both slept through this complete chaos right outside their bedroom window.
Where was the dog?
But Jennifer McCabe's phone records tell a different story, and they tell the truth. She spoke with them for the better part of a minute, 38 seconds to be detailed about it, at 5:07 a.m.
What now?
And then she lied about that call. Remember that?
Were we
What
going to
was
talk
the
about her
reason
lying
for
to
that
the
call
FBI?
at 5:07? Was it panic? Was it a warning? We know that conversation took place at the precise time Karen left her house to go search for John, 5:07.
We're coming.
We could answer those questions if we just had access to their phones. Brian Albert, Brian Higgins. But Michael Proctor wasn't interested in their phones. Not only did he not secure their phones, he never even asked. And what about Brian Albert's dog, Chloe? A dog with a history. A dog that is, quote, not good with strangers. Dr. Russell confirmed that John's pattern injuries were from a dog, just like the dog Brian Albert owned. And then Chloe just disappeared. Not there the next morning. None of the officers that you heard from said that there was a dog in the house. They didn't see her. She was just gone. And then
it's a good argument. Remember, in this trial, Jen McCabe said when she came busting into her sister and brother-in-law's bedroom that morning, I didn't see the dog. No one talked about seeing the dog. Law enforcement that went into the house that morning, no one saw a dog. No one heard a dog.
Ultimately gotten rid of altogether. Who gets rid of their family pet? Unless they had something to hide. Michael Proctor wasn't interested in that either. And recall the group chat with the Alberts and the McCabes. They were getting their story straight. Matt McCabe, whom the Commonwealth did not call in this trial, instructed the group in that group chat, you'll recall, tell him to say the guy never came in the house. Think about that exact quote. Tell him to say the guy never came in the house. And Brian Albert, the patriarch of the family, exactly, exclamation point. He blessed it. With the truth, as we all know, you don't need to get your story straight. You don't need to tell someone what to say. It's just,
I need a timeline.
just the truth. And what about the Google search? A Google search that Jennifer McCabe admitted having made. A Google search that was time-stamped by Celebrite at 2:27 a.m. A Google search that read, "Hoslong to die in cold." It is uncontested and undisputed that that search was deleted. If the 2:27 a.m. timestamp is not true, why does Jennifer McCabe have to lie about it? Why delete it? If the 2:27 a.m. timestamp is not true, why create a false story about Karen screaming Google hypothermia? That's just a fabrication. That's just a made-up fact. And by the way, if someone does tell you Google hypothermia, why would you Google how long it takes to die in cold? Wouldn't you just Google
Hypothermia?
hypothermia?
Right.
Jennifer McCabe enlisted Carrie Roberts to help shift the blame to Karen.
This is a strong point.
Why go to that much effort?
Because
unless you're
Carrie
trying to
lied about
cover for
it.
something? Keep in mind the entire foundation of her claim that Karen said Google hypothermia is this fantasy about Karen screaming it at the location, at the scene. That's her entire excuse. But that story went completely off the rails when Carrie Roberts admitted that she perjured herself to back up Jennifer McCabe's false story. That was a dramatic moment in court. It's an admission of perjury, and you don't see that very often in a courtroom.
It's wild. It was a long
It
time
tells
ago.
you
but it was
everything you
wild.
need to know about the character and quality of the prosecution's case and their witnesses, lying and perjury and admitting to it.
Oh,
A
boy.
fundamental tenet of any investigation is to ensure that witnesses are independent and not influenced by other witnesses. You start by separating the witnesses. Michael Proctor did none of that in this case,
Right.
and we see the results. Think back to Jennifer McCabe's own text messages with Carrie Roberts.
Timeline.
About Carrie Roberts, not with Carrie Roberts, notably. What Carrie Roberts did.
Oh my God, she's telling them everything. It's been so many days since we've heard about it. Oh my God, she's telling them everything. Carrie's a talker.
No, was at the time she was being interviewed by the police, Jennifer McCabe was in real time. She was bragging about having influenced Carrie's testimony or her statements to the Alberts and the McCabes. Quote, she's telling them everything, all the stuff. Remember that timeline that we talked about with Jennifer McCabe? That's what she was referring to. She's telling him everything that Jennifer McCabe had put in Carrie Roberts' timeline. The Commonwealth wants you to believe that Karen Reed made a statement at the location, at the scene. I hit him. I'm sure you'll hear that from the prosecution in their final arguments. But their own witnesses contradict that. Jennifer McCabe admitted on cross-examination that her very first statement to law enforcement,
Sounded like
confirmed
glass.
that Karen didn't say anything. She asked, could I have hit him? Did I hit him? Is he dead? The physics and the science answer that question. Could you have hit him? No, you couldn't have. Sergeant Buchanan also testified that the only statements Karen Reed made at the scene, according to his conversations with the first responders, was, could I have hit him? Did I hit him? It wasn't a confession. It was confusion. And Dr. Russell explained that confusion. She told you why Karen Reed or anybody in that position might ask those questions. She was suffering from extreme grief reaction, which according to the evidence can last for years. Even her medical records confirm that diagnosis. It's common to ask those questions in grief.
That's not
It's
evidence.
common to ask those types of questions in shock. You're trying to make sense out of the nonsensical in the moment. And the Commonwealth has tried to twist those words into a confession. There is no evidence.
Remember, that answer only came in from Dr. Russell because Brennan kept pushing on cross. If the defense had tried to elicit it from Dr. Russell, it would not have come in. That came in because of cross-examination from Hank Brennan. They did not hear it last trial, but they heard from Dr. Russell that there's a reason that would explain the things Karen Reed said and why. And we knew they were going to use it in closing.
That any officer at the scene ever heard Karen Reed say, "I hit him." Not a single police officer at the scene came in to support the Commonwealth's claim. It's not on video, it's not on audio, it's not in a single police report, it's not in a single EMT or EMS report. Nowhere. The fact is, Karen never said, "I hit him." You saw the video. Multiple officers were right there. She simply never said it.
Not in
What
any
did Jennifer
reports as
McCabe
strong.
do and not do when she got to 34 Fairview? She would have you believe, I want to set the scene for you, that she's confronted out of the blue with John O'Keefe's lifeless body. Her friend, John O'Keefe.
Has Jackson laid the groundwork to undermine Brennan playing all the videos of Karen Reed in his closing? The defense knows that that's what the Commonwealth is going to lean into. Did they use their closing to undermine that? Let me know what you think.
He's bruised and battered. He's bleeding. His eyelid is cut. His nose is bleeding. Karen is screaming at the top of her lungs. Carrie is screaming back to Karen, "Shut up!" Both women begin crying. Both women are giving CPR. There's chaos everywhere. It's building in the yard, just feet from Brian Albert's house.
Under his
Brian
window.
Albert's window. Jennifer calls her sister at 6:07. With all this chaos going on, no answer. Jennifer calls her sister at 6:08. With all this chaos and bedlam going on, still no answer. No lights come on in the house. In the midst of all this screaming and this chaos, Brian Albert doesn't come outside. Nicole Albert doesn't come outside during this maelstrom. And yet, Jennifer McCabe never goes inside to check on her sister.
Or to ask for help.
There's literally no signs of life inside the house. And Jennifer McCabe doesn't take a foot, a step inside that house to check on her family. Why is that? Does that make any sense? Everyone would sprint inside the house to make sure that there's no one in there that was hurt or injured or, God forbid, dead. Everyone would do that. But not Jennifer McCabe. The only way that makes sense is if Jennifer McCabe already knew that Brian and Nicole were just fine. That's the only reasonable explanation. And the only way she would know
That
if they were
507 phone
fine
call?
is if she knew what happened.
Or that 507 phone call.
But Michael Proctor never explored this incredibly suspicious behavior. Don't you have questions?
That.
This would give anyone reasonable doubt. And don't you have questions also about Brian Higgins? Michael Proctor certainly didn't. Higgins had been sending flirtatious and romantic texts to John's girlfriend, Karen Reed.
I mean, cringy, but yes.
You'll remember I asked Sergeant Buchanan a simple question. Were those texts flirtatious in nature? He refused to answer that simple question. Do you remember that?
Yeah, I do. Sure
Quote,
do.
I'm not comfortable putting a label on that, end quote. We read the texts. It's not a secret.
All of them.
Of course they were flirtatious. Of course they were romantic in nature.
I mean,
The reason he refused to answer that simple question is telling. It's because these flirtatious texts establish a motive for Brian Higgins. Sergeant Buchanan could not bring himself to tell the truth.
y'all keep asking me about time. I'm time blind. I'm not the one who is keeping time, and I keep pausing, so it's hard to know. He's not done yet, but he's getting there. You can tell in the things that he's covered. But I'm time blind. I'm not the one to ask.
Truth.
And I paused
His
a few
bias
times.
was on full display. He was covering for another cop. Investigators also ignored Higgins' suspicious late-night visit to the Canton Police Department.
That
That
part.
was after a night of drinking, by the way. Why didn't they investigate this? What was so important that Higgins needed to go to the police station at that time, 1:30 in the morning, while drunk, by the way? Why weren't they interested in those facts? Remember,
I don't think him being drunk
he's
is
an
an evidence, but
ATF agent. He's a cop, a member of the Blue Wall, and best friends with Brian Albert. He would know that the CPD would be the first to get the call when someone reported John missing or injured. He would know what to look for, what to listen for, to determine if a report had been made and when and what the response was going to be. You saw the skulking through the hallways with his hood up,
Oh, they're going to play it.
moving bags between cars.
Are they playing it?
And of course, that late night mysterious phone call on his cell phone.
We saw
a
it.
phone that you don't have and that you'll never see. All of that, and Michael Proctor never gave him a second look. All of that, and the Commonwealth, who's supposed to be after the truth, didn't call him to the stand. If you have any unanswered questions about Brian Higgins, that's reasonable doubt.
Blame Proctor.
The police didn't interview Brian Higgins on January 29th, 2022, but he was at the police station, as we've just seen. You heard evidence that Higgins and Chief of Police Kenny Berkowitz, also good friends, were in the Sallyport together with the SUV for a, quote, wildly long time.
Thank you, everybody. We binged.
Kelly Dever, another Boston cop, told you that.
Oh, boy.
She also told law enforcement agents that she found it, quote, weird.
You better get her last name right, Jackson, or you're going to catch some hell because it's Dever.
Long time. Kelly Dever, another Boston cop, told you that. She also told law enforcement agents that she found it, quote, weird that Higgins could have access to that very sensitive evidence, the SUV. Folks, there is never a situation in which a witness, a potential suspect even, should be given access to the evidence in a case. But that's exactly what happened here. Higgins was given unfettered access to that SUV and its taillight nearly immediately, according to Kelly Dever's statement to law enforcement. And it was at that exact time, the exact moments that Higgins would be in that Sallyport, that the 42 minutes of the Sallyport video is just missing. It's just gone, vanished. Well, that's convenient. Now put in context the condition of that taillight when it was
How many of you were waiting for him to say, that's weird, that's suspicious? I know, me too.
actually seized in Dighton. It was cracked, but not completely damaged. I ask you to compare and contrast Officer Kelly Dever, her attitude, her demeanor. That's all for you to judge. Her attitude, her demeanor, her truthfulness, her motives from the witness stand.
And
compare and contrast that to Sergeant Nick Barrows. Who's more believable? Officer Barrows is unattached to any of the players in this grand play directed by Michael Proctor. He's truly independent. And what did he tell you?
give him that old razzle dazzle.
Was the taillight, he was asked, was the taillight in this condition when Michael Proctor picked up that SUV at 412? His answer? Absolutely not. Absolutely not. It was cracked, but not completely damaged, not smashed out like that.
Absolutely not.
So how did the taillight get cracked? How did it end up in the condition where it was cracked, as Officer Barrows saw it, but not completely damaged? Well, you don't have to guess. There's a video. Just
He's
watch.
looking at the screen because he does not have the PowerPoint in front of him. It's being operated by his team, which takes significant
That's how it got cracked.
timing. And the
And
defense
Judson
team has worked
Welcher's
well
own
together.
recreation confirms it. Look at the contact. That's from the Commonwealth's expert. And that further is confirmed by the fact that there were no taillight pieces found in any of the initial searches conducted at the scene.
Looked like they had a bunch of cards of reasonable doubt up there that they keep putting and overlaying the different questions of their PowerPoint on. So it looks like each time they have one of those cards or little Post-its, they line up into their pile of reasonable doubt. It looks like that's what they're showing in their PowerPoint.
2 searches, 50-foot
Simple
area
words.
searched. Not a
Lots of visual
single
imagery.
fragment was found until after Michael Proctor had access to and control of that SUV and its taillight. What does that say about the character and quality of this case? It's revealing what happened here at trial. One of the most dramatic moments probably of the trial, Kelly Dever. How can you trust this investigation when you saw
False
how
memory.
far a police officer will go?
Oh boy.
You had a front row seat to the power of police manipulation and police corruption. A front row seat. Kelly Dever was interviewed by a separate law enforcement agency, not a friendly department, not
Nope,
Boston
wrong
Police
one.
Department, not Michael Proctor's MSP, a different independent agency. She told those law enforcement agents in a formal interview that she saw Brian Higgins and Chief Kenneth Berkowitz alone in the Sallyport with the SUV. She was detailed, she was clear, she was unequivocal, she remembered the specifics, she recalled how it made her feel, quote, weird. She recalled how long Higgins spent.
Weirdly
a,
long?
Quote, wildly
Wildly
long time.
long.
As she described,
I use
these
them
are all
synonymously.
incredible details to tell law enforcement. She couldn't have been clearer. She couldn't have been more specific. But then she's put on a witness list
But then,
and she's subpoenaed
just wait, there's more.
by the defense. Oh boy.
I don't even know why I'm here.
Then this rookie cop was called up to the police commissioner's office. The same commissioner that was the boss of Brian Albert. They have a meeting, a private meeting, and he says, wink, wink, nod, nod, we support you, Officer Dever.
Do the right thing.
What else was said in that meeting?
Do the right thing.
What else is reasonable to believe was said in that meeting? She claimed she couldn't remember. She claimed not to remember if he instructed her to do the right thing. But the commissioner of the Boston Police Department certainly said something to this rookie cop, and all of a sudden, that detailed, unambiguous, unequivocal statement to law enforcement
False
became,
memory.
what did she say? A false memory. Not I didn't say it. She admitted she said it. She admitted she detailed the entire story. She just said, it's a false memory.
Like, literally
What?
whenever.
So she's called to the commissioner's office to make sure that she would do the right thing. That's why she was called. And now we know what that means. In her words, my entire career depends on what I say here on the stand. I'll quote that again. Quote, my entire career depends on what I say here on the stand.
I told you when she said it that was going to come up in closing, and whoop, there it is. Because never ever has a defense team received as many gifts that have fallen into their lap as this trial. There are so many moments in this trial that happened that they could not control, that happened during cross. Because again, my entire career, who asked the question that elicited that answer? Brennan. That was an answer to Brennan. Right. And you know Jackson was sitting down, writing it as fast as he could. That was an answer to Brennan my entire career. Isn't that their point?
You bet it does. That's how it works. And that's how we got here.
It's a great point.
At the end of the day, you have to ask yourself, can you trust the Commonwealth's case? Can you trust their witnesses? Can you trust their evidence? And here are a few of the highlights. A video that was played in a courtroom and sold as accurate. Turns out it was completely inverted, flipped backward, completely false. The test that formed the basis of their entire theory of the case.
That point's actually stronger than
Watch
inverted
closely
video this trial.
as Dr. Welcher stands as a surrogate.
Dressed as John and leans in. He didn't lean back. Oop, there he goes.
Is that a righteous test? Or is that a manipulation? Dr. Welcher tried to deceive and fool you by leaning into the car, manipulating the results of his own test. When the truth was revealed by Dr. Rentschler, the Commonwealth spent the next hour cross-examining him about how that test was meaningless. It actually didn't mean anything. Well, that's convenient now that we realize that it was a manipulated test, and it actually does mean nothing. It didn't represent the theory of the Commonwealth's case. That's what was suggested. That test does not represent the theory of the Commonwealth's case. Really? Then why was Dr. Welcher playing dress-up in John O'Keefe's clothes, or identical clothes to John O'Keefe, when he was holding a glass? Why was he holding the glass right behind the vehicle? And why was he standing with his right arm oriented to the right rear taillight, if he wasn't trying to recreate the circumstance that is the Commonwealth's entire theory. The Commonwealth stood up here with a straight face and told you they weren't trying to suggest that that's how John was hit by the car.
Okay,
of
then-
course they were trying to
then
suggest
how was it?
that's their theory of the case.
Right.
They only abandoned it 2 days ago when it was revealed by our experts that it's physically impossible. That silent witness, that science, that physics has become very pesky to the Commonwealth because there was no collision. Dr. Welcher also told you under oath that there were no x-rays taken of John's arm. He tried to deceive you into believing that John's arm might have been broken. I don't know. I didn't see any x-rays, so I can't tell you what the damage was inside the arm.
Is this why they didn't call Welcher on rebuttal? It might be. We knew this was going to come up. I think this is probably getting closer to the end of his closing because we knew the x-rays were going to come up.
Really? The Commonwealth has had those x-rays in their possession for 3 years. And again, it took the defense to bring out the truth. The x-rays do not fit the Commonwealth's theory.
Hoodie next.
So you
Do
weren't
the hoodie
shown.
next.
And Dr. Welcher wasn't going to admit it. And my goodness, then we get to the sweatshirt.
Yep.
That
Hoodie
was the
next. Was a bridge too far.
Mr. Brennan stood here in front of you and dramatically held up John's sweatshirt. Not just to the witness,
It's the order I would have argued it into.
but to you. And asked Dr. Wolf about it multiple times.
Here.
Specifically, while it was in that plexiglass, asked Dr. Wolf about the multiple holes in the back of the sweatshirt. He interrupted Dr. Wolf, and Dr. Wolf started to look at the sweatshirt and say, well, and he said, how about here? Here's a hole, here's a hole, here's a hole, here's a hole. Dramatically tapping on that plexiglass. It was clear what the suggestion was, that the holes in the back of John's sweatshirt were from January 29th. That's the impression that was expected to be left with you. That's the impression that he wanted to leave with you. And that's false. The truth is, the Commonwealth created those holes. They aren't holes from road rash. They weren't made on January 29th. Those are cuttings from the Commonwealth's own crime lab, folks. That's what those holes are.
The court told you.
And even with 3 prosecutors, all 3 of them, sitting right there in the room at the time, it had to be the defense to correct that record, to bring out the truth. If we hadn't done that, what impression would you folks have been left with? That's more than negligence. That's dangerous.
Oh boy.
It's dangerous. I'm going to guess that Mr. Brennan's not going to say much about this, about the fraud that was attempted on you. And if he doesn't, that speaks louder than any concocted excuse that the Commonwealth might come up with.
Oh
It's
boy.
shameful. It's shameful. We are after the truth in this courtroom. You're entitled to it.
I'm not going to be able to take you seriously if you start yelling you can't handle the truth. I'm just putting that out there now. However, he has challenged Brennan to explain himself. Brennan wrote his closing last night or the night before, I'm sure. But he has challenged Brennan to explain himself. We'll see if he does.
Demand it. Why would the Commonwealth stoop to a stunt like that? It's desperation. They know what you now know, what their experts know. There was no collision.
I'm sure they put the picture of the hoodie up and the PowerPoint.
So now we've reached
with
the
no
final
holes in it.
moments of the trial, and you've seen the facts and you've seen the evidence, and we've just talked about dozens and dozens and dozens of facts that are reasonable doubt. Each one of them are reasonable doubt.
Yeah, he's getting to the
These
end.
facts, these note cards that you're looking at, piled high, one on top of another, literally stacks and stacks of them covering the table.
Not the stacks.
As you mentally sift through those cards, realize that every one of them is a massive hole in the Commonwealth's case. Every single one of the note cards represents a hole in the Commonwealth's case. If you're holding mentally even one of those cards, you're holding reasonable doubt, folks. You're holding a not guilty verdict. Reasonable doubt is not a sliding scale.
Yeah,
it's
he's
a
almost
wall.
at the end. Start
if the
with
Commonwealth
doubt.
cannot get over every one of these dozens of
End with
walls,
doubt.
you have to acquit Karen Reed. The truth is, Karen Reed is not guilty. Not because of technicalities, but because the facts, the law, the science, the physics, the data, they all say so. They demand it. The Commonwealth does not have a theory about how John was hit by the car. They haven't even shown you that it's possible that he was hit by a car. And the reason they haven't is because it's not possible that he was hit by a car. There was no collision. Your job is not to do their job, their burden entirely. It's theirs. They have to prove this case and their theory beyond all reasonable doubt and to a moral certainty. And not only do they not have a theory, they can't prove one that doesn't exist. All you need to know is that the Commonwealth failed. They failed to provide you with a truthful representation. They failed to prove the essence of their case, that John was even hit by a car to begin with. They failed to prove any intent on the part of Karen Reed because she has none. They failed to investigate the actual suspects in this case. They failed to present the lead investigator to you. They failed to justify the perjured testimony that you heard discussed in this case. They failed to hold accountable an officer who came in here and lied to you and claimed false memories so she could do the right thing to cover for a fellow cop or cops. They failed to maintain a fair and unbiased and honest investigation. They failed to present you with the truth. And this is what you get. An investigation that's riddled with errors and omissions and a rush to judgment and conflicted and corrupted from the start. Every part of it. That is the literal definition of reasonable doubt. How can they ask you to be morally certain based on this evidence? It's a tragedy. When the government fails so completely, so catastrophically, when there are dozens and dozens of points of reasonable doubt on the table, your duty, your oath is clear. Your sworn obligation under the law is to acquit Karen Reed, not just because you can, because you must. Justice demands it. Do not let the Commonwealth get away with this. Don't let them get away with this. Do not endorse and sanction an investigation that is broken and corrupted top to bottom. But just as importantly, do not let Michael Proctor get away with it. And make no mistake about it, folks. If you convict Karen Reed of anything, if you convict her of anything, science, the physics, the data, they lose. But tragically, Michael Proctor wins.
Strong.
Remember
point.
his texts.
Oh.
Something stinks.
Oh dear.
Yeah, but serious charges will be brought on the girl. She's fucked. Could you ever say to yourself, this is justice? The fact is there was no collision. A car did not kill John O'Keefe. So I ask you, let your voice be heard, not in whispers, but in truth. Let the community feel through your verdict that justice cannot be bent
That's close.
and that it will not be buried.
A little close.
Find Karen Reed not guilty, not guilty, not guilty.
That's probably the end.
Thank you.
Yep. I'm going to see if the court's going to take a break. Nope. No rest for the wicked. Brennan is coming up real quick. That was a powerful closing argument by Jackson. He used the Commonwealth's I hit him to bring no collision, no collision, no collision. And at the end, not guilty, not guilty, not guilty. When I was saying at the end, that's a little close, bringing in the community and other things gets really on the line to improper argument. But I'm not surprised that Brennan didn't object right at the end of closing. I think it probably would have pissed people off in the courtroom and the jury more than the objection was worth, because it was so close on that line of improper argument. But I think saying let your voices be heard ties it in. The community deserves to have faith in the system. Again, close. But if that is the only criticism of closing, it is a minor one, because Jackson has done this a very long time. We know that he leans in to storytelling, to showing the jury. And we didn't see all of their PowerPoint, but we know from the parts that we saw that there were index cards with his points on them dropping on to stacks of reasonable doubt. He opened with the burden, he ended with the burden, and he told the jury what he wanted them to do with that not guilty, not guilty, not guilty at the end. He didn't go into the specifics and nuances of the jury instructions because it goes against his argument. His argument to the jury is this is so obvious, there is so much doubt that it doesn't matter what the jury instructions say. It doesn't matter what the verdict forms say. The only option here is a not guilty verdict. And he called out Brennan directly about the hoodie. He called out Proctor over and over and over again. And we're going to go to Brennan's closing now, but my takeaway on this closing versus last closing, and I did not go back and rewatch it. This is my initial takeaway. Focusing on the investigation, I think, was so much more powerful than focusing on Albert this, McCabe this, who did this, what phone went there. He focused on what the investigation didn't look at, who turned the other cheek, who ignored what they could investigate, and what the Commonwealth didn't show you. It does not ask the jury to believe that all these people did a thing. It asks the jury a very simple question. Do you believe that you know the truth? Do you believe that you were shown everything in this case? And do you believe this was a sufficient and thorough investigation? And if you do not believe those things, then you cannot come back with any other verdict. Focus on the investigation, the investigators, and what the Commonwealth didn't show. I think it was a much more powerful closing, and it gives the jury a cleaner task. Do you believe it? Do you trust what you've been shown? Can you trust this investigation? And can you trust Karen Reed's words? I saw a lot of you in the chat, and there's over 60,000 of you in the chat saying, is he going to address the clips? He did with Dr. Russell. It was sandwiched there in the middle, but he's not going to highlight those clips. He tried to undermine Karen Reed's words being a confession by saying, was it a confession or confusion? That's how he undermined it. That's all. Brennan is going to lean into Karen Reed's words quite a lot. But in opening, Brennan said he was going to lean into the science and the facts. Let's see what he does. All right, time for the Commonwealth's closing, and then the jury will take lunch. And then we will zoom past lunch as much as we can to get to the jury instructions. Here's what I want to know from the jury instructions. Did they add a simple DUI? That's what I want to know. Why are you doing that?
John O'Keefe was 46 years old. 46 years old. He spent his life helping people. He's described as a good man, kind, generous, thoughtful. He was a Boston police officer. He worked to help the community.
Thank God for
Everything
those
you've heard
new microphones
about this man, he was a good man. He helped people.
I agree with this.
When his niece and
100%.
nephew had nobody, he took them in. He took them in. John O'Keefe seemed to be the type of person who would help anybody at any time. And on January 29, 2022, John O'Keefe needed some help. He needed help from somebody else.
Yeah.
You see,
Somebody
John
to
O'Keefe had
investigate
just been
this.
hit by Karen Reed in front of 34 Fairview Road, and he lay on the ground dying. And he needed help. Someone to reach out a hand, someone to knock on a door, someone to make a phone call to 911, even anonymously.
Someone who?
Not take responsibility, just to help. And there was only one person in this entire planet who could help him that morning, to give him a chance. Maybe it was a 33% chance if he met the Isaac Wolf of the world.
Only one?
But to give him a chance. And that one person who could help him that morning was this defendant right here, Karen Reed. And she made a decision. In her Lexus with the shattered taillight, debris field all over the front yard,
Music blaring.
and John O'Keefe lying helpless like a child on the front yard, she made a choice. She didn't call 911. She didn't run to his aid. She didn't knock on a door. She made a decision about herself. In her Lexus, she drove away. She was drunk. She hit him, and she left him to die. She was drunk. She hit him, and she left him to die. Before I go through and detail the evidence, let's talk a little bit about the evidence as a whole. She was drunk. She was drinking that night. She was drinking McCarthy's with John. She was drinking at the Waterfall. Her blood was taken with samples of a retrograde analysis, almost 2 to 3 times the legal limit. She was drunk. She hit him. The timeline in this case is beyond dispute. You can
It is?
accuse, assault, characterize, malign, twist. The timeline doesn't change. It is data. Data is data. The black box, the forensics from the SD card, we know exactly step by step where they were. We know in that window she hits him because he never moves again. His healthcare data. The temperature on the battery of his cell phone.
Really?
The physical evidence, the debris field, the DNA, the hair. And then she left him to die. He had a basal skull fracture, countercoup. You heard all about it when the back of your head hits the ground and the brain comes forward.
Agreed.
Dr. Wolf told us the reason why they have level 1 trauma centers around the country is because people can survive this injury if they get help. That's why they have this care. That's why they have these hospitals. But you gotta get help. You gotta get help. And if you don't, you develop symptoms, ecchymosis, raccoon eyes, your brain swells, and you die.
I like the
She was drunk.
microphones facing into the well. It's very helpful.
And that night was a recipe for disaster. But before we get to the drinking,
You just
in
covered the
some
drinking.
ways, the fate of this night was sealed well before that night because John O'Keefe and Karen Reed were in a toxic relationship. This relationship was crumbling. We hear lovey-dovey, and it was crumbling, and we know it. And we know it because a month before, his niece Kaylee talks about when they went to Aruba. It should have been a wonderful event. It was discord. It was fighting. It was aggravation. And when they got back, the discontent was palpable. Miss Reed reaches out to Brian Higgins, text messaging. John O'Keefe, the relationship is crumbling. And you heard a little bit about what that relationship was like. Kaylee, his niece, told you When there was an argument, John would do what John does. He would walk away. She described to you one time, to get away from the scene, he walked into his bedroom. But the defendant wouldn't let it go, pounding on his door, having to get the last word, never letting go of the fight. Kind of mirrors what happens on January 29, 2022.
He's tying in the voicemails
And maybe
to the testimony from
maybe
Kaylee.
sometimes quietly they got along. But behind closed doors, relationships have up and downs. We have a bird's eye view into the relationship on January 28, 2022, because we have the text messages. Not so lovey-dovey. The relationship is almost over. The tensions are simmering beneath the surface. They are not getting along. She believes Mr. Keefe is already halfway out of the relationship and he's not into it anymore. You will read them, you saw them. This relationship was unstable and at its end. And so fast forward that night. That night, after this discord, after the arguing, they go out and what do? They drink.
They definitely do
They
that.
drink a lot. So Keith drinks a lot, and Karen Reed drinks a lot. You've seen the McCarthy videos. You can call it 6, 7, 8, whatever you want to
What
call
about
it. You
Karina,
can see
though?
the shots into the mixed drinks. More shots into mixed drinks. Count them yourself. Over a half dozen mixed drinks in just a few hours. Sober?
Karina Kolakakis
And then at the
was
Waterfall,
sober.
a shot, a mixed drink. Now, it was brought up the Waterfall that there was some type of discord between Brian Higgins and John O'Keefe. They knew each other. They were friends. Brian Higgins' conduct of speaking to Karen Reed is not honorable. It's not. But they were friendly. There was no adversarial relationship. There was no anger between them. What we heard is they barely greeted each other. Could we have slide?
If you are going to argue that Higgins and John O'Keefe were friendly, it's hard for me when you're the prosecutor and you don't call Higgins. The people at the Waterfall said there was no argument there, but you're in the position to answer that question for the jury and you're arguing it instead of answering it. But I think the whole beginning of his close, I keep calling it the open close, the whole beginning of his close reminds everyone of one thing. John O'Keefe deserved a better investigation and something horrible happened that night. But at the end of his closing, is the jury going to feel confident about what that something is? Let's see what slide 1 is.
One, please. At the Waterfall bar, when you see John O'Keefe come in, here's him barely greeting him. That's
Oh,
him,
they're playing the video of the Waterfall.
Mr. Higgins. Barely greeting each other. Reality sometimes is different than argument. This is a celebratory mood. Take that down, please. Celebratory mood. A
Karina
bunch
said
of
that
friends.
too.
They're playing around. They're hugging. They're grappling. This is a fighting technique for a murder 2 hours later. Is that the story? They're practicing their moves to murder John O'Keefe. In this celebratory mood, you don't see any aggravation or animus between Brian Higgins and John O'Keefe. Inevitably, the next morning, Karen Reed is brought to the hospital and they take her blood. Now, the government doesn't have to prove that she was drunk. It is either that she's over the legal limit, 0.08, or she had enough alcohol to affect her ability to operate a motor vehicle safely, but you will know
That's
that
true.
she was far beyond the legal limit. After the retrograde analysis, almost 2 to 3 times the legal limit. Almost 2 to 3 times the legal limit. Now, it's been intimated, not come out and said, that maybe she went home and started drinking after she got home.
Her words.
No evidence, mind you. No evidence. And that somehow that is why she had a high blood alcohol level. It's not appropriate for me to comment on the credibility of another attorney's argument, so I won't do that. But Karen Reed will do that for her. So if we listen to slide 2, she'll tell you exactly
Should've just
what
leaned
she
into
thinks
her
about
words.
that claim.
My alcohol intakes probably about 5 or 6 or 4. The drinks that they were pouring me at McCarthy's, which is where I consumed most of the alcohol, was the weakest flat tonic. It tasted just like old soda water with blue lime.
Slide 3, please.
I wouldn't have gotten on the expressway. I wouldn't have gotten on the expressway at 12:15 on January 29th. I mean, it was quiet. The roads were very quiet. You can see on the videos. And I was going, when I've had my drinks and I drive, I always drive extra slow. I know my alerts aren't as sharp as they should be. But I shouldn't be driving.
Thank you.
I shouldn't be driving was the end of that.
You think she drank when she got home? When they leave the Waterfall bar at 12:12, you see a video, you have it in evidence, there's a still photo of John O'Keefe holding a glass. Not from the Albert's home. He didn't sneak into the house in the cupboards and grab a glass. From the Waterfall, you see him with a glass, and in it is a straw.
Also, chat, you wanted to answer Brennan's question. Brennan, the 60,000 people in the chat have an answer for your question. Do you think she drank when she got home? A lot of the chat said yes, and the rest of the chat said it's possible that she did. So they're unclear, which means they have doubts about it. So there's that.
Take a look at that picture. And now from 12:12 on, we virtually have a historian in the data that tells us exactly where he went, exactly step by step where he went. And how do we have that? Well, we know the defendant's car had like a black box, and Judd Welcher, Dr. Judd Welcher took the data from the black box.
Saying his name again doesn't make it better.
So you can see the movements and the triggering events. And then Shannon Burgess, well, you don't like what he says, don't attack the data, attack the man. He can be mocked for his LinkedIn profile or his unupdated CV. But what he did is he found a key, critical piece of this case that did not exist before. He found it recently. And it was that SD card. The SD card that everybody missed, including the defense expert.
That's a good point.
Everybody missed it. So as much as you want to make fun of him, Shannon Welcher found the key.
Shannon
so that
Burgess.
he could have the time and date and location coordinated for an impenetrable timeline that can't be broken.
His last name
That's
is
what
Burgess.
Shannon Burgess did.
But his last name's Burgess.
And so we know on the way from the Waterfall to 34 Fairview, Ms. Reed is driving drunk. Mr. O'Keefe is in the passenger side of the car, and they're heading their way to 34 Fairview, and they get
When he talked about Shannon Burgess finding the SD card, I think it would have been smart to say their experts agreed, because their experts agreed, the defense experts agreed that that was helpful timing. They 100% did. The experts agreed on that SD card and how it was helpful. The defense didn't even mention their tech expert. And I wonder if Brennan will point out that the defense did not mention their own tech expert that was their first witness, because they agree. And that timeline gives a window. The problem is the timeline only gives a window. It doesn't narrow it down.
lost. And now
He
we
did
have more
mention
data
DeSorga.
because
I didn't even remember him mentioning DeSorga. Chad is saying he did mention DeSorga. Fair enough. It didn't stick out in my mind. But fair enough. I think Brennan should mention him too.
John O'Keefe has a cell phone. And I said it in the beginning, it is a historian. It doesn't suffer from bias, it doesn't suffer from prejudice, it doesn't suffer from memory loss. It has data on it. And he puts on Waze. High location data, as Ian Whiffen would say. And it tells you second by second the speed, the location, the movement. That's what it does. And he has healthcare data
Oh,
on
that's
that
right, the
phone.
variations.
The
Thank you,
healthcare
Chad.
data separately shows his movement. And that is critical. It is critical because it not only shows his movement, it shows when he does not move. That healthcare data is critical. And it's not subject to bias. It's not in dispute.
It's not healthcare data.
There's no other contrary evidence. It is data. On the way to 34 Fairview, alcohol fuels tension. We know that. And we know from those text messages the tension in that relationship, and then there's a trigger. There is a trigger on the way because they're lost, and when John O'Keefe calls Jen McCabe for directions, Jen McCabe says something that triggers what's going to happen next. Could I have slide 4?
What did Jen McCabe trigger?
Very close to the outbursts. In fact, when Jen was navigating John to the outbursts when I was driving, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating.
And so as they travel to 34 Fairview, under the duress of this crumbling.
I'm going to gain up when they have Karen Reed speak in court because it is a bit hard to hear on the microphones. So if the sound shifts a little for you, that's me. The Bella Child's house, Ashley's house. Jen told her it's near Ashley's house. Right.
Relationship fueled by intoxication, we have triggers. Now, we know on their way there, we know from the data, where they went, how they moved. If we look at slide 5, Ian Whiffen showed you a guide. You could enlarge that just a little, please. And it shows you with the healthcare data, it registers as flights climb, but it doesn't mean someone's climbing upstairs. It could mean there's an elevation.
They didn't even mention the
Break
stairs.
down the data, the red, the green, if you could move down, please, Ms. Gomez. And then the bottom left, that's 34 Fairview. You can see, second by second, the circles of their route, even the three-point turn on Cedar Crest. That's what you see. At that point, they've left the bar. Remember, the battery temperature was 82 degrees. They're now in a car. It's now 77 degrees. Think about how accurate the battery temperature is, that it reflects the difference between being in a bar and being in a car.
Okay.
They take a three-point turn at Cedar Crest. And because of
agree
Shannon
with that.
Burgess, and because of Judd Welcher, we have the data, and it's a triggering event. Remember, if there's an acceleration past 30%, it registers data on the car, and that's exactly what happens. Is a three-point turn, and it all lines up with the cell phone after you synchronize the times. It's that simple. It's nothing complicated. There's nothing tricky. There's nothing devious about it. It's data. They do the three-point turn, and you can match the cell phone clock with the Lexus clock, and when you do, you can reconcile the difference. There's been a lot of talk, a lot of argument, a lot of fights. Shannon Burgess says 21 to 29 seconds. Mr. DeSorga comes in. Unfortunately, he wasn't able to actually do anything. He wasn't given the invitation to test the data. He just looked at the report and made criticisms like a Monday morning quarterback.
Oh, boy.
But even he, looking at the data, says, well, it's 3 seconds off or 2 seconds. Same window, same time. We have all the arguments we want. They're there. They're together. The data matches up perfectly.
DeSorga agreed with his expert quite a lot. I still don't understand why he doesn't just use that. Instead of trying to pan what DeSorga did, why not just talk about where they agreed? He's done it throughout his crosses too. It's an odd strategy for me. Instead of panning the expert, point out where they agree.
Perfectly. And so they make their way down to 34 Fairview Road. They don't stop. They don't stop at the driveway. They don't stop. And John O'Keefe gets out of the car. They go to the flagpole, and we know for two reasons. One, the data. And secondly, Mr. Nagel and Ms. Mason at Cedar Crest, at that intersection before it goes down to the right, they meet. They let Karen Reed go first. They follow behind in the truck. Now, at this point, Mr. O'Keefe has about 8 more minutes
Chad, I'm going to put up a poll because a lot of you are
for the
asking,
beginning and the end of his life.
will he mention Proctor?
And he's in that car. He's in that car for most of it. Because Miss Mason and Mr. Nagel don't see anybody get out of the truck. Nobody crosses the lawn. Nobody goes to a garage. Not just because they didn't see it. They didn't. Not because they didn't see it. Because the healthcare data on the phone shows that John O'Keefe is not moving. The car is stopped at the flagpole. The healthcare data stops. The battery stays at 77 degrees. The data is the data. You can't change it as much as you want to. It's data. And they sit at that flagpole for minutes. It's 12, 24, 33 when they get there. They're there past 12:30. Remember, Miss Mason and Mr. Nagel said they were there about 5 minutes and then they go? It's not exact, but about 5 minutes they said. So there's about 2 minutes left for John O'Keefe. And what are they doing in those 2 minutes? What are the last 2 minutes of his life that he can remember that would be open to him?
Oh, boy.
They're arguing. They're arguing. They're arguing. And we know they're arguing because Miss Reed tells us through first responder Becker. She was sad. Remember, he sees her in the back of the ambulance and he's trying to calm her down? She was sad because her last moments were arguing. They're in an argument. That's why they're not going in the house.
That also supports the stress, though.
But John O'Keefe
Doesn't it?
decides to get out of the car, and we know because the dome light goes on. That's what happens when you open a door. Whether he's bent down, he's standing outside, or on the other side, the dome light is on. And then you see the data. John O'Keefe begins to move. 12:31:56. It's the first time he has moved since they got to the flagpole, and it will be the last time he moves in his life. And he moves for 20 seconds. Ian Whiffen said that the satellites, they move, they reconnect, they pull information. He's no longer on high-frequency data because waves are shut off. Now it's more random. It's low-frequency. We would never suggest, and Mr. Whiffen did not claim, based on location data alone at that point, you can tell exactly what John O'Keefe is. What he said is it was readings all night. The bullet is always near the flagpole. That doesn't mean he was always near the flagpole. He could have moved. He could have moved in the circles and come back. Location data is consistent with him never leaving the flagpole.
What?
So that in itself is not enough.
He could have
But
moved
there's
within the
more.
circles?
There is more. There is the healthcare data.
Wait, what?
There is the temperature of the cell phone battery. And so he moves for 20 seconds. It turns west. It does not say he walks to the house. That's not what the data says. It doesn't say that he goes straight line and he walks over to the door. In fact, could he even get to the door in 75 feet? Could he get there? Because when the investigator for the defense testified, he measures from the driveway. He never stopped at the driveway. He never measures from the flagpole. He never measures from the flagpole to the garage door. So this fantasy that somehow he walked in the garage, even though there's no evidence, there's no witness, there's no data. 20 seconds of his life. And he moves. And healthcare data registers his steps. It could be pacing. It could be a straight line. It could be shaking the phone. We don't know.
We don't know.
We don't know everything. We don't know every little detail and every little second. We don't have to. That's not doubt. That's not reasonable doubt. We know for that 20 seconds he's moving. And in that 20-second window, when he moves, he has his phone and he looks down, 12:32:09, he sees a text message from his friend, John McCabe. And he looks at the text message and he closes it.
I don't think I've ever heard a prosecutor say we
No,
don't
no.
know everything and we don't need to.
We know from the uncontroverted data from that black box, we know that Karen Reed, after he gets out of the car, drives away. She drives for at least 33 feet away from him. He's back near the flagpole. She's gone. It's over. Whatever argument is over. Whatever anger and flame has been dispassioned, she's moved on. He's separate from her. He's safe. And then she makes a decision. That's what this case is about. Then she makes a decision. She could have driven home. She could have broken up with him. They could have talked about it the next day. Or like knocking on the door, like Kaylee said, getting the last word. She doesn't drive away. She takes that 6,000-pound Lexus and she makes a decision. And the decision is that she steps on the gas after banging it into reverse. Before we talk about what happens next, I want to talk to you a little bit about the charges in this case.
Okay.
I digress, but it's important so we really understand what we're talking about here. I have no authority to talk about the law in this case. The Honorable Judge Cannoni will do that. But I want to talk to you a little bit about the charges. Don't rely on my interpretation of the law. It's the judge who has that special power. But I want to explain to you a couple of things so when you think about what happens next, you can really assess the facts of this case with the charges against Miss Reed. She is charged with second-degree murder.
I was very much hoping we would see Hank Brennan get into explaining the charges. And he walked the jury through his argument of what happened that night up to the moment, as he says, Karen Reed banged the car into reverse and started rocketing it backwards. Those were my words. And now he's going to explain the charges. He is pausing right up to the explanation of how John O'Keefe gets hit to pause and explain the charges. Okay? I was hoping he would explain the charges. I'm interested to hear how he explains them.
Sounds ominous. It is. It's a serious charge, second-degree murder.
Second-degree murder is the top charge
When
here.
most people think murder, they think shooting or stabbing somebody. It's natural to think that. Second-degree murder is different. It's not first-degree murder. I told you at the beginning of this case.
He did.
I told you that we were not going to suggest or try to prove that Miss Reed intended to kill John O'Keefe. That was never part of this case. We're not claiming that. I told you that we were not ever going to try to prove that she even intended to hit him. We never suggested we would try to prove that, and we're not trying to prove that she intended to hit him. We're not. What we are obligated to prove, and what we have proven from the evidence in this case of second-degree murder, is that she intended an act, and that is
The reverse?
putting the car into reverse
Yep.
and heading back towards John O'Keefe. She intended that act. The question then becomes, did her conduct create a clear, plain, strong likelihood of death? Late at night, dark, beginning to snow, under the influence of alcohol, knowing where she stopped and left him
I said that
after an
yesterday.
argument, heading back in reverse to the exact spot or right near where she left him at over 24 miles per hour, accelerating at over 75%. You need to ask yourself, are you convinced if somebody does that create a plain and strong likelihood of death? And if there's no doubt in your mind that she intended to hit that accelerator in reverse, and that conduct will create a clear and plain likelihood of death, then she is guilty of that crime. Whatever the label is, she would be guilty of that crime. Now think about this. Let me give you an analogy. If somebody, maybe a teenager, someone young, impulsive, is on a bridge, and they see cars going by, and they have a boulder, and they want to throw the boulder off, they're not looking to hurt anybody.
What?
They're not meaning to kill anybody, but they throw the boulder off the bridge because they want to see the car break, the thrill. And when they throw that boulder
This is
off
not a
the
good
bridge,
analogy.
and it comes down and lands on the car, and there's somebody, passenger, child, anybody in that car, and it then goes through the roof and kills the person in the car. Did they intend to kill that person? No, they were trying to have a thrill throwing the rock. Did they have the malice to want that person dead? No, they didn't. But that would be an example of second-degree murder.
Not a
When
good
you
analogy.
take a boulder and throw it off a bridge, there's a plain and strong likelihood
That is
of death.
not helpful.
When Karen Reed in the midst of that tension and fight, after she drove away and was gone, disengaged, when she came back for the last word, in the darkness, the beginning of the snow, under the influence of alcohol, and decided to stop her Lexus, decided to put it in reverse, decided to accelerate 75% in the exact same direction of where she left him, and then hit him, and he died. I suggest to you that is second-degree murder. The other charge, operating under the influence of alcohol, manslaughter. It's different. It's a totally different and separate charge.
It is.
Was she under the influence of alcohol? And then secondly, did she operate her Lexus wantonly and recklessly in a way that would very likely result in serious injury?
Very likely result is the
When you're
difference
under the
there.
influence of alcohol, and you drive a 6,000-pound Lexus in the heat of the moment, at the direction of where somebody is, whether you intend to hit them or not, I submit to you that is wanton, it is reckless. And any reasonable person would think it's very likely that serious injury would result. It's not a matter of intending to kill.
Very likely
It's
is
not a
that
matter
standard
of
for
intending to
manslaughter.
hit. It is the conduct of the operation and the risk that is created.
He's explained that one better.
And so those two charges are two of the three. The three is leaving the scene, knowingly causing death. And we'll get to that. So now, sadly, we need to get back to 34 Fairview Road where we left.
So we covered counts 1 and 2,
We
not
know
yet count
from
3,
the text
leaving
stream
the
data
scene.
that you drove 33 feet at least, because it only picks up a 10-second window. And when it starts to pick up the data, we know she's driving at a speed. So it's more than 33 feet. We just don't know. And then when she comes back, she covers the 33 feet and 50 more. 80 feet. 80 feet. Over 80 feet. Now,
Where
nobody
was
has
that
ever
room?
suggested, even Dr. Welcher, when she collided with them. This data doesn't tell you collision. It's a 6,000-pound Lexus. It's a 216-pound man. It's not going to show a blip. It could have been in that 10-second window. It could have been 2 seconds after. It could have been 4 seconds after.
Could have been, could have
But
been.
it's in that pocket of time, and we know it. We know it because when you reconcile the data with the phone, that 20 seconds is in the same window of that 10-second window coming back. So even if it's a couple seconds later, 4 seconds later, whatever Mr. DeSorgo wants, he stops moving. John O'Keefe stops moving. Forever. Forever. Next slide 6, please.
Probably going to be a clip of Karen Reed, I would imagine.
You'll get to see this more closely. And you can probably see
Maybe
it where
not.
you're sitting, but there's important data. Data doesn't lie. And you will see acceleration,
Oh, the car chart.
75%. You will see speed, 24 miles per hour backwards. You will see distance, over 80 feet. That's what you're going to see in this data on that night. Anger, although not necessary in any of these charges, anger can be inferred for somebody to come back that hard, that fast, that reckless, that obvious, likely to create a plain and strong likelihood of death. That data tells a story that can't be changed, can't be attacked. ARCCA, they did some crash test dummies. You know what else they do? Text stream data. There's nothing about that data that is uncertain. Nothing.
That's a good point.
Take that down, please. When Ms. Reed...
He's working with what
John
he
O'Keefe,
has, right? ARCCA doesn't disagree with the text stream. ARCCA disagrees with the fact that there was collision. He didn't point that out. He's not going to. But ARCCA doesn't disagree with the text stream.
hits John O'Keefe, collides with John O'Keefe. We don't know if he went in the air a foot. We don't know if it was how much of a clip it was. We don't know if he stumbled back but we know there's a collision. There's no doubt there's a collision because her taillight's all over the yard. It's all over the yard. And when he falls back and he hits the back of his head, his basal fracture, he's then lying there helpless. When Miss Reed leaves, she leaves behind tons of her taillight all over the yard. All over the yard. It's called the debris field. And you've seen videos. You can't replicate the exact contact. You can't because you would need where the person was hit, how fast the person was going, but you know what happened because when you look at the debris field, when a light is broken, it's no different than what was on the front yard. It's no different. She leaves him behind. She leaves her taillight behind. She goes home. And on her way home, you know she's still angry.
Yeah, well, we heard her messages.
You know she's still angry because she starts leaving him voicemails. Slide 7, please.
He's going to play some of those, it seems like.
Healthcare starts at 12:31:56, 12:32:04 to 12:32:12.
This is their timeline.
The data, which is adjusted when you reconcile the clocks on the Lexus. 12:32:09 is when
this is the first time I think we've seen a consolidated timeline.
12:32:16 is his last steps. The disorder says that red range should move a little bit, 2 or 3 seconds. They can move it 4 seconds, 5 seconds. It doesn't matter. It's all in the same window. It doesn't change. We could have slide 10, please. Can you play that, please?
Oh, I didn't need to gain that up. That's the car going backwards.
Thank you. Each one of those pegs represents 10 feet.
Okay.
You can't place that car where it was.
Did you just show us a slide of a car going backwards? Did you just...
In front of Fairview. You just
Okay.
can't. The data doesn't tell you that, but that tells you the movements of that car.
The car went backwards. Okay.
Now, as John O'Keefe sadly lays on the ground, abandoned, you're going to have to ask yourself a question for charge number 3, leaving scene knowing somebody was injured and then died. You're going to have to ask yourself, is there evidence that Miss Reed knew that she had hit him? Don't need to prove it for murder 2. Don't need to prove it for OUI manslaughter. But for the 3rd charge, Commonwealth has to prove beyond a reasonable doubt
She has to
knew
know.
she hit him. We weren't there, but there was an eyewitness. There was a guide. And that eyewitness tells us that she knew. And that eyewitness
Is Karen Reed.
herself.
Yep.
She tells you that she knew. Could we have slide 8, please?
Could I have hit him? Did I hit him?
I'm gonna gain this up. I'm gonna back up so I can gain it up. He said there is an eyewitness there who can tell you, and that eyewitness is Karen Reed.
That she knew. And that eyewitness
I'm gonna gain this up so we can
is
hear
Karen
her.
herself. She tells you that she knew. Could we have slide 8, please?
Could I have hit him? Did I hit him?
How could that have been? I mean,
I don't know what that could have been. It was howling wind. I had YouTube blasting on the stereo. And I thought, did he somehow try to flag me down, which was the reaction I was hoping to garner as I slowly pulled away from the house. Did he come out and maybe trip or bend over to pick up his cell phone and I ran over his foot and then he passed out drunk? I mean, I didn't think I hit him, but could I have clipped him?
I didn't think I hit him, but could I have clipped him? Is that a question or a statement? And is the jury asking themselves, is that confusion or confession, as the defense argued? I gained it back down.
When she left Fairview and left John behind, she didn't think he was mortally wounded. But she knew she hit him. She knew she hit him. And so when she made her way back home,
Are you
not
gonna
only
play
did
that
she
clip?
leave debris field all over the front lawn. But she took evidence with her too. Hair, DNA on the taillight, and she drove back to John's house. And she started calling on the way back, 12:33, just a minute and a half later. And then her messages show her anger. You see, this was John's fault. This was John's fault. And her phone calls tell you about the tone and the destruction of that relationship. 53 phone calls that night. 53 phone calls. Not one to 911. Not one to Jen McCabe, please go outside and try to help. Not one to a hospital.
Why would she call Jen McCabe to help? Jen McCabe didn't live at 34 Fairview. Was Jen McCabe still at 34 Fairview? Why would she call Jen McCabe to help? Unless Jen McCabe knew what happened, why would she call Jen McCabe to help? I'm very confused by that argument.
53 phone calls that night. 53 phone calls. Not one to 911. Not one to Jen McCabe, please go outside and try to help. Not one to a hospital. Not one to anybody but him. 53 calls. Slide 12, please.
Interesting. It's an interesting argument. And I say it's interesting because we know Jen McCabe's sister lives at the house, but that's not what he just said. He didn't say, why didn't she call Jen McCabe and say, can your sister tell me where John is? That's not what he said. All right, we're going to hear the voicemails.
Can you play voicemail one, please?
In the timeline with the voicemails. I'm not gaining these up. They're too loud as it is.
The calls keep coming. Cell phone temperature, 72 degrees. He's been outside now, not moving, on that cold, hard ground with his cell phone.
So most of the
under
timeline
him.
we've seen from the Commonwealth.
The warmth of his body, the cold ground, 72 degrees. It tells you the story. As this temperature plummets and that cell phone battery is compromised, so is John O'Keefe. And him and his cell phone alone on that yard. 66 degrees at 12:45. It is plummeting. Ian Whiffen's taking a phone and putting it in a freezer, not a same analogy. The idea that means that John O'Keefe was in the house, absurd. 66 turns to 61, it's 12:53. 48 unanswered calls from the defendant. He's not in at a party. He's not wrestling with Brian Higgins. He's not in a fight. If he's in a fight, his cell phone would be moving. There would be healthcare data. There'd be steps. If he got into the house in 20 seconds and his cell phone is found under his body the next day, and how would he get back outside? There would be more steps. Because this phone is working, the data is the data. There's nothing wrong with it.
It's a good
registering
argument.
Everything.
The phone
The
stops
temperature,
moving.
The movement.
Right?
He doesn't go in any house. He can't go in any house. His phone never moves again. Voicemail number 3, please. Listen to this.
The phone has data coming in all night. He makes a good point. The phone has location data pinging back all night long. And it shows that the phone's not moving. It's a fair point.
Fucking kids. Nobody knows what the fuck you want, you fucking pervert.
Did you hear that? Nobody knows where you are. It is 12:59. John O'Keefe has been on that lawn for about 27 minutes.
It's a good
She
argument.
hasn't called anybody else, hasn't spoken, has no information. Nobody's called her. You'll see her phone records. And she says, nobody knows where you are?
No, nobody knows where the fuck you are.
She knows. She knows. Nobody does know where he is. Except her. except her. Why is she asking nobody knows who you are? She is starting to get panicked because she knows she hit him. Not suggesting she meant to kill him or for him to die, but she knows she hit him, and now he's not responding, and she's getting nervous, and she's getting anxious, and she's leaving call after call after call. He's not answering. He's not calling back. He's not even picking up the phone. And we know what's happening at this point. Panic, drunken denial, it's setting in.
I agree that she's
And
panicked.
so then we see the healthcare data from Miss Reed's phone. She doesn't move after a little after 1 o'clock. She could be sitting, she could have fallen asleep, but she doesn't move for a while. But she wakes up. She wakes up early the next morning. Take that down, please. And when she wakes up, she doesn't call Jen McCabe and say, "Where's John?" She doesn't call Brian Higgins, has his number, has been texting with him. "Hey, was John at a party with you? Did you see John tonight?" She knows exactly where she is, and she's frantic. So she wakes up Kaylee, that young girl at the time, and she says, she's panicked, she can't understand where she's saying, "Call Jen McCabe, call Jen McCabe." Why is she calling Jen McCabe? She calls Jen McCabe. You know what she doesn't say when she calls Jen McCabe? "When did he leave the house? What happened last night?" No. She calls and says, "I left him at the waterfall. I left him at the waterfall." See, now it's gone from panicked to self-preservation. "I left him at the waterfall." And Jen says, "Left him at the waterfall? We saw you in front of the house." Click. Hangs up. Hangs up. So then she calls someone that she doesn't know very well. She calls Carrie Roberts. But now she has to pivot because someone has seen her in the exact spot that John will be found soon. Whether she's the first one there or somebody else, John will be found. Maybe Lucky missed him. It's a snowstorm. You can't see. But someone's going to find him at some point. So she calls Carrie Roberts. It's no longer she left him at the waterfall. She pivots. She calls, "Carrie, Carrie, Carrie. John's dead. I think he got hit by a plow." Why do you think she chose those words? Why did she choose those words? Because she knew that there was a collision with a large motor vehicle, and she had to substitute her 6,000-pound Lexus for another big vehicle.
Interesting argument.
I think he got hit by a plow. And so now we have the introduction of Jen McCabe and Carrie Roberts. Phone calls that they probably never, ever wanted. A worse nightmare to get a call like that. For what's going to happen, what they're going to see, what they'll never be able to forget. But because the defendant is John O'Keefe's girlfriend, they wake up in the middle of the night, in a blizzard, out of their kindness, their loyalty, their devotion to John O'Keefe. And when she calls them and tells them that she wants them to come out, this soccer mom with a perfectly normal life
Oh boy.
gets drawn into this whole farce, and she answers that call. She gets out of bed. The spirit and kindness she displays to put herself in that position because someone asked for help, because that's what good people do. Carrie Roberts didn't know Jen McCabe. They both knew John. They met each other once years before. Carrie Roberts, separately at that time, answers the call, gets out of bed, drives to go help, because they have a common denominator, a common bond.
John
O'Keefe. And so you hear and see at 5:07 the defendant leaves Meadows. She leaves. And Kaylee is behind waiting. And you see her back up.
Heartbreaking.
And Judd Welch just showed you all of those demonstrations where you could see the unsettled snow in the back. And after the bump, you can see the pieces missing. No taillight. There's no taillight on the ground, all the white snow. There's no crack. There's no break. It's a nudge. It's a nudge. But the taillight has already been broken, because when you look at the video, not one little piece, it's still framed, little angle with the light, the brakes are on. You take a look, you'll be able to slow it down. You'll see the exact same piece is missing. Because it's back at Fairview. That's why it's missing. It's not there, it's back at Fairview. And then she leaves at 5:07. She gets to Jen McCabe's about, 5:35? 28 minutes.
That was
About a
long.
10-minute ride. Where did she go in 28 minutes? Where did she go? We don't know. We don't have data for that. But we know when she gets to Jen McCabe's house, she is panicked, frantic, out of her mind, screaming,
But why is there no data
waking
for that?
everybody up. Jen McCabe comes down. Can't understand her. Going out.
You have data for everything. Why don't you have data for that? Why is there no data for that 28 minutes?
To the car to try to console her. Why is she so frantic? Why can't she speak? Why can't she say a word? Because John went out and had a drink and fell asleep on a couch? Because John would maybe be cheating on her? What is causing this extraordinary duress? Did she stop somewhere on the way by?
Well, I'm completely biased on this point because I get very stressed when somebody doesn't answer the phones, as you well all know. So I don't really have objective thoughts about that. But when somebody's not answering my phone calls, yes, I get panicked. I get upset and I get frustrated. But he's intimating, where did she go for that 28 minutes? And why was she out of her mind stressed? Is he going to argue it's because she drove by Fairview to see what was going on? And she knew he was there? She drove by Fairview. She knew he was there. And then she went to get everyone. And that's why she went running out of the car to where he was. Because she already knew, because she did a drive-by. Is that I think that's where he's going with this argument. And that's why she's so heightened when she sees Jen and Carrie.
Did she just see death?
That's exactly what he's going to argue. I'm going to back up. But there's a lot of these arguments that are being made more like a defense attorney, because a lot of these arguments are could. Could this have happened? Could that have happened? Did she? You don't get to give options. The defense gets to give options. You have to give one thing that happened, not options. But if the jury believes the data, he's saying, look, this is why she's so upset.
Couch? Because John would maybe be cheating on her?
Not because he's on a couch.
What is causing this extraordinary duress? Did she stop somewhere on the way by? Did she just see death? Kerry Roberts comes, take charge kind of person. She pulls him behind. She sees the broken taillight in Jen McCabe's driveway, and she decides she's going to commandeer this. We're going back to Meadows. You're going to follow me. Leave the car. I'll drive. At this point, Jen and Kerry don't know each other. They've only met once. And they go back to Meadows. They obviously don't find John because he's back at 34 Fairview. And then they start their way towards 34 Fairview. They start driving towards 34 Fairview, and they're looking. And you heard from Kerry Roberts, Jen McCabe, they're looking out the window. They can't see a thing. The snow, the blizzard, the weather, the darkness, they can't see anything.
Right.
And they're driving, and they decide they're going back to 34 Fairview. And this is remarkable.
They went back to
This is
34 Fairview
remarkable.
because
when they
of
start
Jen.
their way past towards 34 Fairview, they get close. And when they get close, they can see nothing. But the defendant screams, "Stop, let me out." And they look around and they say, "What? Let me out, let me out." She does not see John O'Keefe. She knows where he is. She knows exactly where he is. She knows where to find him. She knows where to expect to find them because she knows where she left him. She tells us. Slide 13, please.
Oh, they're going to play her clip.
Driving Jen's in the passenger seat. And I described this to everyone, so you probably know this before, but John looked like a buffalo on the prairie. It was just a lawn and a heap that it wasn't a bush or a hydrant or a dog. It was a weird shaped lump at that time in those elements. And I was looking to find him on the side of the road. I was expecting I'd find him.
Thank you.
I was expecting I would find him.
A weird shaped lump in a blizzard, and you equate that to John O'Keefe? A weird shaped lump, not like a bush, and that is John O'Keefe? She tells us she knows where she left John O'Keefe. And so they go over to Mr. O'Keefe, Kerry, and Karen. And she's upset, there's no doubt. I am not for a second trying to deprive her of the unrest and the trauma that is happening at this scene. Doesn't change what happened before, but I appreciate the trauma. And they're trying to help him. And guess what
I'm
happens
turning
when
that
they
down a
first
bit because
move him
he's
around 603, 604?
peeking.
Ian Whiffen, data. The cell phone battery gets the cool air, presses on the battery, the cell phone battery drops. Healthcare data, he has not moved since that 22nd, hasn't moved. They start shaking him, you're going to see, when you look at the records, that healthcare data starts to move. He's been there all night. All night. Nobody else. Her. And so when they try to help him, she says something that is remarkable.
He answers the question about why the phone battery
She
temperature doesn't continue to drop. He didn't say it. He says, when John O'Keefe moves and the cool air comes in, then it starts to drop again, and tells the jury, go look at it. The phone was under John O'Keefe, and when he moves, the temperature drops again. And he's inviting them to go look at the evidence. But he's got to be getting close to done. And you know what name he hasn't said yet?
There's a piece of glass.
Oh, he's going to play her
stuck
clip
in
again.
his nose. And she plucks it out. And she says when she plucks it out, blood spurts out. We'll talk about that in a couple minutes. But remember that. Piece of glass, pulls it out, blood spurts out. That's what she says. As they try to help John, Jen is calling 911. They would like you to believe there's a conspiracy.
They didn't argue
The glass that's
that.
found in Mr. O'Keefe's body is somehow from inside the Albert House. The glass, well, you will hear in the clips, if we don't play it, you'll have all the clips with you. She talks about the fact that he took her glass. He took the glass. She says it.
She does.
So the Albert House, they don't need to give the glass. He already has the glass with the straw that's later found on the street, by the way. That's what
The point the defense was making, though, Brendan, is not where the glass came from. It's that investigators didn't look for it, though. The point they were making is that investigators didn't go look. They didn't know what she said. These interviews are recent. These interviews, you have them all dated. They're not something that law enforcement knew. The defense point was they didn't go look, not where it came from. That's the difference in the point, though. And then the glass on the back of the car is a pesky little thing.
happens on an impact, things move. The glass comes with him, lands near his body. Debris field moves past him. Shoe, hat, straw. Jen McCabe makes a call to her sister, and they say because it registers 29 seconds, a cell record is not the same as a call detail record. There was no evidence, it was a conversation. No lights go on, there's no conspiracy. You can call somebody, it can ring, it can go to voicemail. They have
Was there a voicemail?
no evidence, none, that there's a conversation between Jen McCabe, the person who was ripped out.
The defense doesn't have to have evidence, though. You're arguing like a defense attorney. The defense doesn't have to have evidence. I think this is like the third time he said that. I think if I were the defense, I might object at this point and say burden shifting. I very well might. The defense doesn't have to have evidence of anything. I don't like it. They have no evidence of that. He can say that's all just argument from them, but our data shows. But him trying to say the defense doesn't have evidence of that is getting perilously close to saying they need to prove it to you. They do not. We'll see if he keeps doing it if the defense objects. But
Out of her sleep.
It's uncomfortable at this point. For me, watching. They have no evidence of that. He said it 3 or 4 times.
There was no evidence. It was a conversation. No lights go on. There's no conspiracy. You can call somebody. It can
He
ring,
can say
it
there's
go
no
to
evidence. He
voicemail.
can't say they have no evidence.
No evidence.
Right. That
None
part.
That there's a conversation between Jen McCabe, the person who was ripped out of her sleep to come help, and her sister for some grand conspiracy. And so what happens next is traumatic. Kerry Roberts and Jen McCabe see their best friend prone, lifeless, frozen, on the ground. And they're living this torment because somebody brought them into this. When they're trying to help John, there is not one suggestion from anybody that John ever went into that house. There's no reason to go into that house because John was never in the house. Not one time does anybody say, what time did he leave? I thought he went in there. Not even a whisper of it because it never, ever happened. When they find their friend John, he's not 20 feet off the side of the road like Mr. Rentschler or Mr. Wolf thinks. He's right there by the side of the road, close by the curb.
Who took those measurements? Just remind me, who took them? Who took those?
Slide 14, please.
Who took the measurements about the road? Just, I forgot.
You see, there's Kerry Roberts' vehicle,
Just can't place it.
and then on the left, you can see where they're working.
Where?
Right off the road. That's not 20 feet. That is a clip, a stumble, and a fall. And remember, when John Keefe fell, there wasn't snow. It was just the beginning of a dusting. It was the cold, hard ground. Remember what Dr. Isaac Wolf told us about cold, hard ground? Causes this type of injury all the time. All the time. If we could go to slide 16, please. Remember the glass in the nose? The glass in the nose.
I think what Isaac Wolf said was when people slip on pavement.
See on the bottom left, that's where the Canton Police Department found the glass that he took from the car, from the waterfall. And then exhibit 195, matching glass. On February 3rd, the matching piece of glass was found on the street. The matching piece of glass, the glass that was found with Mr. O'Keefe, was found on the street. He didn't fall back 8-10 feet from the road. It broke, and then it shattered and went to the street. I would suggest to you it broke at the time of the collision, and he carried the glass with him, leaving the evidence behind, a trail
What?
to memorialize what happened to him that night. Remember the straw I asked you to take a look at that picture and leaving the waterfall at 1212?
If he is holding that glass in Exhibit 195, I need you to tell me why his hand is not cut. Thank you.
Black straw in the drink on the street. Collision, glass, nose, straw, back, hits his head. Could you play the clip on the left, please? 59.
So when John got out of the car at Brian Albert's house, he took my full.
What happened?
What?
The feed stuttered. That was not you. That was not your internet. Blessedly, that was not mine. The feed stuttered.
69, please.
So John's laying there, his left and his right, and I approached John from the left. That's where the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And it just pulled it, and as soon as I pulled it, it just gushed blood down his face.
Thank you.
Gush blood, not spurted. Gush blood down his face.
911's called by Jen McCabe.
I gained that
Not
back
hiding
down.
from anybody. She's trying to help. She's bringing attention to the situation. And when 911 comes, we have first responders. These people are heroes. Some of them, you've heard from some of them, they were born to help people. That's what their life is about. The detail on all their mechanics, getting to work 2 hours early in the middle of the blizzard so that you're there on time so you can help people. These are the core of our community. Mr. Nuttall, This is what he does. He rushes to go help. He's the first person on his knees. He doesn't know this person from anybody. But to him, it's another human being. This is his passion. Katie McLaughlin, first responder, this is not just a profession, it's her life.
It's like first responders respond to emergencies and want to know what's happening. Like that?
Yes, she knows Caitlin Albert. Do you think she went there that night at a party and set up a murder and came back? And so they tell you what happens at the scene. Some things hard to remember, some things people will never forget. When you're in a traumatic incident, sometimes it's something you'll never, ever forget. And Timothy Nuttall remembers speaking to the defendant. I hit him. Remember, he's on his knees. What happened? I hit him. I hit him. She is now coming to terms with the moment. Her fear is realized. She hit him. She clipped him. She didn't think he was mortally wounded. She panicked. She can't come to terms with it, so she has to bring people with her to face it. And now she's facing the reality of what she had done.
It didn't stand out
And
to her
her
enough.
emotion is overwhelming. I
about
hit him. I hit him. She speaks to Miss McLaughlin. I hit him. Not did I hit him? Could I hit him? Perhaps I hit him. That was earlier. Now she's recognizing what she did. I hit him. And these people are making it up. Anybody that says anything adverse or inconsistent or inconvenient is a liar or a perjurer or in on a conspiracy. Or is it that these good people who went there for a total stranger to do their duty to help happen to remember that she admitted what she had done? I know that doesn't reconcile with the boogeyman Proctor and the bad government. I know it doesn't reconcile with no DNA on this piece of that.
Did he just call Proctor the boogeyman? Okay. We've heard Proctor's name once. He's not explained what Proctor did. He's not explained why this investigation's not tainted. But he said, essentially, the defense is making Proctor the boogeyman. Okay. But also the defense didn't call Proctor because they wanted to make him the boogeyman. I am curious as to which the jury will find more effective because they have the texts. It's not just all fiction is the thing with Proctor. I had to back up to hear him say the boogeyman again because there's the one Proctor drop. I'm now keeping track.
You're done. I know that doesn't reconcile with the boogeyman Proctor and the bad government. I know it doesn't reconcile with no DNA on this piece of that piece. I know it doesn't reconcile with everybody setting up the girl. I know that doesn't reconcile. But the reality is you have independent core people who hear her say, I hit him. I hit him. And the attempt is to portray everybody as a liar. But you don't have to rely just on these good people, although you should. You should. You don't have to.
I mean, some
Because
of
we
the
have a
witnesses
guy,
lied.
and it's Karen Reed. Slide 17.
He is making every single point that he is making with Karen Reed's statements. When I said yesterday that they were going to use Karen Reed's statements for their whole case, I didn't think it was going to be this much of using Karen Reed's statements for their whole case. But that's where we're at. I gained this up.
So I must have said was, did I hit him? I always said I hit him, but did I really say this many times as law enforcement is claiming I said it?
Thank you. I know it doesn't fit.
I know I said I hit him. It's a good point. It doesn't fit the narrative, is what he's going to say. And Karen Reed, in her own words, I know I said I hit him. I'm going to back it up because it went fast. And I started talking.
So I must have said was, did I hit him? I always said I hit him, but did I really say this many times as law enforcement is claiming I said it?
Thank you. I know it doesn't fit the theme, the theory, the story, but she tells you herself. She endorses those good people exactly what they had heard. She tells you herself she hit him. It's undeniable, it's unmistakable, it's inconvenient. But the truth has a way of seeping up to the daylight. It can be oppressed and suppressed and pushed down and covered and twisted, but it rises. It rises. And it is not a coincidence. There's no coincidence that Mr. Nuttall and Ms. McLaughlin hear exactly that.
I had to gain him back down.
She tells you. And Jen McCabe, when she's sitting next to or standing next to Ms. McLaughlin, she tells you she saw or heard the same thing. Remember what happened to her on the stand when she had the audacity to say, I heard her say it? What happened to her? This woman who never even wanted to leave her home that day, pulled out into a storm to see her best friend dead. What happened when she had the audacity to say that? And now we know that the defendant herself said the same thing. And the funny thing, the ironic thing is, you will see in a photo when Ms. McLaughlin, firefighter, was speaking to the defendant, Ms. McCabe was next to her. Ms. McCabe was trying to protect her, trying to shut her up. Don't talk, you're upset, stop saying crazy things. The villain of this story was trying to help the defendant from incriminating herself. The irony. Can we have slide 9, please? This is the battery temperature. You're going to have a chance to look at it. If it wasn't so tragic, it is interesting.
Battery temperature.
If you like data. The 29, 12, 13. They're leaving the waterfall, 82 degrees, 12:22. In the car, 77 degrees, 12:37. About 3.5 minutes after the defendant collides with John O'Keefe, it started to go down 72, 12:45, 66, 12:53, 61. And you see it drop and steady off at 12
until 6:14.
Remember, cell phone battery under him. John O'Keefe either struggling for life or he's passed. And blood's still warm either way under him. Doesn't move again until 6:06. It drops down 7 degrees because the women are pulling on him. The cold air is hitting the battery. What happens at 6:15? You're going to see the video. You've seen it. Still photos. Kerry Roberts goes over.
They pick him up.
Picks up the phone. Not only does she pick up the phone, she puts it in her pocket.
Pick up John O'Keefe.
And then 20 minutes later, the next meeting, the temperature rises. That's not convenient. That's not a coincidence. That's fact. That's data. And then the vote is passed, put in a warm environment, and it raises up. 6:15. How can someone conspire to pick up a phone on the side of the yard that was under Mr. O'Keefe's body at 6:15 and know the battery temperature was then going to rise? And not only did the battery temperature rise, when you look at the healthcare data, at 6:15 when she picks up the phone, you know what happens to the healthcare data, right? It starts to move. It's data. It's data. So, while they're going through this duress, the defendant asked Jen McCabe for yet another favor. Look up hypothermia. Find out how long it takes for someone to die in a cold. And there's Miss McCabe
That's not what she
in her
said.
winter jacket, soccer mom, trying to help. She has MS. Her hands aren't working. She's trying to type in what's happening during that time. It's a frantic scene. She tells you that. The defendant then wants to run back to the ambulance, so she goes with her, never finishes or completes the input. And then she tries it again. At 6:23, at 6:24. That's what this woman did that night, that morning. Not only for her friend, for her. For her. That's what she did. And what happens to her after? Because the timestamp, when you open the timestamp, it's at the time it's open, and she's in bed at 2:27 looking up Hockomock Sports because she is so interested in the kids' sports, and that timestamp stays open. And she goes to that tab the next morning when she puts in how long to die in cold.
He's going to play that clip of It's You or
And that's
Me.
being portrayed that she's
right?
in a conspiracy. She gets vilified as a murderer, a soccer mom who came to help. It took Ian Whiffen 5 minutes to show you a live demonstration on how simple that works. That she's not deleting anything. Jessica Hyde told you it's automatic deletions over time. You usually can't delete that information. That's not a click and swipe like the good Dr. Wolf from ARCCA knows how to do. This can't be erased. But they still hold on to this. as they argue to you and all the injustices that have been done, they tell you, they want you to believe, or take a flyer on the fact that she looked up how long to die in the cold at 2:27. It is an absolute contrary to the science. There's no basis to support it, but they stand here in front of you. Why? Because every time they say something like that, you look the other way. Don't look at her. Look.
The defense spent a very brief few moments talking about Jen McCabe in their closing. The prosecution seems like they wrote their closing based on the defense closing in the first trial, not based on the clear strategy this trial. And the clear strategy this trial, for everyone to see, was pointing at the investigation. Everyone could see that coming from a mile away. We knew. We've talked about it for 8 weeks that the defense strategy was to point at the investigation. The investigation, the investigation, the investigation. What didn't law enforcement look at? What was Higgins doing? Why was Higgins at Canton? And they wrote their whole closing with a substantial amount of time focused on Jen McCabe. The defense didn't argue third party once. And the prosecution's like, look what happened to this soccer mom. She got called a murderer. Who called her a murderer in this trial? I don't know how he couldn't see exactly what was coming from the defense. Because this is written for the way they argued last time, not the way they argued this time.
Look the other way.
Okay.
227, look the other way. Don't look at what she did. Former Trooper Proctor, look the other way.
That's twice now.
Every time they make those, oh, she got the glass from inside the Alberts. Maybe in the basement. Look the other way. Don't look the other way. Look at the facts. Look at the data.
Okay, that's ripped directly from the defense closing last time. The defense closing last time, they said look the other way a lot. They said the prosecution wants you to look the other way. Wow. That's interesting.
And it all leads to one person. There's no grand conspiracy. It leads to one person, the defendant. And it's not just the data and facts. It's her herself.
Back to
Let's
her
talk
words.
about Mr. Proctor. You were
4 times.
Invoked
3 times.
This emotion early in the opening that this is a cancer. That's a tough word. Try to evoke that primal reaction, disgust. I'm not saying you shouldn't be disgusted by the text messages. You should. They're not defensible. I don't stand here and defend impropriety. I don't. But that doesn't change the physical evidence, the scientific evidence, and the data. He was terminated. He paid a penalty. He was held responsible for what he did. He should have been. He should have been. But that doesn't get a free pass. That doesn't change the facts. It doesn't change the physical evidence. It doesn't change the science. It's unfortunate. It's distasteful. It's dishonorable. Remember, Trooper McKennick was asked, was the investigation with honor and integrity? And he said it was. Was Trooper Proctor's effort honor and integrity? And he said it was integrity. But he never said honor. That's a man of honor. Military service, dedicated to his country, highest level of clearances, to the President of the United States, now a state trooper. He would not say that Trooper Proctor was honorable. Because he wasn't. He wasn't. But that does not change. It doesn't create a conspiracy. It doesn't invent a dog. It doesn't make somebody in a house something they're not. It just doesn't. When you read those text messages, they're hard to look at. It's unfair. It's unfair. And if there's a penalty more than being fired, well, maybe that penalty would be deserved. But it has nothing to do with the justice in this case. It just doesn't. There's not one piece of evidence, not one, that we can look at and say, this was tampered with. This was planted. This was distorted. Remember when we introduced the taillights at the beginning? I didn't introduce 3 of the taillights, but then the defense did, so I put them in. Those were taillights that were only found by Trooper Proctor. I did not put that evidence in. understanding those text messages and
Interesting.
appreciating the disdain one might have for his comments. Not that there was any evidence of tampering, not that there was any evidence that it was not true, but I didn't put that evidence before you because we didn't need Trooper Proctor in this case. We don't need Trooper Proctor to prove this case beyond a reasonable doubt. That's why I didn't introduce that evidence to you.
I think he's now said
Now,
Trooper
there's
Proctor
been a
more
lot
than
of
he said
talk
soccer mom.
about planting of taillight.
Wow.
We know the taillight wasn't planted because Trooper Buchanan and Mr. Proctor did not go down to Dighton to see Miss Reed until later in the afternoon. We know from the 507 video, we've seen that. We know the taillight was already missing when she's leaving the driveway. When the good Canton police detectives went to do a wellness check to care for those young children, and they went to the house inadvertently, they didn't even know it, the dash cam captured the back of the car. The taillight packed with snow is missing. It's already gone. It can't be planted. At this point, Trooper Proctor's still in his pajamas. He's not even on the case. He's not even on the scene. He hasn't been near the car. And then the Dighton videos themselves, when you close it, you can take it at an angle and it moves, but if you get the right angle, you can see it's missing. It's gone. Can we have slide 18, please?
Is that the video?
507. You can play any angle you want, but if you look at this angle, it's gone. You don't plant. It's already gone. You know where it is? 34 Fairview Road, on the Refield. January 29, 2022, 823. Look at the right-hand side. Look at the left-hand side. It's packed with snow. It's gone. It's gone. And the same thing when you do the videos, it's a different angle, a little smaller, but if you play that and watch the lenses go up and down and slow it down, you'll see it expands. It's gone. So when you have Dighton Officer Barrows come in here and try to tell you what he saw in the salad bar, couldn't have been it. You got to ask yourself, what interest does he have coming in here in this case? A lot of attention on this case, a lot of people watching. Comes in
What?
after, of course, driving all the way out to the defense attorney's hotel to meet in a conference room
Sir,
so he can get a subpoena.
that's not a serve.
He spends 2 hours driving up and back so that he can conveniently get a subpoena that tells him to appear, which he could have got by fax or in the mail. And so when he comes in, what he says is, that's absolutely not what I saw. Absolutely not. And then he claims at the last time he testified, he had made the same statement. I showed him his transcript. And did you see the redness creep over his face? He never said this before. In fact, he testified to the opposite. And so he sits on the stand with a new story after a meeting. We don't know why. But then I show him that bottom right photo.
A news
with the
story
snow,
after a
with
meeting.
it missing. And I say, is this the way it looked? It's, of course, before the snow melts out in the salad port so that you can see it unexposed. And he says, yes, he had to agree. This taillight was gone. There's no boogeyman. There's no plant. There's no Higgins at the salad port. There's no one tearing out pieces. In fact, remember I played you a clip and you'll have it where the defendant says, I was picking out pieces, it was crashed in, the bulb was showing, when I was showing Kerry and Jen, when they went back to Meadows. If you don't remember, listen to that clip, you'll hear it. Unfortunately, there's no ring video when they go back to Meadows. There's a ring video when she leaves, there's no ring video when she gets back. And so, now when we're trying to look the other way, we want to find a dog bite. So enter Dr. Russell. Dr. Russell, according to her, nice woman, nice doctor, very accomplished. I respect that. She's the only dog expert in the world. The thing is, we know no idea what that expertise means. She volunteers for the job. She wants to be here.
That's not what she said.
But she can't explain methodology. What are you looking for in a dog bite? She can't tell us. It starts a year ago that it's claws, it's teeth, and then it's claws, then it's teeth, then it's I don't know. And then when you look at each of the different parts of the abrasions, she says, well, I can't tell if I look at each one of them, but all together it's a dog bite. It's a dog attack.
She explained that pretty well.
That is the masterful expertise that the defense has bragged about bringing in. Dr. Russell telling you, because she says this is a dog bite. She has never been in a forensic situation where she's looked at a wound and identified it as a dog bite before. This is the first time, the only time she's ever done it. And what she says is these are
Never been in a forensic situation. Oh, okay. Because the ER is a treatment situation? Interesting.
Not punctures. Punctures means it goes into the skin, a wound. There's no punctures. And she's sure because she's an expert, so you should rely on her because she's coming in saying she's an expert and she's being presented. Yet, after saying there's no punctures, Dr. Laposada comes in and she sees punctures everywhere. It's an animal attack. It's a dog. How is it? No method, no methodology, no history of this, no prior testimony that we know of other than arbitrarily what she says. And she says the exact opposite of Dr. Russell. Why is that? How does that happen? So obviously there is no science to looking at an abrasion.
Dr. Scortibello also said there were no punctures.
No detail. They give us nothing that we should rely on. They contradict each other. It's just to get you to look the other way. And so we have now the issue of the defense has said over and over again, there's no collision. There's no collision. There's no collision. And they had a number of witnesses come in to try to say that. And they point to Dr. Scortibello, who works at the medical examiner's office. She tells you that she doesn't see injuries consistent with a collision. She's looking at this case for 90 days. 90 days. The evidence in this case did not stop. It continued for 2 years. She knows nothing about the data, nothing about the black box, nothing about the interviews of Miss Reed.
The data on the car doesn't change what happened to the human, though.
She doesn't know about the DNA. She doesn't know about the shards in the arm or in the clothes. Strike that, in the clothes. She knows nothing about that. So in 90 days, she didn't see any lower body injuries. She didn't see any lower extremity injuries, which are very common in car collisions.
Looked.
But that doesn't mean it didn't happen
She
because she in 90
resected.
days saw a fraction of the information. A fraction. And we know now, argument back and forth for days about lower body injuries, the suggestion is a car accident can affect everybody differently depending on the angle, the scope, the speed. Some
Going
people
after
can get plowed over by
Scortibello
a
is
car and have no
not
injuries.
the,
Some people can get touched lightly and have more injuries. And there was the debate about no lower body injuries. Well, ARCCA dispelled that in their dummy test, that you can have a collision with no lower body injuries. They did that for us. Thank you. And so the idea that at the time in 90 days that she doesn't have enough information to say consistent with a car accident doesn't mean there was no car accident.
In those tests, though, ARCCA also talked about the extensive injuries it would have been, and the foot was run over. The foot was completely run over.
Let me talk a little bit about ARCCA. I don't want to waste too much time with them.
Okay.
What expert who's supposed to come to you, they're not the arbiter of truth. Their opinions weigh no more than yours. Your common sense has more value than an expert's opinion. Their job is to assist you, to explain what their expertise is so that it's a tool for you so that you can make a decision. That's objectivity. We've heard words like confirmation bias, objectivity. Mr. Wolf got on the stand, and before we even started, you have to ask yourself, what expert has a court order for text messages and then deletes the text messages? What expert?
That's
what objective expert?
I think that's objectionable because that's not what's in evidence. He said he deleted them before he ever got that order and couldn't turn them over because they were already gone. There is no evidence on the record that he got the order and then deleted them afterwards. And the only reason the prosecution can make this argument, and for everyone who's watching the first trial only, I apologize for everyone who watched both trials, Brian Albert and Brian Higgins both got court orders the day after their phones were destroyed. It was gone before the court order. Dr. Wolf's was gone before the court order, but they can argue it because that evidence isn't in. But I do think it misstates the evidence because the order came in after the texts were gone. And I think that misstates the testimony. The defense didn't object. Yes, they can object during closing. They didn't. if the jury clocks it, the jury will clock it, because the defense spent some time saying, what is the Commonwealth showing you? But that's what he said. The ARCCA got a court order, then deleted it, and that's not what's in evidence.
Uses signal, an encrypted app, to communicate about the case. Never used it before, hasn't used it since. And so when he did his tests, he used a lower weight arm. Wasn't trying to bash him, wasn't trying to insult him, tried to get him just to recognize that a 9.38 pound arm
He's like, you better
is
recognize.
less weight than John O'Keefe's metric, which would be 11.8. That's all, and because it's a lighter arm, it takes more speed to create the same damage. I don't know science, I don't know math very well, but that's basic. It's basic. And he fought me over and over again. Did he seem objective that he was trying to help you? Because Dr. Retrial came in the next day and said, well, you have to adjust for that. That's all I asked him for an hour about adjusting, just like Judge Welcher adjusted. Do you adjust it? And he tried to talk to me like I was making something up. His own colleague had to admit it. Now, it's funny, he admitted it before he got through his credentials. No sequestration order violations. Nobody was coaching him, but he knew enough to come in at the beginning and get right on that point.
Well, sir.
Remember Dr. Russell on her limo ride over? If Brendan asks you a question, make sure you ask for a transcript.
That's not what she said.
Impede the progress. Slow down the questioning. Interfere. Sequestration orders, so there's fundamental fairness for all witnesses, not just some. And so what happens with Dr. Retrial, we don't know, but we do know he comes in here and he tells you that he was not getting information that was helping him the last time he testified. He insisted. I asked him 5 times, was he getting information that would help him in his testimony? Not from the defense, from his former employer. He said, no, no, no. And at the end of the examination, he reads his transcript and it's yes, yes, yes. And he tells us that he's independent and objective. I asked him.
Are you done talking about Dr. Wolf? Because you didn't talk about showing him the hoodie.
About a luncheon, not a big deal. Just asking him about it.
Okay.
And he says, I have a sandwich and I stand in the corner until I remind him.
The ham
we got
sandwich.
Video footage from a documentarian, and he's in one of the scenes. And then things change. So when you talk about objectivity and who to trust, they can come in and say, Judge Welcher said this and that. It doesn't make it so. Judge Welcher, Dr. Welcher, never in any report, in any presentation, in any testimony to you, ever suggested this is how it happened. This was how his arm was. This is how his feet was. He was trying to show.
He said that x-rays were never taken, though.
Whether or not the orientation. Could this happen with the angle, with the height? That's all that test was. It was no more. But what they do is they reposture it, repackage it, and say it means this when it doesn't, and we're going to show you why it's not that, therefore we win. That's all that is. It's semantics. Judge Welcher, Dr. Welcher, never suggested that. And his work on text stream data, unassailable. And so what we have, inevitably, is we have a timeline that never moves, data that never changes, physical evidence that can't be put in that spot without a collision. We have, inevitably, proof, without any doubt, that on January 29, 2022, Ms. Reed was with Mr. O'Keefe, and she got drunk. She drank. She was 2 to 3 times over the legal limit. And they went to a party, an after party, and they were fighting. It was a relationship in decline, and he got out of the car, and he had a brief window of life left. And when he got out, and she drove away, she couldn't let it go. She got drunk, she hit him, she left him to die. It's that simple. We don't know exactly how this collision happened, but we have a good idea from the physical evidence. And we know that it happened. Can someone have a collision without lower body injuries? Could I have slide 19, please? You bet they can. We don't know
He's
if this is a
using
body
the
condition. We don't know if
ARCCA
this is
29 mile
exact
per hour
speed, but it tells
test
us
with Randy
this is viable.
and Randy's
Look
foot.
at the debris field. Look at his turn. Remember his sneaker on that curb that got lodged against the sneaker? Mr. O'Keefe then falls back.
Randy's whole
hits his
foot
head,
gets run
counter
over.
coup, left to die.
The prosecution's point there is, remember, John O'Keefe wouldn't have been harnessed. He would have been moving backwards before that. That's what he is arguing.
Thank you.
Oh, you're done. I'm surprised he didn't argue and leave them with Karen Reed's words last. He's leaving them with the 29-mile-per-hour test last. I'm going to play that one more time.
We don't know if this is the exact speed, but what it tells us, this is viable. Look at the debris field. Look at his turn. Remember his sneaker on that curb that got lodged against the sneaker? Mr. O'Keefe then falls back, hits his head, counter coup, left to die. Thank you.
Wow. That's the end of his
Ladies and
closing.
gentlemen, there is
Oh.
no doubt what happened that night.
I thought that was the end. He was like, thank you. He must have been saying thank you to the tech. I thought he was done. All right. Not done. Just kidding.
Ladies and gentlemen, there
I
is
made a
no
mistake.
doubt what happened that night. There is no doubt who did it. You have a very difficult task ahead of you when you consider the evidence and you consider the law. Very difficult. There are 3 charges. There is second-degree murder. Ms. Reed, when she chose to drive back at Mr. O'Keefe in that night with a 6,000-pound Lexus, in that anger, 75%, whether she meant to hit him or not, didn't mean to kill him, she hit him.
Oh, fair. Chat pointed out that the video was not the 29-mile-an-hour test because that's the one where the whole back gets wrecked. It's the 24-mile-an-hour test. Thank you, chat. Appreciate it. The 24-mile-an-hour test is the one they showed.
It is a plain and strong likelihood of death. You would never back down your driveway if your kids were at the end of the driveway. You'd say, what, are you going to kill somebody? You would never do it because you would expect, if you drove at them at that speed, that someone would die. That's second-degree murder. DUI manslaughter, she's drunk, she was reckless. She doesn't even have to know she hit him. She doesn't even have to know she hit him. But she did. She did. And she left a man who was kind and generous and thoughtful. She left him alone. She left him alone to die. Could I have slide 22, please?
Oh, he's got to end with her words, right?
He is not an it.
Oh,
John
no, with a photo of John O'Keefe. I thought they were going to go to more video of her.
O'Keefe is not a body. John O'Keefe is not a buffalo on a prairie. John O'Keefe was
Those
a
are
person.
her words.
And he was murdered by Karen Reed.
Take that, thank you. All right, Juror.
Wait, that's what he ends with? He doesn't say, so ladies and gentlemen, I'm going to ask you to find her guilty. No. Thank you for your time in this case. No. Doesn't thank the jury once. No. Doesn't end with Karen Reed's words. No. I kept thinking he was done. And then when he was actually done, I was like, wait, what? I'm going to back that up one more sec because the judge is going to send the jury to lunch.
A buffalo on a prairie. John O'Keefe was a person. And he was murdered by Karen Reed.
No, we're going to ask you to find her guilty on charges 1, 2, and 3. Thank you for your time and deliberation. Nothing. That's an interesting. Okay.
Take that, thank you. All right, jurors, the next up is my instructions to you.
And they're
on the
long.
law. I'm not going to do that right now. You've been sitting for a long time.
They're very
So
long.
I do have to tell you, even though you've just heard the closing argument,
You cannot discuss the
this
case.
even with each other. All right, so we'll send you back for lunch. It's going to be a shorter lunch. My instructions are long, and we want you to be able to get this case to start deliberations today. So I'm going to send you back maybe about a half an hour. Is that enough time for you folks? All right.
I'm sure they're all
we'll give you
nodding.
a half an hour for lunch, and then we'll come back. I'll give you my instructions on the law, and then the jurors will go out to deliberate. I know there are 18 of you. We seat only 12 deliberating jurors.
Oh, boy.
6 of you are going to involved. I can just tell you that you know the odds, right? And I can tell you it's Mr. McDermott's least favorite part of his job is smoking. So we'll do that this afternoon. Do not discuss this case to see the water.
All right, the court is going out for lunch. The court has told the jurors that 6 of them will be alternates. Hold on, let me zoom. They are still at lunch. I'm going to wrap what we saw. I'm going to take a quick break to grab more water, food, go to the bathroom, and then we're in for jury instructions. The Commonwealth just finished their closing argument. I'm very surprised at how they ended their closing argument. I thought that they would end with Karen Reed's words from her. They didn't. They ended with a photo of John O'Keefe and then quoting and paraphrasing some of Karen Reed's words. But what surprised me is that in most cases, you will see the prosecution at the end say, and we are asking you to find the defendant guilty of count 1, 2, and 3, or whatever the counts or charges are. We thank you for your time, your consideration, your diligence in this. I know it's been a long trial. He did not thank the jury once, which actually surprised me. There were points of Brennan's closing that felt like he was arguing from the perspective of the defense. It's the job of the prosecution to close all the loops. And as he showed the ARCCA video, the 24-mile-an-hour test, because Chad is Bay and reminded me that's not the 29-mile-an-hour one because that's the one where everything got wrecked. The 24-mile-an-hour test, he said, this shows you that it's viable. The standard in Massachusetts is proof beyond a reasonable doubt and to a moral certainty. There were points that he made for his closing that were good points. The points about John O'Keefe's cell phone, the points about the data. But one of my criticisms of Hank Brennan is there's times where his really good points get lost in the other stuff. And we will see if his good points get lost in the other stuff. Because I think he said Jen McCabe was a soccer mom 4 or 5 times. He did talk about Trooper Proctor more than I thought he would. But he essentially called Trooper Proctor a distraction and said, well, Trooper Buchanan came in here and told you this investigation was not compromised, that this investigation had integrity. He didn't say Trooper Proctor was honorable, but he said that this investigation had integrity. And Brennan argued, look, I didn't put in the parts of the taillight that Trooper Proctor found. I didn't. I know what the texts are. I didn't. I'm not defending those texts. They're not defensible. The defense put those in. Yes, he absolutely argued that in his closing. But he talked about John O'Keefe's cell phone, when it stopped moving, the location data showing that John O'Keefe's cell phone did not move. He called it the healthcare data 1,000,000 times over and said that the healthcare data shows when John O'Keefe's phone stopped moving. And he argued that the battery temperature went down commensurate with being outside and then slowed down commensurate with being underneath John O'Keefe and then went down again more rapidly when John O'Keefe was taken by EMS. I thought those were helpful points. He talked about the debris field being the same as you saw on the ARCCA crash tests. But he also said that the ARCCA crash tests proved that it happened the way he said it did. He said, thank you for that. But earlier he said, the reason Dr. Welcher didn't do crash tests is because there's not enough information to do those tests. He argued that the testing by Dr. Welcher didn't say that's exactly where John O'Keefe was. It was almost like he was arguing that the Welcher testing was to show that it was possible, but not to show what happened. And I think that's where, for Brennan, the facts are difficult to argue. I also said it in the middle of his closing. The defense, I think it was in the first trial, talked about the prosecution wanting you to look the other way. And Brennan took that into his closing this trial and said, The defense wants you to look the other way. It's a dog, it's this, it's this. There's no evidence of that. At one point, he said they don't have evidence of that, which I think is objectionable. I don't know if he said it more than once, but he kept saying there's no evidence of that, but insinuating there's no evidence of that towards the defense points. The defense doesn't have to bring evidence of anything. The defense can just poke holes. Here. He didn't address Joan O'Keefe's hoodie, but there were times in the prosecution's closing where it seemed like he was writing his closing towards the way the defense argued the case in the first trial. He kept saying there's no conspiracy here. He called Jen McCabe a soccer mom maybe 4 or 5 times. There's no grand conspiracy. He said it over and over. The defense didn't argue a conspiracy this trial. The defense said, look at all these things that law enforcement didn't look at, which we've been talking about together for 8 weeks was going to be their closing. They've said it in court and in their motions. They said they were going with a Bowden defense, and that the Bowden defense was, look at what law enforcement didn't look at. It's spelled out. Look at what law enforcement didn't look at. Look at this behavior. They didn't investigate it. Look at this behavior. They didn't investigate it. There were points of Brennan's closing where he made very strong points about the phone. The problem for me with Brennan's closing is that he didn't close all the loops. This is viable. This isn't a conspiracy. He leaned in very heavily to Karen Reed's words, and we knew he was going to do that. She said it. He took his points and then highlighted it with Karen Reed's words. This is what she said. This is what she said. This is what she said. And he took the time to explain count 1, 2, and 3. He took the time to explain the actions that he thought were wanton and reckless for count 2, something that was never explained in the first trial at all, and something the defense did not spend time on. The defense spent time on, we're not even going to explain this to you because there's no collision, therefore there cannot be a guilty verdict. The prosecution leaned into, listen to what Karen Reed said. Listen to how she talks about John O'Keefe. She's backing up the car. That is the wanton and reckless behavior. That is the volitional behavior. And he leaned into the text stream data and pointed out that the defense experts did not come for the text stream data. They came for Welcher's paint test. Did the defense poke enough holes? Did the prosecution close the loop? The reason the prosecution goes last is because they have the burden. But I feel that Brennan didn't shift his closing to address some of the points that the defense made and the tenor of the argument from the defense focusing on the investigation. He kept arguing against a conspiracy that the defense didn't argue. They've talked about it outside of court. They talked about it a lot last trial. They went to points of it. The defense barely talked about Jen McCabe. And they talked about it in the context of what investigators didn't look for. And Brennan, I don't know if he did enough to circle it back around and say, investigators didn't need to look more. Investigators didn't need to look more because the evidence is so clear. He did not argue that. He did not argue about the investigation other than to say, Proctor's a distraction, look the other way. It's all a big conspiracy. Interesting strategy from Brennan. But it was also interesting that he said the defense was leaning into emotion in their closing, which both sides did. Closings should be a bit emotional. The defense leaned into emotion in their closing. He started with emotion in his closing, and most of his closing was about emotion. And I think the jury's going to sit there and being like, wait a sec, what? Who's talking about emotions? Because the whole time, when we get to jury instructions, get snacks. Get snacks. When we get to jury instructions, the thing I want to hear the most are the instructions on the charges and what lesser included are included in count 2. And I'm going to highlight those for you if you're watching along with me. I'm going to pause and I'm going to point out the elements that the jury has to find. And then when we're done with instructions, the jury's going to go back to deliberate and we're going to answer questions. The jury is still at lunch. I am going to take a few minutes. I will put up a poll when we get back from lunch. I am surprised he mentioned Proctor as much as he did. I'm more surprised that he called Jen McCabe a soccer mom as much as he did. Like, that was a lot. That was a whole lot. So I'm going to put up our video. I'm going to tell the jury should be back in like 5-10 minutes. I'm going to get water. I'm going to get a little more food. Y'all go hydrate. If you have the Law & Order app, you're set. If you do not have the Law & Order app, that is how I am going to tell you when we are going live, when we hear anything that the jury's doing. Jury has a question and they're coming into court, we'll talk about it. Jury has a verdict, we'll talk about it. I'm going to be interested to see what time the jury gets this case today, because it really depends on how they feel. They could want to look at all this evidence. They could want the weekend to think about it, or they could be done. Anything is possible with a jury. I would not expect a quick verdict. I'm not telling you it's not possible. It's not my expectation. But I have been surprised by jurors before. Sometimes when they're done, they're just done. They're like, we've heard it. We've heard it. The app is free on iOS and Android. Make sure you grab it. Megalina, will you grab me the lunch break? Thank you. You're the best. Megalina's like, I'm reading your mind, girl. I will be back. Let's see. It's 12:24. I will be back by, and that's Central. I will be back in 10 minutes by 12:35. If court's not back, we'll be back. One question was, Emily, have you ever seen a quick verdict? I had a jury that buzzed with a verdict before I had even left the courtroom to go to the bathroom after my closing. And I was a little like, we haven't even sent the evidence back yet. Like, the jury went back and buzzed and said, can we get the verdict forms? Because the clerk hadn't even sent the verdict forms back yet. They sent back the verdict forms and like 3 minutes later, they buzzed again with a verdict. I'm like, I haven't even gone to pee. So yes, I have. But it was not an 8-week trial. It was not this fast. It was not this quick. But the Murdaugh jury came back. This was an 8-week trial. Here's what I will say with jury verdicts. Do not read into how much or how little time they're taking on a trial this long. Remember, all the moments in court that we've been like, girl, what? All of those moments in court, they haven't gotten to talk about. They haven't been able to talk to anyone about the facts of this case, the lawyers, the parties, the clips, the moments. They haven't been able to talk to anyone about this case for 8 weeks. They might want to read Trooper Proctor's text. They might want to rewatch the clips of Karen Reed. They might just want some time to talk to each other. It was a long trial. So it really depends on this jury. They might want to take an initial poll and get out, but they also might want to talk. So don't read anything into them not coming back today or Monday. They might need time to talk. Imagine if you had sat there for 8 weeks and you couldn't be like, oh my God, now there's x-rays. Imagine what you would want. 8 weeks and they cannot talk about the case at all. Do you think they want to talk about the lawyers a little bit? You think they want to talk about the witnesses? You think they want to talk about Jen McCabe? Right. They're going to want a little time to talk. So I wouldn't put too much stock in it, but the court did say she was going to let them deliberate till 5 or 5:30. They will not deliberate over the weekend. They will not render a verdict over the weekend. They will get this case after the judge is done with their charging. And that'll take about an hour, hour and a half, depending on how fast the judge reads. I'm going to grab food and water. I want you to grab food and water. We will be back. The court's going to read the jury instructions. Y'all are going to ask me, Emily, can we zoom? No. The jury instructions are incredibly important. Incredibly important. So we're going to listen to them. Don't worry, I'll let you know when we need to highlight something. We'll pause and highlight those. There are going to be some standard instructions. Listen to how the judge tells them to evaluate witness testimony, evaluate experts, what reasonable doubt is. But the thing I want to hear is the charges. I want to hear the judge go through the second-degree murder, the manslaughter lesser included, and what those are, because we don't know yet, and the hit and run. That's what I'm really interested to hear. So we're going to hear how those come in. Oh, and then that pesky little instruction about do not render a verdict till you've reached verdicts on all counts. That one. Yeah, we're going to talk about that one too. Go get your food. Go get something to drink. Get the Law & Order app. We will be back 10 minutes. Well, less now. If they're not back, I'll let you know in the chat. I'll come back when they're back, if not a little bit before, and then answer questions. So let us switch to our lovely lunchtime hold music, because A, I love it, and B, I love it, and C, it reminds you to get the app, and I like the music. Emily, that music was loud. I know, but we needed a little bit of music. All right, Law Nerds, I will see you in just a few. Get the app, do the things. I'll see you in just a minute. That was me messing with things. I'll be right back. Hey Lawnard, court is still on break, but don't forget to download the Lawnard app so you know exactly when we're back from break, and you can get a notification from us when witnesses take the stand that you've been waiting for, when something unexpected happens in court, and during verdict watch. The Lawnard app has all of your live court notifications to keep you in the loop. LawnardApp.com, free for iOS and Android. And while we're on break, don't forget to hydrate, get up and stretch, and take care of yourself. Trial days are long days. All right, Lawnards, are you ready? We went fast for lunch. I know, we sent out an app notification. Everybody will get it in just a moment. We went quick because I grabbed stuff and Dr. B texted and was like, I can grab Starbucks. I'm like, yes, we're gonna need it today. Court took a very short lunch because the judge wants the jury to get to deliberations today, and they're going to extend the court day to make sure that they have time to do that. So we're going to listen to the jury instructions. Yes, they can be long and sloggy. Yes, it's probably the most the judge will talk the entire trial because it's a lot of talky, but they are important. So I saw Tammy said this chat goes so fast. We're on slow mode. But yes, we want the Lawnard to be able to have a conversation, but it does move. It does move it. It does. And the mods do an incredible job of making sure when people come in to troll that they are gone immediately. And I appreciate it. So are you ready, chat? We're ready. It's time.
Bring the jury.
Let's bring the jury. Let's get to the jury instructions, shall we? I'm ready to. Court is now in order.
So who wanted to see me? I'll see you at Sidebar for just a minute.
You're going to Sidebar? Fuck. All right. Is there a question about the jury instructions? Is there a question about the instructions? We have the scantest of Zoom room.
Some space here, please.
Wait, what did the court say? Did she just say, can we have some space here, please? What is happening?
No, Chris, yes. Yes, I'm sorry. Some space here, please.
Well, the jury's not in. What is happening?
Hold 1 second.
Auburn, I hope I said that right. Said, Emily, will the jury get a printed out version of the jury instructions or do they have to go by memory? They should get printed copies. Some courts do one copy for the jury. Some courts do one for each. What's everybody looking at? Everybody's looking at something. Is everybody on devices? Everyone's on devices. Everyone's on devices. So sometimes they go one per juror, sometimes for the whole jury room. I would prefer to have one per juror and let them make notes on it. But jury instructions take about an hour. The court is on the bench. The jury is not in. The jury's now coming in.
Jim, now you're going to have to go through all of those to
You okay with that?
Oh, okay. Okay.
Something happened. I'm not going to speculate. I will take a look and we will see afterwards if we can find, but something happened because they were asking the court if the court was okay. But I don't know. That might be something in court. I would caution that that can just as likely be something personal. So my only caution would be to not speculate. I have seen judges get notifications that they've had family members pass, people in car accidents, people injured, have gotten sick. It can be many things. So with that, I don't know, but something's happened. We don't know. We will take a look. They're proceeding with court. And it looks like the jury is coming in. So we can back that up, but life also happens. So I just caution that things happening in court might not always have to do with court. That's all. So.
Jim, now you're going to have to go through all of those to pick the alternate out?
You okay with that?
Oh, okay. Okay.
So they're going to go through the alternates. I'm going to zoom to the jury is back, but it sounded like Brennan said, "Are you okay up there?" And she said, "I'm okay." It could just be hot. One never knows, but they were all on their phones. I am sure we will find out at some point.
Jurors, going to give you the instructions now in the law. But first, I want to thank you for serving on this jury and for being so attentive. You'll soon deliberate for the purpose.
There is one question in the chat that asked, and I think this is an important question. I thought the ARCCA videos weren't allowed. The ARCCA videos all were allowed in, just not the PowerPoint about them. All the ARCCA videos came in separate. All right. We will answer questions as we get to the end of this.
Of reaching a verdict, but before you do that,
The judge is going to
it's
tell
my
them
responsibility to give you the instructions concerning the law. These instructions are divided into 3 parts. The first part, general instructions that are provided in every criminal case. The second part, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give any special attention to any other instruction. To make sure that I give you the...
I like that these are done in 3 parts. It helps the jury pay attention. It's going to take about an hour to go through the instructions.
Instructions accurately. I will read them to you. You'll also get a written copy so that you may refer to it in the jury room during deliberations.
I think all courts should give jurors a written copy while they are listening to the instructions. But
I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud. You must take the law as I give it to you.
How
You
do they
may
know the
not
difference if they
quarrel
don't
with
have
it. You can't do that
You can't
regardless of
quarrel
any
with the law.
opinion you may have as to what you think the law ought to be. Lawyers or witnesses may suggest something about the law. That's not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you what the law is. I'll now turn to part 1 of these instructions, which are general instructions that apply to all criminal cases. As I've explained to you at the beginning of the trial, there is a fundamental rule that applies to all criminal cases.
All right. Well, I said I wasn't going to zoom until we get to the instructions on the crime. I'm going to put the court at 1.25 until we catch up. We'll be at real time in like 2 minutes. But when we get to the charges, I'm going to slow it back down.
Including this case. Every
We can
person who is
listen
accused
fast.
of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at this trial that Ms. Reed committed the crimes charged. I'll explain what I mean by reasonable doubt in a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. She does not have to testify, call, or question witnesses, or provide any evidence at all, because you must presume she is innocent.
Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. Now, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable...
All right, because the doubt instruction is so important, I'm going to put her at normal speed for that one. We'll go back up to 1.25 when we get to some of the background instructions.
Doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. How do you decide whether the Commonwealth has proven that each element of an indictment is true beyond a reasonable doubt? Let's talk about the roles we all have. First, the function of the jury. You are the most important people in this room. It all begins and ends with your function. You will determine the facts in this case, and that is your job and yours alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must decide the facts solely and entirely on the evidence as you have seen, heard in this courtroom, and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion, sympathy, passion, or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I'm giving it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed has been charged or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done. Your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in the case. However, I have no opinion about how you should decide this case. You should not consider anything I have said or done during this trial as reflecting any opinion by me about how you should decide this case. If you believe I have an opinion about the facts of this case, you must disregard it.
She's like, believe me, I
don't.
You
must decide this case based solely on your evaluation of the evidence. The arguments of the lawyers are not evidence. They are not witnesses. If a lawyer during argument made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court procedure and are not part of the evidence. So don't hold it against the lawyers or their client If they made objections, motions, or other requests, they're simply doing their job during the trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. The verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show
evaluate the witnesses
and the
and the
importance to
evidence.
give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits that were introduced in this trial. You will have those exhibits with you in the deliberation room. In addition, as you heard during the trial, the prosecution and defendant agreed that certain things are true. Therefore, you must accept those things as true.
Those are the stipulations. You must
There are
accept
some
them as
things you
true.
have heard about that have not been introduced into evidence.
There are some things you've heard about that are not in evidence. Gee, what are those things? But the stipulations like Trooper Proctor was not in that picture at the autopsy, etc.
Such as previous testimony of witnesses, police reports, autopsy and accident reconstruction reports, and perhaps other reports. You may naturally wonder why neither side has introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may
show
or may not contain. Similarly, as you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed
So the
from
redacted
them.
exhibits.
Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements and any comments they made, are not evidence. If the lawyers or I made any comments during the trial, those comments are not evidence and you must base your verdict only upon the evidence. In an interaction between a lawyer and a witness, you may consider only the witness's testimony as evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witness, that is, their answers to the questions and the exhibits are evidence. Finally, on this topic, if one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in the courtroom.
Right.
But your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law. I have allowed you folks to take notes during the trial if you chose, and you may refer to those notes.
You got to take notes
during your deliberations.
Yay.
But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with the other jurors. Please consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Keep an open mind until then. For each indictment, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of that specific charge. Your decision as to each charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip for each indictment. When all 12 jurors agree on the verdict for a particular indictment, the foreperson should check off that verdict and then...
Did you catch the difference? When all 12 jurors have reached a verdict on a particular indictment, not all, A, that's a modification from last time. And I know the jury conference looked at this one, but that is a very helpful clarification from the way it was worded last time. And we went through the way it was worded last trial so many times. Separate indictments and a verdict on that indictment. It's just so much clearer. I backed it up a little because I interrupted it, but it is much clearer.
Decision as to each charge must be unanimous.
The decision as to each charge. So this is each charge and how to decide each charge.
Each indictment,
Way
you must
better.
decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of that specific charge. Your decision as to each charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip for each indictment. When all 12 jurors agree on the verdict for a particular indictment, the foreperson should check off that verdict and then sign and date the slip in ink.
Much
For
better.
each charge, if you all agree that the Commonwealth has proved every element of the charge beyond a reasonable doubt, then you should find Ms. Reed guilty of that charge. On the other hand, if you all agree that the Commonwealth did not prove one or more elements of a particular charge beyond a reasonable doubt, then your verdict must be not guilty on that charge. You'll remember that we took a view in this case. It seems like a very long time ago, but we took a view in this case.
That's true.
The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable or convincing any part of the evidence is. You should evaluate the testimony of a police officer in the same way you would evaluate anyone else's testimony. You must not automatically believe or disbelieve a witness just because the person is a police officer. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation. You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness? What relationship did they have to the case, to the other witnesses or parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the witnesses and the assessment of the evidence presented. Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate and reliable, or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and reliability, and only for this purpose.
Reading out loud
Also, if there has been a suggestion that a witness recently contrived their testimony, you may take into account any earlier statement the witness made which was consistent with their present testimony. The prior statement is relevant only as to the witness's credibility and reliability, and only for this purpose. You have heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted test or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involved factual determinations that are entirely up to you. And you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. During the trial, I gave you some instructions on how you were to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I'm going to summarize those limiting instructions here. Ms. Reed is not charged with committing any crime other than the charges contained in the indictments. You've heard evidence about interactions that Ms. Reed may have had with Mr. O'Keefe in Aruba and others in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive
that they've gone through
on January 29, 2022. You may not consider the evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must have committed the offenses with which she is charged here.
Right. They're not allowed to be used.
You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and the nature of her relationship with John O'Keefe. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored the electronic communications were in fact John O'Keefe, Ms. Reed, Michael Proctor, Brian Higgins, or others alleged to have authored or created them.
In this case.
If you do not find it is more likely true than not that the persons alleged to have authored or transmitted or created the communications were the persons alleged to have done so, then you may not consider the electronic communication in deciding the case.
The reason the court says offenses is because there's 3 charges here.
Photographs have been entered into evidence, and in some instances, those photographs will be inside an envelope when they go back to you to the deliberation room.
A lot of you have asked about Aruba. John's niece talked about it and what happened when they came home. So it was in evidence through John's niece, which is testimony that wasn't televised.
Photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You heard evidence of statements made by John O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind. You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that Ms. Reed was aware of Mr. O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you can reasonably infer from the evidence that she did learn of it. Now, you have heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose it may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all of the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances.
That goes mostly to the police.
Some testimony came from witnesses who
interview
saw
with
or
her.
heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience.
Those are the
But
experts.
special training or experience does not necessarily make the witness's testimony any more believable or important than any other evidence. So you should consider the same questions about witnesses' testimony that I mentioned earlier, including any bias or motive these opinioned witnesses may have had to testify in a
Those are
certain
the
way.
expert witnesses.
You may also consider the witness's level of experience and training and whether they base their opinions on the facts that you find to be true. There were hypothetical questions asked of some of the witnesses. You may give whatever weight you deem appropriate to the opinion based on the hypothetical, but only if, after careful consideration, you find that all the facts in the hypothetical were true. Remember that witnesses, even those with special training or experience, do not decide cases. Juries do.
Right.
It is up to you whether to accept or reject, in whole or in part, any opinion or conclusion that a witness offered during the trial. You have the same powers with respect to the exhibits that you do with respect to the witnesses. Look them over and decide the weight, that is the value, that they deserve to receive in helping you resolve the case as you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You do not have to believe something simply because it's written on a piece of paper or appears in a photograph. You are not, of course, required to disbelieve it because it appears there. You decide whether to believe what an exhibit purports to show and how much weight, if any, to give the exhibit.
They get to decide.
Certain charts and summaries not admitted into evidence have been shown to you as testimonial aids intended to summarize, clarify, simplify evidence, or to help explain the contents of records, documents, computer data, or other evidence introduced in the case. Charts and summaries are not new evidence, and you should give them only such weight as you think the underlying evidence deserves. So you've heard me talk about sources of evidence in this case. Those are the tools that you
gotten to
have
the
to decide the
charges yet.
case. Now, with that evidence in mind, what can you do with it? As
This is how to
jurors, you may
consider it.
bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe because you're entitled to rely upon both direct and indirect or circumstantial evidence.
Right.
Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Indirect or circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences
It's
from
just a
them about the
circumstantial
fact that's sought
evidence.
to be proved.
Most of those
Such
cases,
inferences may be
circumstantial.
considered with all of the other evidence in reaching your verdict. Indirect or circumstantial evidence alone is sufficient to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable.
Which ones are reasonable.
And decide which seem more reasonable
And if
to
there's
you.
more than one,
Remember, when you're dealing with inferences, you never have to infer anything. You may, but do not have to draw inferences whatsoever. An inference drawn from indirect or circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one,
wait.
which is not.
You're saying we can't infer that the Lexus shot off into space. Well, damn it.
Too remote in the ordinary course of events. You
'Cause
may
that
not
would be too
guess.
remote.
You may not speculate. You may not engage in surmise. You should not pile
I'm gonna start
inference
saying no
upon inference
surmise.
until the pile gets so high that it tips over logically, or that the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends to equally give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition.
Right.
In order to convict the defendant,
If there are two inconsistent propositions, then neither has been established.
you must find that all of the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household hands you the mail and states that they observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the events with his or her own senses and told you what he or she observed. The issue you would have to decide is whether that witness was credible. On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox
There's
was
mail.
emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case. Not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I've just described. You may have noticed that Ms. Reed did not testify at this trial. Defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent.
Right.
The fact that Ms. Reed did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You're not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits.
Not
Now that
testifying
completes
cannot be
the
held
first part of my
against
instructions.
you. That was part one. On
Now
to
I'm
part
going to
two.
turn to the elements of the charges against Ms. Reed.
Everybody whose brain has stopped working, come on back. Elements of the charges. This part is what we need.
The Commonwealth has alleged that on January 29th,
This part is what I've been waiting to hear because I'm interested in hearing what the lesser includeds are. Each element are the different prongs that the jury has to find.
instructions. Now I'm going to turn to the elements of the charges against Ms. Reed. The Commonwealth has alleged that on January 29, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. So in that indictment, Ms. Reed is charged with second-degree murder. Now, I just want to tell you that our Supreme Judicial Court has promulgated jury
3 prongs.
instructions on homicide charges that I have to read verbatim. So I want to make sure to do that right.
She's saying I have to read them verbatim because there are prongs that don't apply to this particular case.
So murder in the second degree.
Assault and beat is the language of the second-degree charge. It does not mean that that's what they are trying to prove. It is the languaging of the second-degree charge. She's going to read the prongs. That is the languaging of the charge. We went through it yesterday in the indictment.
In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to Ms. Reed,
This is what the Commonwealth is charging here. Intended to do an act, not intended to kill, not intended to do grievous bodily harm, not grievous. 3, it's 1 or 1 or 1. So the third one is the one that they are charging. I know that gets confusing, but it is cause the death And then this third prong is what they're charging.
Intended to do an act which, in the circumstances known to Ms. Reed, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe.
Caused the death, plain and strong likelihood. Those are the two elements.
A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill John O'Keefe, or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has three sub-elements, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of these three prongs beyond a reasonable doubt.
It's
the first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe's death. The second prong is that the defendant intended to cause grievous bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this.
Yeah, what does that mean? What does plain and strong mean?
You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time.
This is why Brennan argued intended to back up, intended to throw the car in reverse, intended to speed backwards, went forward and then went back, because this is the prong that he argued, intended to do the act of backing up.
Time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether John O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would.
That's the but. But if, then, that second part.
Result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the second indictment is the indictment charging manslaughter while operating.
Manslaughter has prongs, and then this also has lesser includeds.
A motor vehicle under the influence
this has a lot of
liquor.
Prongs.
And there are lesser included offenses on this verdict slip.
Which ones
as well,
are they?
And I'll explain those to you as well.
Great. I want to know. This is going to count 2?
In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. To prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the things, the well-known things that drivers do as they travel on a street or highway, and also when doing any act which directly tends to set the vehicle in motion.
So those 5 prongs have definitions. So she's going to go through the definitions of each of those 5 prongs, including 3, and 3 has subparts like A and B. So hang in there. 5 prongs plus prong 3 has subparts A and B.
A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which alone or in sequence will set the vehicle in motion.
This is how you know someone's driving.
To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way.
Right.
This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing, and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, whether it is publicly maintained.
It's a road. It was plowed.
To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness.
That's why they used Karen Reed's statements about her driving. And for those of you asking, is that and? No, it's or. Under the influence or 0.08. I mean, it can be and, but it's an or. One or the other. They don't have to prove both.
And ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that the defendant's ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed alcohol. However, no matter what the reading is, the blood test is not sufficient by itself to prove that the defendant was under the influence of alcohol. Under the second theory, the Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly.
And that's why you saw the defense asking the hospital blood draw and the labs, is this a forensic lab? Is this a hospital lab? How are the procedures done? What are your procedures? That's why, week 1 or 2, there was so much questioning of the blood draw of the hospital lab and then of the other lab, because the hospital blood draw was sent to the other lab, and that's why there was so much cross-examination on certifications and what have you. It's because of this jury instruction.
You may also consider any other evidence pertaining to the test or the test results. The fourth element the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly.
That's the bigger point on this.
A person
cause of
drives
action.
recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently, that is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger of death or serious injury to others, but chose, nevertheless, to run the risk and go ahead. Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Here, the defendant must have intended her acts in the sense that they were not accidental. But it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in that category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation.
And that's why you heard
the
Brennan
defendant's
argue it.
rate of speed and manner of operation, the defendant's physical condition, and how well the defendant could see and control her vehicle. The condition of the defendant's vehicle, what kind of road it was and who else was on the road, what the time of day, the weather, and the condition of the road were, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all 5 elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while...
Let's talk about lesser includeds for 30 seconds. A lesser included crime is a crime that all of the elements of the lesser included are included in the greater crime. So they have gone from the OUI manslaughter or the DUI manslaughter down to the invol. So she's going to read the instructions on the involuntary. What'll be interesting is to see what, if any, lesser includeds come next. Last trial, we had the charge count 2, the involuntary, and then the motor vehicle homicide. The defense asked yesterday about a DUI, so they are going to the lesser included of the involuntary, which means the requisite proof and culpability and charge sets down. The defense asked to include the lesser includeds. The Commonwealth did not ask for any of the lesser includeds. So the court is going to read in the lesser includeds now.
While operating a motor vehicle under
The Commonwealth did not ask. A lot of you are like, Lally said no lesser includeds. The Commonwealth did not ask for any lesser includeds. But in some cases, the court can put the lesser includeds in. In some cases, the defense can ask for them. The defense asked for them. So these are the lesser includeds.
under the influence of liquor also charges her with that lesser included offense. The Commonwealth may prove the lesser included offense of involuntary manslaughter, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence. So I'm going to define involuntary manslaughter for you. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, that the defendant intended the conduct that caused John O'Keefe's death. And third, the defendant's conduct was wanton or reckless. I will now discuss each element in detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her action...
For those of you asking, what is the difference with this one? This one is just without the under the influence. So it takes out the under the influence. It is caused the death, intended the conduct, which would be the driving, and the conduct was wanton or reckless. So it takes out the driving on the public way and it takes out the under the influence. So instead of the 5 different elements, you've got 3 elements.
Directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act in a natural and continuous sequence results in death and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving grave risk of harm to another that a person undertakes with indifference or disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted,
This is the same
knowing what the defendant knew.
definition from the last
If the
instruction.
defendant realized the grave risk created by her conduct,
So if it sounds
her
repetitive-
subsequent act amounts to
Yes.
wanton or reckless conduct.
It is.
Whether or not a reasonable person would have realized the risk of great danger. Even if the defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined that term. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant was affected by her consumption of alcohol.
That goes to state of
A
mind.
defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide,
Oh, so they are including
felony
motor vehicle
OUI,
homicide.
and negligence. As a matter of law, the indictment that
So this is the second lesser included motor vehicle homicide OUI, which is the lesser drinking and driving. The one we just read was the invol. This is the lower one. I see a lot of you asking to go to 1.25, not while they're doing the charging, because these are the elements of the crime the jury has to find. So the charging is really the most important part of this as to the elements of the crime. So we have gone through the charge, the second charge, then the lesser included of the involuntary manslaughter, no drinking, no driving. Now we're getting into the motor vehicle homicide, which also includes drinking and driving.
influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI, and negligence. As a matter of law, the indictment that is before you that charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor also charges her with the lesser included offense. With that lesser included offense, the Commonwealth may prove the lesser included charge of motor vehicle homicide.
These are going to sound very repetitive to count two. A lot of it's the same. For those of you asking about OUI versus DUI, it depends on jurisdiction, but operating while intoxicated in some jurisdictions, OWI, operating under the influence in some jurisdictions, OUI, and DUI, driving under the influence. And in some jurisdictions, one is a felony and one is a misdemeanor, depending on if you're DUI or OUI. So it changes very substantially based on where you live. Some places it's DUI, some places it's DWI, some places it's OUI, some places it's OWI, under the influence.
Even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter and you are.
They've also, I think, parsed this out better. It is getting to, if you are not guilty on this one, then you go to the next one. It's in the instructions. And if you're not guilty on this one, then you go to the next one. You may only consider this if you are not guilty on the other parts. I think it's spelled out better.
Are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. On the verdict slip, that just means you start from the top and you work your way down.
Yeah,
in order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered.
So count 2 is the wanton and reckless, not negligence. This lesser included is negligence. It's that lower standard.
Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as previously instructed a few moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element, so I'll focus on that. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people.
That's
a person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by not doing something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of a road it was and who else was on the road, the time of day, the weather. And the road conditions. what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The offense of manslaughter while operating under a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI liquor.
They just read
And
that one.
the lesser offense, I'm sorry, hold on.
That's duplicative. You just did that one.
And the lesser included offense of operating under the influence. As a matter
So the court did put it in. That is something I was wondering about. Was the court going to add just a straight up DUI? She was not charged with a straight up DUI. The defense asked for just a straight up DUI. This is that lesser included. So they have three lesser includeds, 4 things to consider on count 2. Count 2 is the manslaughter, then the involuntary, then the motor vehicle homicide, which is DUI related, then just a flat operating under the influence. That's what she's going to read now, is that final lesser included.
Matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with these lesser included offenses. So the Commonwealth may prove the lesser included charge of operating under the influence, even if it fails to prove the
So that's
greater
the
charges
OUI.
of manslaughter while operating a motor vehicle under the influence of liquor and motor vehicle homicide. You may find the defendant guilty of operating under the influence only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are not convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide, but are convinced that the defendant is guilty beyond a reasonable doubt of operating under the influence. To prove the defendant guilty of
So what the court said was, first you have to go to count 2. If count 2 is a not guilty, then you go to lesser included 1. If that's a not guilty, then you go to lesser included 2. If that's a not guilty, then you go to lesser included 3.
operating under the influence, the Commonwealth must prove elements 1, 2, and 3 that I instructed you on motor vehicle homicide while OUI. So the third indictment is leaving the scene of an accident resulting in death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated a motor vehicle on a public way or in a place which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe.
The court read the OUI. The court read in the OUI that she was drinking and that she was, or that she was drinking and that she was driving. I'm paraphrasing, but the court read the OUI just before this.
Resulting in his death. Fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed on the first and second elements. The other 4 elements should be given their plain meaning, and the parties agree that I do not need to define these any further, correct? Okay. Thank you.
The court read in the 5 elements and said, we agreed to the plain meaning. We're not going to read the definition of failed to stop and what it means to fail to stop. That's count 3.
Yeah. All right. As a general rule, you're permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm or intends to do an act which, in the circumstances known to him or her, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person.
Right.
In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. That completes my second part of the instructions. I'm now going to turn to the third and final part, which is shorter.
Part 3.
In order for a jury to return...
For part 3, we're going to 1.25 speed. We are warp speeding past that. Those were the instructions. Now is the final charge before they go out.
Turn a verdict. That is to reach a decision.
I sped this up. We've already gone through the charges.
In a criminal case, the law provides that there may only be 12 persons on the deliberating jury, and you will note that there are 18 of you. To avoid the need for a new trial if one or more jurors becomes ill or is to be excused for some good reason, we customarily impanel extra jurors at the beginning of a trial, as we did in this case. Because of the anticipated and now actual length of this trial, we impaneled more jurors than are commonly impaneled. However, when you begin your deliberations, the law in Massachusetts is that only 12 jurors
Only 12 can deliberate.
Therefore, at the conclusion of my instructions, Mr. McDermott will reduce your number to 12 on a random basis. The jurors not selected to serve in the jury will become the alternate jurors. If you are selected as an alternate juror, please do not feel that your efforts in this case have been wasted. Because as I've indicated, it's important that we have extra jurors in case of an emergency.
Don't be mad.
If we did not impanel extra jurors and a juror became ill or for some other reason had to be excused,
we'd have to
we'd
start
have to
over.
try the whole case all over again with a new jury.
You need to be here. So sorry.
In the event that a juror has to be excused once the jury starts deliberating, then an alternate juror will be chosen to take that juror's position, and the jury will be required to start deliberations from the beginning. Therefore, it's important that the alternates not discuss the case with anyone else, including each other. For if an alternate becomes a member of the jury for deliberations, the alternate's views should be his or her own and not be influenced by anyone else. Different states and jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own person. In Massachusetts, the judge is responsible for selecting the foreperson.
And it's just the person in seat 1.
The
Congratulations.
foreperson of a jury has been described as the first among equals. He or she is responsible for organizing the deliberations, communicating with the court if necessary during deliberations, and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations. However, and in that sense, the juror is equal with all other jurors. I am going to ask the juror seated in seat number 1, your juror number 5, sir, would you agree to be foreperson in this case? I'm going to ask you if you would be foreperson in this case. Thank you. I always appreciate it when people say yes before I tell you what's involved, but thank you very much. All right. So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree. So, all right. So I skipped the line. When you return to the jury room to deliberate, the court officers will deliver to you all the exhibits in this case, as well as the verdict slips that you'll be using.
You've been calling told.
So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree before you have a decision to any specific charge. That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should consider each indictment individually and continue deliberating until you've reached a final verdict.
I'm going to slow this down because she's talking about considering each indictment individually.
You should not begin deliberating until all 12 jurors are together in the jury room and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case. Further, I remind you that no juror is better qualified to determine the truth of the facts in this case, to dispute or to deliberate on a verdict solely because of education, background, or experience. The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight.
You've got it, y'all. Let's go.
To reach a unanimous juror, reach an unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement, if it can be done without violence to individual judgment.
Good Lord.
At the same time, each juror must decide the case for himself or herself, but only after impartially considering the evidence with his or her fellow jurors. Don't hesitate to re-examine your views and change your opinion if convinced it is wrong. But no juror should surrender an honest conviction to the opinion of fellow jurors simply for the purpose of reaching a verdict.
Right.
Although how you conduct your deliberations is up to you, I urge you not to begin by conducting an immediate straw vote. Rather, I encourage you not to take any votes before you've had completed a careful and thorough collective view of all the evidence.
And this is
At
why
this
I
point-
think this instruction is not in all jurisdictions. And this is why I think expecting a swift verdict might not be the right expectation, because the jury instructions tell them consider all of the evidence, all of it, all of the evidence before you take a poll. Not all jurisdictions have that language in there, but the jurors are also told, I'm not telling you what to do, but maybe you should do this.
Point, I want to remind you of an important issue that I raised with you at the beginning of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. I also pointed out that we all have our own built-in expectations and assumptions, even if we are not conscientiously aware of them. And I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to it.
This is the exact same instruction they give the jury at the beginning of the trial. I'm going to put it at 1.25 because we have now heard it like 16 times.
Decision. Hasty decisions are the most likely to reflect stereotypes
Slow
or hidden
down.
biases.
Do not
take time to consider
Give
all the
your
evidence.
opinion too forcefully or
Second, as
too
you start to draw
fair.
conclusions, consider what evidence, if any,
Fast.
supports the conclusions you are drawing, and whether any evidence casts doubt on those conclusions.
Right.
Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as members of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or
This
gender
is
identity
read
groups?
in every case.
Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making
Listen
assumptions,
to each
perhaps
other.
based on stereotypes.
Don't make
Of
assumptions.
course, your fellow jurors could be influenced by their own unstated assumptions, so don't be shy or hesitant to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions.
Talk it out.
If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible.
Yes, the
and
court
that is your
said slow down, and then
responsibility
I
as
sped her
jurors.
up.
Now, during the course of your deliberations, you might have a question concerning the law in this case. Perhaps I said something you did not understand. If you have any questions, please
Send a
feel free to
note.
bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officers. I'm not suggesting for a minute that you have to have questions, but if you do, that's the process. Because your rule
And you have to be told
as the
in open
jury is
court,
to
that's
determine the facts in
process.
this case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are.
You
Neither is it possible
decide
for me
the
to provide you with a
facts.
transcript of the testimony. If you send a question to me, I'll respond after consulting.
It's so odd to me that they do that in Massachusetts, but they tell them in the instruction, nor is it possible for me to send you a transcript.
With the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case. Generally, we will not answer a question or take a verdict from 1 o'clock till 2 o'clock, but I think you've all waited so long to get this case, I think we can change that. But the court staff needs a luncheon break. You'll have lunch brought into you, and you can decide whether or not you want to stop your deliberations during lunch or continue and deliberate.
Didn't they already
At the
have
end of
lunch
the day, if
today?
you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the
other
day.
days.
And return the next morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before you until such time as you've reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict on each indictment. After the final vote
It
of the jury,
has
the
to
foreperson
be
should check the
unanimous.
appropriate boxes as to each charge, then sign and date the verdict forms and notify the court officer when you've reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts. This will be the last time I'm going to see counsel at sidebar, but I'm required to see counsel.
This will be the last time I see counsel at sidebar because this is the opportunity to object if there was anything read out of order, anything skipped, anything read improperly, this is their opportunity to object. So there needs to be a sidebar here to say, was everything read properly? They're looking at the instructions as the court is reading them. If the court flips past something, this is the time for the attorneys to raise that issue. And now they will pick the alternates out of the wheelie box. It looks like they were already rolling the wheelie box, and then they will call those out. There's the wheelie box. Oh, like the balls are in the box.
May I?
Yes.
And that's loud. And then they will call the alternates.
Could the juror sitting in seat number 13 step down and take your place as an alternate?
And then the chips.
Could the juror sitting
The chips are being put to the side after he reads them.
in seat number 7 step down and take your place as an alternate? Juror 6, could you step down and take your place as an alternate? Juror 17, could you step down and take your place as an alternate? Juror 2, could you step down and take your place as an alternate? And Juror 8, could you step down and take your place as an alternate?
Those are set to the side so the lawyers can look at them. So the lawyers can go look at the numbers that he pulled out. Those are the alternates.
All right. Yes, please do.
And then the court officer will get sworn.
Do you swear that you will keep this jury in alternates in some separate but convenient place until they agree, that you not suffer any person to speak to them, and to speak to them yourselves, nor ask them if they agree, nor suffer them to disperse until they have discharged their verdict, except by further order of the court, so help you God? Thank you.
All right, so members of the jury, I need not remind you that you have an important responsibility.
And they are going
that
to be
I believe
charged
that you will bring to bear
to
all
deliberate.
the wisdom and the judgment and conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide the case with integrity and with principle. We all expect you to reach an impartial verdict dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you've heard here in court during the trial. We are looking for impartial judgment dictated by your reasoning and the fullest discharge of your oaths as jurors. You may retire and deliberate your verdict.
And they're out.
Jurors, make sure you take your notebooks with you, please.
Jury out. The jury is retiring to begin their deliberations. I'm going to later go on social. I'll grab the exact time they started deliberating because we're just a touch behind real time. The court will probably come back and ask the lawyers if there's any items they need to put on the record, I would imagine, and then talk about scheduling. So let's see what the court has to say. I'm waiting to hear you are unmuted. Tell me I'm unmuted. Unmute us. Oh, I can hear what's going on in court. And the jury is back.
Counsel one more time.
Not at sidebar. Can you just do it in open court? The jury's already out. Thank you, Dr. B. We needed more coffee. And back to sidebar they go. All right. If there's anything that needs to be put on the record, I hope they will just do it in open court. But they are back at sidebar. Okay.
What numbers? Counsel.
All right. Let's hear what they put on the record.
Judge, the first thing is counsel this morning and yesterday looked at exhibits, and I believe that we were pretty close. We had one exhibit that needed to be dealt with. Ms. Little, what number is that one again? 150?
Yes, this is exhibit 155.
155.
Exhibit 155. I'm going to gain this up, so he might peek a little bit, but they talked this morning about the exhibits. Let's hear what they have to say.
And I'll let Ms. Little take it from there.
Yes, there's just one page, Your Honor. I believe, and my memory is not perfect, but I believe that we were going to have this redacted subject to the same redactions from last trial. I think there's just one line here that needs to be redacted.
Okay, is the Commonwealth in agreement with that one line?
No objection. I believe it was redacted last time, so if defense
Okay.
wants to make that reduction, you can go into evidence.
Great.
I'll see if I have a Sharpie and maybe I can just take care of it.
I think we probably have one here you
I
can
have
have.
one. I definitely have one somewhere.
Jim's
All
like,
right.
I have a
That's
Sharpie.
number one. And number two is, can counsel look at the verdicts and just tell me if verdict slips and just tell me if they're okay with it? Thanks.
You'll see that it's not what you provided me yesterday, Mr. Kennedy.
You have to review the verdict slips every single time. All of the lawyers have to review the verdict slips. The amount of times that there are typos on the verdict slips can't be understated. It happens. You have to check the verdict slips. So the lawyers are going to see that, and the court said you will see it's not the one that you proposed, Mr. Giornetti. It's probably the standard verdict form. We'll talk about why courts do not deviate. Because deviation has not been approved by the Judicial Council. But I talked about my thoughts on that yesterday. Fifi, it's probably too long. There's a text limit on chat. So they're reviewing the verdict forms. Hi, George, I hear you. The court did not put in any instruction about the hoodie, which means that was denied. It was asked for. She did not rule on it, so it would have been denied at sidebar. Jesse said, Emily, we can get notifications for the jury on the Lawnerd app. Yes, that is exactly what we will do. I'm going to stay live for a little bit. We've got a lot of questions to answer, so we're going to be live for a while longer. The jury said they will stay till 5 or 5:30 Eastern today, was the last we heard. The defense is reviewing the verdict slip. If I was the defense at this point, I might argue about it one more time. They've made a record, but why not? I would. So the jury is out and deliberating. The defense is reviewing the verdict slip.
Sworn in first.
And we are in verdict watch. Which, once they are done in court, we will officially verdict watch.
Counsel, you can keep doing that. Mr. Rose, can you raise your right hand?
Counsel,
Do you solemnly
can keep doing
swear that you will keep that jury in some separate but convenient place until they agree, and that you not suffer any person to speak to them, to speak to them yourselves, nor ask them if they agree, nor suffer them to disperse and to charge their verdict, except by further order of the court, so help you God? Simply because you weren't in the room. Thank you.
They swore the other bailiff who wasn't in the room. So multiple bailiffs have been sworn. A lot of you are saying you would be so mad to be an alternate. Yeah, you sit there for 8 weeks, and then he gets the little bingo counter and pulls out a marker, and wham, you have to go sit separate from the other jurors and apart from the other jurors and not talk about the case.
Almost content.
The question was, is the Commonwealth content with the verdict slip? Lally said the Commonwealth is content, but the alternates cannot talk about the verdict, the case. They still have to stay undisturbed. Hopefully they let them bring a book, so they have to go sit somewhere and wait while the rest of the jurors go back and deliberate. So the other jurors get to talk all about it, and the alternates have to wait. It would be so annoying. They probably can't have a laptop or social media. They would need to have a book, like a physical one. Hi, George. What's up, buddy?
Your Honor, I understand that you've rejected our proposed verdict slip.
So everybody else can sit down. Mr. Yannetti can stand.
Thank you. I understand that you've rejected our...
I said I thought the defense might argue again over the verdict slip. The defense is going to argue again over the verdict slip. I'm not surprised. Hi, George. George would like to say hello. George, we're on verdict watch, buddy. I know. I'm going to be covered in cat fluff, George. This is not the time.
Verdict slip.
We're only interested when I'm streaming.
Our concern with this verdict slip...
We're listening to Yannetti.
...is
I'll be
that
back.
there are...
Hold on. Go watch the birds.
4 options for... Actually, more than that. 7 options for guilty verdicts. 1 option for not guilty. And we're concerned that this is too confusing for the jury. So we are asking that there be not guilty options for each of the charges, including the offense charged and each one of the lesser included offenses. So we really ran into the same issue last time. I think what complicates it is the fact that there are two theories for two of the lesser included.
Do you suggest that doesn't accurately reflect the law?
It does reflect the law. I'm not saying that. I'm saying that it makes things very confusing, and that's why we believe that it cries out for some not guilty option, given the amount of options for convictions on this verdict slip. So we would again ask the court to adopt our proposed verdict slip.
So your proposed verdict slip did not cite any case law. Do you have any case law that supports that proposition, Mr. Yannetti? I have not found any. I've looked.
There's not a lot of case law out there in this verdict slip either.
Other than that has never been proven, has never been found to be inaccurate.
Not yet.
Okay.
And I mean,
So
This is the thing. Lesser includeds are incredibly common. Lesser includeds are incredibly common. So this is not a verdict slip that is unusual, that is customized, that is odd. This is a verdict slip that is common in Massachusetts. And the verdict slip has never been found to be at issue. The court is saying, the defense is saying, we think it's confusing. But the way they do their verdict slips is the way they do their verdict slips. And if that's what's used in every case that has lesser includeds, then it's going to be what the court is going to go with. I still think if you go with what the defense asks for, it reduces the potential for that to be an issue on appeal. However, the verdict slips are standard across the state, so the courts have already evaluated them. And the courts already evaluating them mean that this is what is used. I understand both arguments. The reason I understand both arguments is because, well, when the courts say these are the verdict slips, they are pretty standard. So, but I understand Yannetti's argument saying this can be confusing, especially when the court says you have to decide on this one, and then you have to decide on this one, and then you have to decide on this one down below. So I understand where they're like, okay, but shouldn't you be able to pick guilty, not guilty as to each thing instead of just not guilty at the top and then guilty to each thing? I get it.
That's fine. So your rights are reserved. Does that help you?
No.
All we can do is object, Judge, and you may.
Okay.
No.
Okay.
It doesn't help
Judge,
him.
the last couple.
If you
He doesn't
find
like it.
authority for that,
He doesn't like it. Your rights are reserved. Okay, well, his rights will be reserved if you used it anyway, because if she's acquitted, the Commonwealth can't appeal, and if she's convicted, she can appeal, and then the response from the appellate court will be, we gave the one you asked for, so you can't appeal on that issue. I mean, that's another way to reserve it. Just saying.
let me know.
Will do.
Okay.
The last couple of things, judges, that we were provided with a clean
Laptop?
laptop. Thanks. We were, with a clean laptop. Defense counsel had a chance to, or at least defense had a chance to look at it, and I think that's fine. But
All right, so we'll send that in with the exhibits. I need to go edit my charge to fix all the typos.
And then the final thing is I provided counsel with the exhibit list that we had, and it was satisfactory for both sides.
Great.
Thank
All
you.
right, thank you.
All rise to the court, please.
The Commonwealth, I saw a couple questions. The Commonwealth cannot appeal, can't appeal if she is acquitted. Can't appeal. Can't appeal. So this was my point regarding the verdict slip. If she's acquitted, the Commonwealth can't appeal. So if she's convicted, the defense can appeal. And if the defense appeals and tries to appeal on the verdict slip, the appellate court will say, that's your verdict slip. So too bad. Which means, for me, your rights are preserved. That can go both ways. One, this is the way we always do it. Two, if we do it the way you want to do it, the Commonwealth can't appeal it. And if you appeal it, the Court of Appeals is going to say, nah, you can't, there's nothing you can do. So that's what it is. I am now covered in George fluff. So thank you, George. Hi, buddy. Yeah, it's summer, isn't it? We're going to try to summarize what happened today, and then we will chat more. Yeah? Okay. He's like, but Mom, now is the time. Now is the time. Let's try to summarize today. Oh no, wait, first we need to go to Verdict Watch. That's what we need to do first. First, we need to go to Verdict Watch. You're right, law nerds, we do. We need to go to Verdict Watch. Hold on, it's been a minute. Let me find it. Let me find Verdict Watch. The jury is out. We are on Verdict Watch. That is where we're at. Let's talk about what happened after the lunch break. It seems that the jurors got a quick break. The court reminded the jury that they normally do not take a verdict between 1 and 2 p.m. That ship is kind of sailed because it is 3 p.m. local time. The verdict is, or the jury is out to deliberate. George is Georging. Where are you going, buddy? I was not paying enough attention. Yes. Okay, George, we have lots of law nerd questions to answer. George is going to find one way or the other. There we go. George is like, I will find your attention. I am going to get your attention. I know, George, your human is at camp. I understand. I know. He's so disappointed every time we come home and Travis is not with us. He's like, no. Let's answer some questions. Let's talk about where we were at the end of today. The court read in all of the jury instructions. What I was curious to see is, would the court give the instruction the defense had asked for regarding the discussion of John O'Keefe's hoodie? The court did not. The other thing I was curious to see is if the court would include just a DUI in the lesser includeds. And yes, the court did include a DUI in the lesser includeds. I also saw a lot of confusion over lesser includeds. The lesser included crimes to be included on the verdict slip must be crimes where all of the elements are also included on the greater charged crime. So it is saying that there is the top crime, and then in those elements, there are also these lower or lesser crimes. They are less serious crimes. So the most serious one is charged, and then you can add the less serious crimes under it. And that is what was done here. The same few as last trial, plus the addition of a flat or a straight DUI, just a driving under the influence. So count 2 now is count 2, the manslaughter while driving under the influence, then lesser included A, involuntary manslaughter, lesser included B, motor vehicle homicide, and lesser included C, DUI. I think I got all 3 of those correct. The lowest level charge on that, the DUI, is going to be a misdemeanor DUI, just a drinking and driving, which I imagine a first time misdemeanor DUI is going to involve fines and alcohol classes and maybe community service and maybe probation. And that's about that. So those are the lesser included. Yesterday in the charging conference, you heard Attorney Lally say he was not asking for a lesser included or any lesser included, and the defense said that they were. I will also just remind, well, it might be not a reminder. There are some charges, and I don't know if this is the case in Massachusetts, there are some charges where the lesser includeds get added automatically. So even if you have this greater charge, that the lesser includeds are automatically given to the jury. It is not adding charges. It is not asking for more charges. It is giving the jurors options A, B, C, D, E. Because all those elements are in that charged offense, the greater charged offense. And the attorneys know that. And it's one of the things that attorneys talk to their clients about and strategize about if they want lesser includeds. If they don't, sometimes the judge will add them in there without the attorneys wanting them. It really just depends on the case, the judge, the charge, and the jurisdiction. But Attorney Lally said, we're not asking for lesser includeds. The defense said that they were, and the lesser includeds were in there. The defense also wanted a different form of the verdict slip. We heard a fight about this last year. The defense has raised those same objections again. That verdict form, and I will let's pull up the verdict form from last year. This is from last trial. It does not include that OUI charge, but it shows the layout, which I think is helpful if we take a look at the layout of that verdict form and why they have made their motion against it or about it again. So let me pull that up real quick. Again, caution. This is the one from the last trial. This is not the one from this trial. Just so we are abundantly clear that we are talking about a different thing. Let me open that. All right. So let me pull that up real quick, and then we will pull up the OnlyFan again in a moment. Again, this is the verdict form from the last trial. Here's what the defense is. Every time I do this, I mess it up. Here's what the defense is arguing with the court about. The charge defense is up at the top. The manslaughter while operating a motor vehicle under the influence. That's at the top. Then at the top, there's an option for not guilty. She's not guilty of any of this. Done, period. Then the lesser includeds and the top charge are listed. So the option is not guilty, then guilty of the offense charged manslaughter, and then A or B, then guilty of the lesser included offense involuntary manslaughter, then guilty of the lesser included offense motor vehicle homicide, felony OUI, then A or B. Then on this one, there would be another one, a number 5, that just has the DUI. So the defense is arguing, look, instead of having the not guilty at the top, it should be guilty of offenses charged, A or B, not guilty of offenses charged, or not guilty of offenses charged, then guilty as offense or as charged. Then the next one should be not guilty of lesser included, guilty of lesser included. And so and then it would go down the line. So that's what the defense is asking for. The court said that this is the way they do it in Massachusetts. This is the way they do it with lesser includeds. And this is what the verdict form is. Also, the court's instructions on this issue, I think, were much clearer. The court said you must go down the verdict form and decide, and you can only decide if Karen Reed is guilty on the lesser includeds if you've decided she's not guilty. So you have to decide not guilty on the first one, then not guilty to go down the line. So the defense is saying, right, so shouldn't there be somewhere to check it? However, that is not what the court did. But does it raise the issue or the circumstance that the jury could click not guilty at the top and then click guilty on one of the lesser includeds and cause a whole bunch of confusion? I could 100% see that happening. I could see a jury thinking that the not guilty at the top modified the charge offense, and they're like, we don't think she's guilty of the manslaughter, we think she's guilty of a DUI, and then going down the list. I can see that being an issue. We'll just have to wait and see. The jury instructions on this, I think, were much more clear than they were. And the court said it more than once that you can only consider the lesser includeds, and they'll have the jury instructions printed out. And this time the jury instructions say you can only consider the lesser includeds if you've decided not guilty on the offense essentially above it. So each time in the jury instructions, it goes down that list, and the jury will have them to read. But I can understand why it's confusing. Martha said, wait, is there more than one verdict form? Yes, there is a verdict form for each separate indictment. But for indictment 2, there are lesser includeds, and all of those stay on one form, and that is very common. So I think that we will see the defense bar in Massachusetts, or at least Mr. Yannetti, arguing that these verdict forms should be changed. I saw a lot of questions in the chat about the jury instructions, and a number of you said these sound familiar. There is a national model jury instruction, and then there are jury instruction committees and judicial committees in each jurisdiction that take the model jury instructions and modify them to their jurisdiction. And then those jury instructions are edited for each case. So normally the jury instruction will have the option to select gender. They will have the option to fill in the name. They will have the option to fill in the charges. And you go through the computer program and you fill in all the things, and then you end up with the verdict forms or with the jury instructions that they read in court. So when they sound similar, they're supposed to. If you are charged with the exact same crimes in the same state, the verdict forms, yes, but the jury instructions should be the same. They should be vetted through the courts. So when there are issues with jury instructions, they go up to the appellate court. The appellate court sometimes says, nah, we're not doing that. Sometimes they say it's fine. So the process of ending up with the jury instructions that we have are from the model jury instructions, the state's jury instructions coming from those, the jury instruction committees or judicial committees that decide it, and then from the appellate courts. So it goes through rounds and rounds of consideration, and they are regularly and frequently updated. So many of you were like, this doesn't feel clear at all. It's like, right? But that's as clear as they can make it. Jury instructions are confusing. They can be confusing. And having the jurors go through it with the court, I think, is more helpful. So yes, Tracy, what the court read in are from the model jury instructions in Massachusetts. Yes. Everything the court read is from the updated model jury instructions. So yes, Miguelina, can we pin that we are on Verdict Watch with the app? Because I will let you know, I don't expect the jury to come back today. Could they? Yes. But I think that instruction, do not take an initial poll, go through all the evidence. I think that's a heavy instruction. Also remember, for 8 weeks, this jury cannot talk about the case. For 8 weeks, this jury has sat there and watched and then go home. 8 weeks. So that is a very long time to not be able to talk about the case. And the court told the attorneys that they could be within 10 minutes. So I would not expect or anticipate that they will come back today. Could they? Sure. Anything's possible. But would that be my expectation? No. All the jury instructions that they read are the model jury instructions for Massachusetts. The judge read the same instructions that are read in every other courtroom in Massachusetts. And in the defense model or the defense request for jury instructions, it had the jury instruction that said the court selects the foreperson. The foreperson is the juror in seat 1. So I think that that is also standard across courts in Massachusetts, that is how the foreperson is selected, because it was in the defense jury instructions that they submitted to the court. Lots of you have asked from so-and-so. You are not, 50,000 of you have asked me, what happens if there's another hung juror? I don't like answering this question because I don't want to put it out to the universe. I think everyone in this case needs there to be a resolution. However, it's up to the Commonwealth. The Commonwealth can retry a case. What happens if there's a split verdict? Split verdicts happen where a verdict is rendered on one count and not rendered on another count. If there is a split verdict, they can choose to retry on just the counts that aren't resolved. They can choose not to. It goes to the Commonwealth. But they could come back with a split verdict. Some verdicts on some verdicts on none. I hope that they reach a decision. I think this case deserves a decision. It has been a long time, but cases can be retried more than 2 times, more than 3 times. They can be retried. It's going to depend. The Commonwealth can choose not to, but I think this case was clearer. I think the jury instructions, especially on the lesser includeds, were clearer. The attorneys addressed count 2 and the lesser includeds, which is clearer. And so I think that there is more clarity in the case for the jury. If you watch the first trial, let me know what you think. Hold on. I'm going to poll on that and then we'll poll on closings real quick. Let's see. If, let's compare the 2 trials. Let's see. 2 trials. Emily, can you type? No. Let's see. Comparing the 2 trials. The first was more clear. The second was more clear. About the same. I just wanted to see Proctor. That's your out answer. I just wanted to see Proctor again. All right, let's get to some questions. And I guess it would have been fair to say I didn't watch the first trial. That's fair. If you didn't watch the first trial, just put it in the chat what you think. So Lonnie said EDB verdict watch. Oh, there is definitely a typo in verdict watch. There sure is. That one. Yes, there sure is. I see the typo. I appreciate it. Don't worry. We'll get it. We'll get it in a new pinned message. We were just trying to answer, is the jury out? Is the jury out? So we put that in quick, but don't worry. We'll get a new one up there in just a second. All right. Let's get to some of your questions. Some of you didn't watch the first trial, which is fair. For those of you that didn't watch the first trial, we're going to do a poll in a minute on the closings. So do not worry. Let's get to some of your questions from Super Chats. We've got a bit of time for questions. Here's what I want to know. Do you want to keep the fan up? Do we need the comfort fan while we're talking, or is it going to make any of you motion sick? You let me know. Do you want the comfort fan? Just while we're chatting? Do we need to just keep eyes on to the fan? Okay. I'll keep it small. There's overwhelming amount of we want fan. All right. I'll make the fan a little bit smaller. We will keep the comforting only fan up for a little bit while we stream. And then we will poll in a minute about the closings. So good to see all of you. It's been a long day, hasn't it? Hasn't it? So, Magdalena, that's fine to have the link as long as we also have the Where in Verdict Watch. That's fine. All right, let's get to all of the comments and questions we haven't gotten to. Casey in the chat said, what time is it in Massachusetts right now? It is 3:26 in Massachusetts. Natasha said, am I the only one who feels this case is personal to them? I think a lot in the chat feel that way. I am not the right person because I have so much experience in being either connected to my work or disconnected to my work. But a lot of people feel that way, Natasha. I don't think you are alone in that. So it is not unusual. And I think this case has, especially for those of you who watched for so long, a lot of people feel personally connected to this case. So I don't think you are alone. Laura M says, what does everyone eat on their ham sandwich? I'm sure that the chat answered that this morning. I prefer a turkey sandwich, honestly, but I'm sure everyone answered that this morning. NY Mom, thank you for the prayers. The tech and the caffeine came through today, so we're here for it. Lady Jen said, closing on my birthday. Let's ride. Friday the 13th are my favorite, and this is the only Friday the 13th of 2025. I didn't know that. Happy 40th birthday to me, and happy birthday to all my Law Nerd birthday partners. I know if you've got a birthday on the 13th, every now and then you get a Friday the 13th birthday. Christy R said, morning muffins. Morning muffins for the Law Nerds. Do you think Dr. Curry is just like, see? People have food. It's not a big deal with the fucking muffins and the ham sandwich and the rest of it. Right. I hope Dr. Curry feels vindicated that another expert has been asked an inordinate amount of questions about food that is not nefarious. Kixie said, can they object during closing? They can object during closing. No one did, but yes, they can. What a wonderful birthday present on top of my favorite Friday the 13th B-Day. BDE, a lot of Friday the 13th Law Nerd birthdays today. I love it. Brandy Rose, good to see you. Did you see the judge denied the motion for transparency in the selection of alternate jurors? The Commonwealth opposed the motion. Why would they do that? I think it's because the defense asked for an order in writing, because they did it in court. And I think the order in writing was the thing. Because again, if there was a normal process, there's no need to put the process in writing. The clerk pulled them out and put them on the table so that the defense could go look at them, or the Commonwealth could go look at them. So, pharmacist Carrie Hopi, there are a lot of ways to interpret those texts, aren't there? Erica said iced coffee and doing my makeup at my desk. Happy Friday. I'm sure you've done a full day now and are coming back. It's good to see everyone who got coffee. Carrie said, why don't they pull the alternate juror numbers in open court? Idaho and Arizona call them like bingo numbers. They did today. I think they did last time and it wasn't televised. And then the clerk called them and just put them back in, probably because the lawyers hadn't asked to see them before. So that is what I suspect. But they were called in open court. They were pulled and called, and then they were put aside so the attorneys could see them. So Christina said, how do they pick the foreman without picking the jury? It seems that juror number 1 is always the foreman. And if that's the case, this is my speculation. If it is the case that juror number 1 is always the foreperson, I imagine they don't put that number in the rounder. And juror number 1 is always juror number 1. That would be my guess. Any soundboard worthy clips from this trial? What are you talking about? There have been too many. We've got to decide later because we're going to run out of room, but the nope is going to stay. Nope is going to stay. He's cooked might stay too. So we'll see. What legal grounds are there for the judge to deny the motion for transparency? She doesn't have to write an order on it, and it asks for an order. And the judge can say, I'm not writing an order. We pull them in open court. So granting the motion means the court would have had to write an order that doesn't need to be written. So a lot of you are saying occiput boner. I don't know. YouTube might get mad. YouTube's already mad today. We just need a larger soundboard. I mean, maybe we do. Shima said, thanks for the company in my first trimester. You are welcome. I pray that your child's first words are objection, hearsay. No, I'm teasing. No one wants that. Objection. Facts, not in evidence. The GOAT said, thank you for your relentless coverage of and content for this case. We were going to watch it. It's a long one. We knew it was going to be long. Some of the trials I chose not to cover this year were because I knew that this was going to be a long trial. I know that Idaho's going to be a long trial. There are going to be other trials I want to cover that might overlap. I just don't know. It's going to depend. Oh, the gross might be a good sound board as well. So yeah, it's trial days are long days. Trial coverage is long coverage. It will be a little easier in Idaho because the time zones will work out in my favor, but I'll have some travel during that too. It works out well that most of the DCI season is going to be in between trials. So there's lots of things we need to catch up on, but there's also going to be some days that I am not streaming because I'm traveling for DCI. So it just really depends. Already said I love how involved Karen has been in her own defense. Oh, she has been incredibly involved. The thing I appreciate is that it seems, let me back up a little bit from that. There are defendants who are very involved in their case who don't seem to listen to their attorneys. I don't know if anyone comes to mind for you, but there are defendants that are very involved that don't seem to trust the guidance of their attorneys. It seems to me that though Karen Reed is very involved in her defense, she also trusts her attorneys and works with them, not against them. She doesn't treat her attorneys, it seems, as like, you need to do this for me. It seems that they work as a team, different than, no, you work for me, do what I want you to do. It doesn't seem like they're fighting with each other. It does seem that they work as a unit, and that requires trust. Trust from the client and the lawyer, and trust that the lawyer trusts what the client is doing too. So it does seem that the defense team works together and trusts each other, and that is critical. Amber Janes, I've been watching for years, finally joined as a law nerd. Glad to have you. Good to see you. And all of you are law nerds, whether you're members or not, you are all law nerds. You're here in this chat. You're having these conversations. You are law nerds. Some of you just have more flair, which is completely fine. I love the flair. The rest of you can just use the emojis. It's all good. But yes, all of you are the law nerds. TDH said, I can't believe AJ dropped the see you next Tuesday. Oh, I 100% can. I 100% can. I 100% can. I 100% believe AJ dropped the see you next Tuesday and was happy to do so with vigor. Did he say fuck too? I think he said fuck. Yeah, he said she's fucked because there's a lot of emphasis. Oh yeah, he was happy to do it because you can't let the jury forget. And he loves to curse in open court, but it's also so offensive. And it is shocking to most people to hear that the lead investigator is dropping the C word on Karen Reed. And he just went boom, boom, boom. She's a whack job. See you next Tuesday. You know, no ass bitch, this and this and that. He just went right through them. Was that more powerful than having Proctor in court and trying to explain them and say they're regrettable, they're juvenile, they're this? Is it more powerful to have Jackson getting up there going, can you believe what this motherfucker, I'm paraphrasing, that was based on vibes. Can you believe what this motherfucker said about the woman sitting right here? Can you believe it? This jury's never even seen him. Can you believe what this motherfucker's trying to do to this woman sitting right here? The fucking audacity. The audacity of him. And it lets the defense lean into that argument. And the Commonwealth's like, ooh, he's a boogeyman. It's like, you've got a lot. You've got a lot to deal with, though, Brennan, with those texts. And Brennan's like, I didn't put in the evidence. I don't trust Proctor. That was the vibe, right? The investigation, Brennan said, has integrity. Okay. We'll see. We'll see how that goes. Let's see. We need an alpaca on the podium. I mean, this trial definitely didn't have alpacas, which is fine. Amanda, absolutely. It is, well, I have lots of family in California. Today is not the day, but absolutely. Kate said, did this yesterday with all the craziness, teaching summer school for the LSAT. No, for the last time. Emily, your brain just went like, when the dyslexia is in real time. Did this yesterday with all the craziness, teaching summer school for the last time, retiring from public education after 35 years. Thank you for the work that you do of teaching high school English, drinking my hot tea, reading for all the tea. Love the law nerd community. Thank you for the work that you do, Kate. It is a career that does not get nearly enough, and it is the most needed. And having our educators not getting the respect and the support that they need is wild to me. But again, I am the child of an educator, so I am very biased in this. I also think education is something that A, everyone deserves, B, everyone needs, and C, is going to be more and more critical as our kids are faced with trying to really parse what's real. And that's fucking wild to me. Like the speed of technology is moving so quickly that teaching kids how to critically parse information is critical, and it's hard. Like, it's hard to teach kids it's not real. Like when CGI first started getting good, all of us were like, yeah, but you can kind of tell it's CGI. And now it's wild. Like, it's just wild. And yeah, it's really fun for memes. But beyond that, kids need to be able to parse. And it's not just kids, it's all of us, but it is a whole thing. So good educators make for lifelong learners. And that, I think, is a very, very valuable thing. Danielle said, I waited long enough. Oh, Danielle, you're not alone. Brennan has his own vibe. However, his demeanor during cross versus his demeanor during closing versus his demeanor during opening versus argument versus voir dire, you can see him shift gears. It's intentional. He is mindful about the way he does things. I don't always agree with the way he does things, but he is calculated in the way he does things. Erica said, I asked this yesterday. I don't know if you already answered. If she's acquitted, do they reopen the investigation and find a new suspect, or is it double jeopardy to charge someone else for the crime? This is a great question. I don't know if we talked about this yesterday, because yesterday everything wilded out, and then my streaming software completely went and like kicked everyone off the internet. So, with this, if she is acquitted, can they reopen the investigation and find a new suspect? They, in theory, can. It's not double jeopardy to charge someone else. Double jeopardy is a personal and individual right. And so the double jeopardy right of Karen Reed goes to her being charged and put in jeopardy multiple times. It doesn't go to somebody else. The issue becomes doubt. Well, how are you charging this person for the same crime when you said this person did it? Over and over and over again, you did this, you said this person did it. How? The only way it works really to charge one person and then to charge someone else is in conspiracy crimes or conspiracy to commit murder crimes and things like that. When you have evidence that someone has conspired for something, you can charge multiple people, and some members of the conspiracy might be convicted and some might not. But it's not saying only one person committed this crime. Oh, wait, just kidding. Not this person. That person did it. That's really hard because it brings up, okay, well, you all charged somebody else, so obviously doubt. It makes it difficult. Conspiracy crime's a little different because in conspiracy, it's like, yeah, but you all had this agreement and this part in it. So a little bit different, but double jeopardy is individual. Big Dyslexic Energy, a lot of you asked. I hope we covered it fulsomely on the lesser included. It's not bringing new charges. It's giving the jury options because the jury can't convict Karen Reed of all of the lesser included. On that sheet, they can only pick one. So it's giving the jurors option A, B, C, D, essentially. Let's see. Jeannie said, husband and myself took today off. He's having his employees over after lunch for Verdict Watch. They have watched you in the shop for the last few weeks. Hi, everybody. After I got them hooked, I'm so nervous. Cheers from Florida. I hope you have a lovely time on Verdict Watch. Remember, the jury will not deliberate over the weekend. And so if they don't come back before they're dismissed for the day, then it will be Verdict Watch resuming on Monday. And I will let you know in the Law Nerd app when there's a question, when they're coming back into court. I will let you know. Do not worry. The fan is going to hold on for just a minute, but we will let you know. If some of you are like, it doesn't matter, I'm going to be obsessively trying to figure out what's going on. Yes. But for some of you are like, okay, you'll notify me. Just make sure your notifications are turned on. Let's see. Can we poll on how happy we are that we didn't need a what if any counter? It was nice to not have a what if any counter. I wondered this at the beginning of the case. Was Brennan's strategy of not calling all the witnesses going to bite him in the ass? Lally's strategy was, if your name's on the witness list, you're coming in to tell me what you saw. Here it is. All of it. All of it. Here's all of it. Take a look and decide. Lally gave the jury everything. Good, bad, ugly, and different. There's Proctor. Here's Higgins. Here's all the things. Brennan's strategy was substantially different and much more pared down. But it does give the defense the opportunity to say, what haven't you heard and why? is that argument a more powerful argument than what did everybody in the House do? So the argument is really given to the defense by the way the prosecution chooses to try their case. Brennan's a defense attorney. He should be able to plus minus what the defense is going to argue pretty easily. What would you do if you're the attorney in that situation? How would you argue it? Attorneys have to be able to see both sides, even when they don't agree, and have to be able to see them well. How would I argue for this? How would I argue against this? For literally everything in life. Anyone that's lived with and or dated attorneys, I'm sorry. I'm sorry. I know. It can be horribly annoying. It is not always an easy habit, and it is not always something people understand. But lawyers can just this or this or this or this all the time on everything, literally on everything. I can talk myself out of things that I feel strongly about. You know, like, where are we going to dinner? It's like, well, there's going to be more traffic going this way, but I really like this dish there. But if we go over here, then I could wear a different outfit because we're going that way. All of the time. All of the time. It is very on point. Ash Elizabeth, I hope I said that right, said in Super Chat, it's very on point for this trial to have an extended sidebar on the day of closing. So many sidebars. So many sidebars. So many sidebars. Live trial cam may be only slightly better. I mean, that's kind of where we're at with the fan. So I know you guys have gotten the app. There are over 100,000 law nerds in the app, which is absolutely amazing. I love that you guys get to hang out with the law nerds and that I can keep you in the loop. And if like the internet yeets itself, I can just tell you in the app. It's so nice to know. If, you know, my channel just magically goes poof, that was really stressful, I can just tell you in the app. Our bad. Time out. It's going to be fine. It's going to be fine. We'll be back. We'll be back. Bethany said, did she pick the four-person before they random selection? She picked the four-person in seat number 1 before they did the alternates. Let's see. Fabian said, Emily, can you answer the question in regards to DNA found on Karen's car? Did they ever specify if it was blood? No. Wouldn't there be more blood on the taillight due to the amount of damage to John O'Keefe's arm? They tested the taillight casing. They tested not the shards that were found. They didn't really ask about it in trial. I imagine if they asked, it would be like, well, they were all in the snow, so we're not going to test for DNA anyway. The broken pieces of taillight were not tested. The exterior remaining pieces of taillight were. So yeah, it is what it is. Richard the magician said nothing but hurry up and wait. Oh yes. Oh yes. Oh yes. Court. The thing is, court is allowed to wait for the judge. The judge does not like to wait for the attorneys. That is when judges get big mad. Big mad is when they have to wait for attorneys. Yeah. Ask me how I know. Emily, what? You know what happens when judges have to wait on lawyers? You're shocked, right? Wouldn't it just be better if we all started at 10? No. Amelia said, celebrating graduating with my master's in social work is in the best way possible. Good to see you. Thank you for the work you are doing. Amelia, thank you for sharing with us, and congratulations. Stacy said last trial foreman was picked before alternates. Yes, and this trial they did that as well. Emily, how many questions will you have to ask yourself? I've asked all of the questions today. We're going to continue doing it. Thank you, everyone who gifted memberships. Dawn said, can the Commonwealth drop the charges at any time? At any time. I think we heard from Brennan what he thinks of the case. There were some arguments he made that I was like, that's an interesting way to argue that. I mean, you could see why he was arguing what he was arguing. Like, I don't necessarily agree with him. I could follow his arguments, though. His arguments were linear. Whether or not you agree with his arguments, whole different thing. His closing was easier to follow than Lally's closing. He made arguments that we didn't see in Lally's closing, but it was easier to follow. Lots and lots of birthdays in the chat today. So everyone, go shorty, it's your birthday. We're going to party like it's your birthday. Don't worry. Carol C asked, does the judge tell them to stop today? The judge asked them if they could stay till 4 or 4:30. But remember, to render a verdict in court, you need court security. You need all the parties. You need all the court staff. So there will be limits to how late the judge can let them deliberate, depending on the rules for, I would imagine, the rules and contracts for the court reporter, which will be separate than the clerk, which will be separate than the sheriff's. So you have at least to consider the clerk, the court reporters, and the sheriff. Plus, you have to consider the transportation for the jurors back to wherever they park, the overtime for that transportation, how many law enforcement officers it takes for that transportation. So there are quite a lot of like just logistical things. So did I say 4:30? 5 or 5:30, sorry. If I said 4 or 4:30, I translated in my brain to Eastern, from Eastern to Central. I was thinking my time, 5 or 5:30 Central. Damn it, that's wrong too. 5 or 5:30 Eastern, 4 or 4:30 my time. So she told them they could stay later today and asked them if they would. So I think the court, they'll probably have about another, it's almost 4 o'clock local. So they'll have another hour and a half. Bellico said, on our way to H-Town Metallica concert, have the best time at Metallica. Is it 2 nights in Houston? Have the best time. Cassidy said, EDB, do you know any details from polling the jury from the mistrial? If so, can you share how you think the prior jurors' input affected this trial? I only know what we saw from the one juror that was interviewed and then the motions that we saw. I think it did impact the trial in that the jurors that sent motions and the juror that was interviewed said that they were very quick to decide counts 1 and 3 and that they were stuck on count 2. And we saw the Commonwealth talk about count 2 a bit more today. We saw some more clarity in the jury instructions today. And we saw the defense really just doubling down on it doesn't even matter what count it is. Don't confuse yourself with the counts. You don't have to understand all the verdict forms. You don't have to understand all of this. Not guilty, not guilty, not guilty. So the defense leaned into, let me keep it simple for you. The only option is not guilty. So I think that that's how the defense addressed it. But yes, the defense was absolutely mindful of it. Matea said, have you seen any reports of the jury's reactions? Only a little bit from Sue O'Connell, who's in the courtroom. And they talk about it when I've been on Canton Confidential, I think twice this trial, mostly due to timing. But they will talk about it on there a bit. But it's not something I've spent a lot of time looking at. But for looking at jurors, what I find very helpful is when people are in the courtroom the entire time and are like, this is kind of what the jurors' habits and patterns are, and this is the usual or not the usual. I don't find it helpful if somebody watches the jurors like a day or two and is like, oh, they're doing this. It's helpful, like Sue O'Connell was in the courtroom, I think almost every day, if not every day. It's helpful if you watch them over the 8-week time period versus a day or two. But again, it's really hard to read jurors and it's hard to know. And I think lawyers can get a feel for jurors. The more jury trials they do, I think it's helpful knowing if they're taking notes or not taking notes, or if jurors who normally take notes have stopped taking notes. Those types of things are helpful. Did they stop writing it down? But then, did they stop writing it down because they're like, I got the point already. I don't need to hear you go on about this again. Or did they stop writing it down because they're like, I don't agree with that at all. What the fuck are you even saying to me right now? It's hard to interpret it. So it really depends. Jurors can surprise you. But sometimes you can see if they make faces. Shauna M. Richard in the chat said, Emily, will we ever see the sidebars? I don't know. They're impounded for now. If they get unimpounded, then we will see. Let's see. EDB, I have a serious question. How uncomfortable are jury seats? It depends on the courtroom. Sometimes they can have pillows. I have seen jurors who have back troubles and stuff be able to ask to bring things in, but it depends on the courthouse. They can be very uncomfortable. Judges that tend to try to make them more comfortable and bring in like seat cushions and stuff. But yeah, they can be uncomfortable. And you hear the judge say, jurors, go ahead and stand up. They are long days and they are not always comfortable. Claire, good to see you. Claire Loya said, happy Friday the 13th, EDB. My 82-year-old grandpa watches you all day. Hello, Grandpa. It's good to see you. He adores you. He says, leave me alone. I'm watching my friend Emily D. Baker. Grandpa, I really hope that Alan Jackson's language did not too deeply offend. And I hope that you are amused by his language. But my grandparents would never. But it's also up to the lawyer, right, to look at the jury and be like, am I going to offend them in a way that they're mad at me? Or I'm going to offend them in a way that they're mad at Proctor? Because Jackson, I think, was like, I'm going to offend them in a way that they're mad at Proctor. Good. Barbara Bell said, I'm on a grand jury and we have the most comfortable chairs. That's federal money. Well, that's not true. It could be state. Grand juries do have states. But yes, being on a grand jury, I know a lot of people want to do jury duty. I know a lot of people never want to do jury duty. Grand jury would be my jam. Put me in, coach. Grand jurors get to send out subpoenas. Grand jurors get to ask for bank records. Grand jurors are like, hey, can you go find this for me? Bring it back. Give me the tea. What's going on? Look, grand jury's where it's at, especially if you get to do the investigative grand jury. Ooh, boy. We will see. Tanya asked, will they deliberate on Thursday, which is the Juneteenth holiday? Ew. I don't know if courts in Massachusetts are closed. They probably should be closed. If courts are closed and court staff are off, then they will not. If they don't have a verdict by then, I would be surprised if they didn't have a verdict by Thursday. Speaking of which, let's do a poll on how long you think they will take to deliberate. And then we'll do a poll on closing arguments. All right, this poll with over 17,000 votes comparing the two trials. The first one was more clear, 6%. The second was more clear, 65%. About the same, 10%. And I just want to see Proctor again, 18%. It's like, I don't care if it's more clear. Proctor! I know. I'm with you guys. I wanted to see Proctor get cross-examined about getting fired. I realize it probably wouldn't help. I realize that both sides had strategy for why they didn't want to do it. But selfishly, I wanted to see how the prosecution was going to ask Proctor those questions. I wanted to see cross-examination. I wanted to hear it all. So that's what I wanted to hear. But I think it was probably better for the attorneys on all sides that they didn't. The Commonwealth doesn't open up a can of worms shit show with Proctor. The defense doesn't, give Proctor a chance to be like, it's juvenile and regrettable. And then the defense can say, why didn't the Commonwealth show you Proctor? What are they hiding? I get it. But I wanted to hear it. I was ready to hear it. All right. I said I was going to poll on how long the jury will be out. No, Emily. How long will the jury deliberate? All right. Verdict today. Verdict. Monday morning. Add option. Verdict Monday afternoon. Verdict. Verdict Tuesday or later. All right. Today, Monday morning, Monday afternoon, Tuesday or later. So let's go with that. I corrected my typo. So a lot of you in the chat said Massachusetts courts are closed on Juneteenth. I think that's consistent across the country. I know it gets confusing because in times in California, there are holidays that are court holidays, but not state holidays. And sometimes there are federal holidays that are state holidays, but not county holidays. So I never quite know. So I appreciate that all of you are like, nope, they are closed. So let's get to some more of your questions. The jury is out. A number of you, hold on, let me go look. A number of you have said that the jury verdict forms have been shared from those in the courtroom and you wanted to see those. So we will do that before we go look at more questions, because now we're in Q&A. All right. Let's see. These are from Christina Rex. I'm grabbing them from Twitter. So let's take a look at those real quick. Oh, I don't think I can pull that up. Let's see if I can pull that up in the proper browser to make that easy. Let's see. I don't think I can. Nope. All right. We'll do it this way. Emily.
Nope.
Yep. My tech is like, that's not happening at the moment. But at least my weather seems to have cleared up a bit. So yay for me. And it's Friday. Emily, if you start quoting Friday, don't stop it. Girl, stop it. Not today. Not today. It's Friday, but it's Friday the 13th, Emily. It'll work. I promise. Then the chat's going to be like, girl, you're aging yourself. The throwbacks to Friday. It's a great movie. I haven't seen it in a million years. All right. Let's look at the verdict slips, shall we? All right. This is from this trial. So these are the new verdict slips. I grabbed these from Christina Rex, shared these over on the Twitters. This is, or the Bird app or X or whatever it's called. I just can't. I try so hard. But it is what it is. Bird app, Commonwealth versus Karen Reed, verdict slip. Offense 1, murder in the second degree. In the above entitled case, we, the jury, say the defendant is not guilty. Guilty of the offense as charged, murder in the second degree. And this is the unanimous decision of all 12 members. Date, year, signature by the foreperson. That is docketed item 722. Let's go to the next one. This is the one that is going to cause much conversation and discussion. This is the verdict slip for count 2 and the lesser included offenses. So count 2 and the lessers. This is offense 2, manslaughter while operating a motor vehicle under the influence of liquor. In the above entitled case, we, the jury, say that the defendant is not guilty of the offense charged or any lesser included offense. I will say that is more clear than the last one. That is more clear than the last one. Guilty of offense as charged, manslaughter while operating a motor vehicle under the influence of liquor, and then there's A or B, because that's an and or. Manslaughter while operating, and it could be yes, no, maybe so on the and or. They didn't really tell them how to fill that out. Guilty of lesser included offense, involuntary manslaughter, only one option on that one. Guilty of lesser included offense, motor vehicle homicide, felony OUI, liquor and negligence. Check one or both of the following. Motor vehicle homicide while operating, and then the .08. Guilty of the lesser included offense, operating under the influence of liquor. Check one or both. Under the influence, .08. So that is your offenses charged, involuntary manslaughter, motor vehicle homicide, and then just a plain, ordinary old DUI. So it does have not guilty of the offense charged or any lesser included offense, which I think is more clear than it was. So Whether or not the jury comes back on the operating under the influence of liquor will be interesting to see. Count 2 is, I'm sure, the one that the defense is holding their breath on. It also gives the jury, an option to say, okay, she was drinking and driving. She told us that. She said that. Fine. Her license has probably been suspended now for more than the amount of time you would suspend a license on a first DUI anyway. So it gives the jury an option. If some of them are like, but I know she did something, it gives them room to say, fine. Or they can say, you know what, fuck all of this. We're not doing anything. It's up to the jury. All right. Verdict slip on count 3. Leaving the scene of an accident resulting in death. 2 options: not guilty, guilty of the offenses charged, leaving the scene of an accident resulting in death. And then it says this is the unanimous decision of all 12. Date, year, signature. So those are the verdict slips. I've seen a lot of questions in the chat about jury nullification. I think the concept of jury nullification gets confusing. So I'm going to give you how I see it, and we'll go from there. Jury nullification is more of a term of art when you're looking at a jury that comes back on a case where all of the evidence points to guilt, all of it. And you're like, this person is guilty. And the jury goes, yeah, nah, we're not going to do that. We're not going to find this person guilty. There's overwhelming evidence. There is evidence well beyond a reasonable doubt. We know it. We're still not doing it. So when we're talking about the concept of jury nullification, this is what Darrell Brooks was arguing for. The evidence is overwhelming, but you still vote not guilty, where the jury sits there and goes, we're not down for any of this. When there is a case where there is so much argument over what the evidence even is, we are not in a situation where I would even have a conversation about jury nullification, because it's not even a concept that applies here. If the jury comes back with a not guilty, it's because they have doubts in the evidence. It's not because the evidence is overwhelming and they don't like the law, the law enforcement agency, the cop, or some other thing. There are times where communities look at a charge, look at a case, look at the evidence and go, yeah, no, we're not doing that. I don't care what you show me. We're not doing it. Nope. So that is why in this case, it's, for me, not even a conversation. The prosecutor can say all day long, I think the evidence is overwhelming. But when the prosecutor says, look, these tests show that this theory's viable, well, viable's not that's what happened, is it? You look at a case like, well, no, Sarah Boone had an affirmative defense. I think Darrell Brooks is a good recent example of it. You look at a case like Darrell Brooks and go, well, the evidence is really clear. And Darrell Brooks argued to the jury, you shouldn't. So that's why I don't really talk about it in this case, because I think there is a lot of room for the jury to argue over the evidence. You have experts that conflict. You have expert medical testimony that conflicts. You have different arguments on the data that conflicts. You have lots and lots of questions. Laura said the Darrell Brooks case was awful. Yep. It was 100%. All right. So let's answer some more questions. And well, let's see. It's 4:00 local time. They've got about an hour and a half out. I am going to start to answer questions and then we will wrap up. If we need to stream again today, I will let you know in the app and here on YouTube and maybe everywhere else if I can get there, but depending on how fast we go live, because there was that, was it Murdaugh that the jury came back so fast? I had to pick up my kid at band. I don't remember which case it was. I was like zooming home. But I'm not going anywhere today. So if we need to stream, we'll just stream. I think it was Murdaugh. They stayed late and I was like, ah, now my teen can drive. That was the worst. It was very stressful. I was like, no, I don't want to miss it. So stressful. Finn Pitmix said, just got a jury notice today. I have a friend whose dog's name is Finn. Just got a jury notice today. Says July through December. Oh, grand jury. And typically convenes 2 days a month. I'm like, what the fuck? 2 days a month for 6 months? Yes. Doesn't sound as fun as you recently said. No, it sounds fucking amazing. 2 days a month? That's so much better than sitting on a jury for 8 weeks because you get to see a whole bunch of different cases if you get selected. So you do 2 days a month. You get to send out notifications. You get to send out subpoenas. You get to hear a bunch of different cases. So cool. So cool. I think it sounds awesome. But also, I'm weird. And I'm really fucking nosy. So the grand jury allows you to do all kinds of investigative stuff, but you're not sitting on just one trial. You're sitting on oftentimes a bunch of different indictments because they will convene the grand jury and you'll hear a bunch of different cases. Super cool. I'm also a complete nerd and I think that would be awesome. But yeah, a couple days a month over 6 months sounds about right for a grand jury. And a lot of you are saying, I'm in. I'm in on that. And yes, that is grand jury service. All right, let me switch back to our OnlyFan. Now that we have we need the comfort fan. You guys I swear, you're going to put the OnlyFan on. We just need like OnlyFan ASMR at some point because y'all are going to miss the fan, the OnlyFan. Grand jurors typically get paid. They typically get an amount a day. And then sometimes they will get paid by the grand jury and by work. It just depends. And then let's see. Laura said, did you say you're super nosy? Oh yeah, I'm super nosy. Oh yeah. Yes. I don't want to be involved in the tea. I want to know the tea. I don't want to be involved. I want to know. I want to know all the things. So yes, nosy. Question. Does the jury have a verdict slip in their possession yet? They probably do. They've been back at least an hour. They probably do. It takes a bit to send the evidence back, but yes, they would probably have the verdict slips back. I don't think them not coming back today means much of anything. It's been an 8-week trial. The defense told them to go read all of Proctor's texts. They've got all those videos of Karen Reed. They haven't gotten to talk about the case yet. They might just want to sleep on it over the weekend. I'm not reading much into it at all. So Lexi says 28 months flies by. This pregnancy, however, oh yes, they can feel very long and very short all at the same time. It is a whole thing. Pity Mom says, hoping none of my clients call me while I'm in trial with EDB. I mean, we're almost done. We're almost done. Imagine getting a call from court saying, Judge Cannoni wants you here at 8:45 on the dot and then sitting on your hands for this length of time. And for the jurors, they would have had to have been even earlier because they get driven to the courthouse. So the jurors would have had to be there sooner. EDB, the attorneys are going back to the court right now. Saw it on TikTok. Okay. Thank you, chat. I mean, we're staying on the OnlyFans. So if the lawyers are heading back to the courthouse, we will see what that means. The only question is, if it looks like they have a verdict, do we start a verdict stream or do we just stay here? I say we just stay here because why not? But that is why the mods and our team keep an eye on those things because you never know. You never know. So we will see. Let's see if there are any updates online from those that were in court. I'm just looking real quick. So you'll see. It also could be a question. It could be that the court wants to ask if the jury can leave for the day. So you never know. Also, you never know. But the jury went out at 2:39 p.m. local time. It is 4:13 p.m. local time. So we'll see. But we're going to hang out here and answer some questions. We got a little bit of time. Let's see. So we've got a little time. Canton Live states that the lawyers are called back. You'd never know. They could have a question. We're going to wait. So we'll wait and see. But I don't see anyone else saying that. But I appreciate it. So if they're getting called back, then that's fantastic. F. Lan asks, EDB, where are you located? In Alexis in space. Emily, it's too cheeky. It's been a long day. I'm in Middle Tennessee. I'm not in Alexis in space, though I've had enough caffeine today that might change. So let's get to some more questions. Thank you, everybody. Topsy Stitches gifted 5 memberships. Thank you. Tara SA gifted 5 memberships. Thank you. Kobe Mitchell said, Emily, when the jury is picked, do they have specific alternates, or could any of them end up being alternates? Any of them could end up being alternates. I prefer it than telling the alternates they're the alternates at the beginning of the trial, but it is still devastating for the alternates, right? Redondo Beach said, I just moved to El Segundo. I love El Segundo. Enjoy Slice and Pint. I miss Slice and Pint. Sandwiches from Becker's. Hopefully the airport noise is not too bad, depending on what side of town you're on. Rock and Brews, I hope, is still open. I haven't been back into town in a minute. So Angela said, what about 3 missing liters of blood? Angela, I get asked this a lot. It has not come into evidence in this case or the last case. So what we do need to do, though, because I asked, when do you think we'll get a verdict? 18% said verdict today. 15% said Monday morning. 37% said Monday afternoon. 29% said Tuesday or later. We're going to end that poll because we haven't polled on closing arguments. So we need to do that. Let's see. Whose argument was more persuasive for you? And then the defense went first, so I'm putting them first. Defense, Commonwealth. All right. I am putting up that poll. I hasten to say I probably won't be shocked by the results. Chat, I have seen the reports from chat that lawyers are heading back to court. I have seen that. Let's see. So I've seen y'all telling me that. I haven't seen who has reported it. I'm looking real quick, but I've seen all of you saying that they are heading back to court. It could be scheduling. Sue O'Connell on the Bird app said Dedham is celebrating Flag Day tonight with a parade in the square. The judge indicated that today could go till 5:30. It's likely to end earlier. It could just be bringing the jury in to dismiss them if there are transportation concerns. It is 4:15 there locally. And if the jury's being dismissed, it would be a reason to call the jurors back, but we'll just have to wait and see. So I have not seen anything else on that. Miguelina, will you just keep me know if you let me know? So we'll see. Yeah, I'm going to keep answering questions and we'll go from there. Let's answer questions. We will see. Jane said, where's the poll? It's in the live chat. You should see it pinned to the top. So I wouldn't be surprised if the court's dismissing them for the day. It is 4:17 local time. I'm going to get to some of our more recent questions as best I can. Kevin, I do not know. I do not know. There have been some issues with that today. You're not the only one. So I appreciate it. I don't know. But if you put questions in front of your questions, I should see it. But there have been some issues with member chats too. So let's see. We're going to keep going because I'm reading chat. So I'm just telling y'all what chat said. Let's see. Birth Be Sleep said, thank you for the 5 gifted memberships. Orlando said that closing had no structure. Brennan's structure was definitely not as clear for me. I could see where he was going, but it didn't have the same flow. And I think one of the things that, well, I think anyone can forget, the chat's not going to forget, but some attorneys are going to be more charismatic than others. And Jackson is an incredibly charismatic attorney. He is well organized, he is practiced, he is dedicated, he is smart, but he is also charismatic. So he can get some of the digs in that with Brennan would come across as too snarky or too heavy. It's just different. So you never know. Allie B in the chat said, why did the defense go first at closing today? I forget that Massachusetts does it that way. They do defense then prosecution because prosecution bears the burden instead of doing prosecution, defense, prosecution. I completely forget that they did it that way. It is so outside of what I am used to seeing, but that is what is the standard practice in Massachusetts. And I always forget because in South Carolina, in Florida, in the rest of it, we will see that kind of sandwich prosecution, defense, prosecution. Doodlebugs at EDB, did the defense actually rest on Wednesday? Sound was so bad I didn't hear it. They said subject to that ruling, we rest. And so, yes, the defense rested. They didn't rest formally in front of the jury. Marco Palazzo in the chat said, Emily, when you were a prosecutor, what did you do to relieve stress or the weight or the stress of the weight? What did the other lawyers did? It really depends on the case, because sometimes you're not even out of the courtroom yet before a verdict comes back. But it depends on the attorney. Oftentimes you have a million things you have to do. So sometimes it's just the practical tasks. Sometimes you just literally sit in your office and stare at the wall. Sometimes you're just walking around talking to your coworkers. This happened, that happened, kind of decompressing, discussing the trial. I would often talk to court staff and talk to them about what they thought of the case and see what they had to say. So it really depends on the attorney. The longer it goes, the harder it is to mitigate stress, especially if you're in a courthouse that isn't yours. When you're in your own courthouse, you can go back to your office and check your voicemails at least, answer your emails, but you don't get a lot done. It's not productive. It's not productive time at all because you're waiting and you could get called at any moment. For anyone who's neurodivergent, the fact that you might get interrupted at any possible moment means nothing will get done. It's like if you have an appointment at 4 p.m., your entire day is wasted because you're like, but if I miss this thing, it's like that day after day. And you start to get a sense on questions if a jury is having issues. You can get a sense for that. Y'all, we've got the fan up on live. So I see you in the chat saying that the lawyers are coming back in. I have not heard why, but I know that they are going back in. We've got the live feed up, so we will see. Luna said, glad to make Verdict Watch. Today's also my birthday. Tons of you with the Friday the 13th birthday. My 6-year-old doomling listening while I braid his hair wants to know if we think, well, I'm sorry, sir, we do not poll on the things. We will wait and see what the jury thinks. But the chat overwhelmingly was more persuaded by the defense's arguments. I have heard that the attorneys are back in court from the chat. You have told me where they're from. So lots of people have said it. Does the jury receive court transcripts? In the jury instructions, they are told that they do not. So let's see. Lots of you have said that the defense is back in the courtroom. We are on the fan. So we will see what happens when it happens. We're here. So let's see. I'm going to take a look in 2 other places. Miguelina, do you want to ping the app and let them know that we hear that the attorneys are coming back to court? Might be something, might be nothing. Just let the app know we're waiting to see. Because might be something, might be nothing. Might be getting dismissed for the day. Might be more than that. We have no way to know. So we will wait and see what happens. Let's see. I am looking for a few different updates from those in court, and I am not seeing anything. I saw that Kathy Russin said it. Let's see. I am not seeing anything updated. Let's take a look. But Court TV showed, you guys said, the attorneys walking back into the courtroom. So I might just go take a look at that. Parties are heading back to the courthouse. Everyone is saying they assume it's going to be the end of the day. I would assume that too, that the jurors are getting dismissed for the day, but we'll see. So you will know. Sandra said, Emily, what are we watching next? It's going to depend on timing. So it's just going to depend on timing. It should be Kohberger, but I don't think there's anything that's going to happen in between that. But then again, there are still things that are unknown with Kohberger. So there are still motions outstanding. So that's what it should be, but we don't know until we know. So, all right. They might be getting dismissed today. I wouldn't be surprised if they do, but let's see. The court asked them if they could stay longer, but we have seen numerous people online state that the Dedham area is having an event this evening. So it wouldn't surprise me if they get dismissed. I'm just going to wait and see if they pull it on to the record. So we'll see. They might not. They might. Chris Spade said Friday the 13th horror movie marathon tonight. Enjoy the movies. Daughter Bree had wisdom teeth out yesterday and watching you with me. Hello, Daughter Bree. Get some rest. It's going to be sore. It goes by quickly. Casey Cat said, if I were a juror, I'd be PO'd at the court regardless of the reason if she sent us home early. Fair enough. But if the roads get blocked for a parade, there's not much you can do. I would think that the court would know, though. Holly, I love your Animal Crossing animal. Thanks for the daily case briefs, Emily. The past 2 weeks have been super busy with life stuff, and the daily briefs help a lot. Team Baker has absolutely crushed the case briefs. Jordan, our editor, has been absolutely steadfast in making sure that you guys get those. Our whole editing team, Megalina on the production team, and the mods, it's been a team effort, and I know you guys appreciate them. I'm so glad that you do, because that is why we do them. Some people are like, I am noped out of this trial, just keep me in the loop. Some people are like, I want to watch every minute. And some people are like, okay, I want to watch every minute but life, so I need to be able to jump back in when I can. So we are just waiting to see if they put anything on the record. Jen said, why was the last trial not considered a split verdict? Because no verdicts were rendered in court. And when no verdict is rendered in court, there is no official verdict, which is why the state Supreme Court said that there was no double jeopardy issue. So let's see. I am supposing that they are probably going to get just dismissed. That would be my guess at this point, that they will get dismissed for the day, but we will see if they do. I know Megalina is keeping an eye on updates, so we will see. The jury went out at 2:39 p.m. local time. It is 4:26 p.m. local time. They have not had a lot of time to deliberate, but the lawyers are coming back into court. Sue O'Connell just tweeted, we are in the courtroom. Defense is here. The O'Keefes are not. We wait. So I'm keeping an eye on social. It really may be that the jurors get dismissed. That really might just be it, that they're done for the day. Yesterday, the court asked if the jurors could stay, or asked the court staff to ask if the jurors could stay. It doesn't mean that they will. So I wouldn't be surprised if the jurors are getting dismissed. We will see. It looks like the camera is moving. Jury is here. Judge is on the bench. I imagine we now have audio. I imagine they're getting dismissed for the day. That would be my guess. So let's tune in and see what happens in court. Thank you to everybody that came over from the app. I imagine we're at the end of the day, but who knows? We will see. I would guess it's the end of the day. Honestly, that would be my supposition if I had to suspect. So.
Court is in session, please be seated.
But we'll see.
All right, jurors, I understand you want to go home. It's been a long day for us. We appreciate everything you've done today. I do have to tell you those same cautions. Please do not
Did you hear what she said? I understand you want to go home.
discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Do not talk to anyone, and that includes each other. So when you walk out the deliberation door, you have to stop talking about this case. Even when you come into the courtroom, don't mutter anything to each other, certainly not on the ride or anything like that. So it's very important that you remember that. And you cannot, even if you get here before you're called into court on Monday, you can't discuss the case then either. And that goes for the alternates as well. So, we really appreciate that. Watch your social media use and the papers and the news. Stay away from all of that if you can this weekend. We'll see you Monday morning ready to start fresh. Thank you.
All right. And with that, the jury is gone for the weekend. The jury will not be deliberating over the weekend. The jury was like, can we go home? I am sure they are exhausted. It is a lot to think about. All right, the court's coming back on the record. And the court's coming back on the record, it seems.
All right, well, I hope everyone has a good weekend with no work.
Thank you.
Have a good weekend. All right, for everyone just coming in, you're asking, what did you miss? The jurors wanted to go home. The jurors wanted to go home, and the jurors are going home. So the court says, I understand you want to go home. We'll back it up and do it one more time. The jury just came in. It is just before 4:30 local time, and the jury is gone for the day. The jurors were ready to go.
All right, jurors, I understand you want to go home. It's been a long day for us. We appreciate everything you've done today. I do have to tell you those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Do not talk to anyone, and that includes each other. So when you walk out the deliberation door, you have to stop talking about this case. Even when you come into the courtroom, don't mutter anything to each other, certainly not on the ride or anything like that. So it's very important that you remember that. And you cannot, even if you get here before you're called into court on Monday, you can't discuss the case then either. And that goes for the alternates as well. So we really appreciate that. Watch your social media use and the papers and the news. Stay away from all of that if you can this weekend. We'll see you Monday morning ready to start.
All right. So at the end of the day, it seems that the jury asked if they could leave just before 4:30 local time. The jury went out to deliberate just after about 2:39, according to Ted Daniel, local time. So they were out for a little under 2 hours, and they will be back Monday. So I will be on a very close verdict watch for Monday. Remember, they do get that very strong admonition. Don't just take a straw poll. Go through the evidence, give it a thorough look. I am sure the jury is tired. I don't blame them. And it might well be that they want to take the weekend, sit on it, and come back and talk about it on Monday. Because I'm sure they're tired. I am sure it has been a long day. Lots of starts and stops. So the jury said they were ready to go. They are ready to go. They're ready to go. I think that it wouldn't be surprising if they said, hey, we're probably not going to be able to come to an agreement on this tonight. It's a lot of shit to go through. Let's just come back Monday. So that doesn't surprise me at all. And she told the lawyers, have a good weekend. No work if you can manage it. So jury verdict watch is done for the day because the jurors are done for the day. When we polled, a lot of you thought that we would have a verdict on Monday. A lot of you thought, with almost 20,000 votes, whose closing argument was more persuasive, defense versus Commonwealth. About 97% of you thought that the defense closing was more persuasive. I'm going to let you guys continue to vote. We're going to answer some more questions. A lot of you are like, I'm off to Stormwatch. I'm going to be off to Stormwatch in a minute too. I'm going to answer a few more questions. We are going to be on Verdict Watch. We are going to be on Verdict Watch on Monday. There will be a new podcast for you Monday. On Monday, we will be talking about some of the things that have happened in the other cases that are going on in the sphere. A lot of you have said, Emily, what's going on in Kohberger? I did a podcast on it 2 weeks ago on the Emily Show. So if you go over to the Emily Show channel, I break down the new defense motion in Kohberger. I think it was two Mondays ago, but there will be a new one. Members, I will send out a notification. I'm not sure when I'm going to get to record because I have some more reading to do. My brain is very tired, but I have some more reading to do before we do a breakdown. We are going to check in again on the Diddy case. Every time I put up an update on the Diddy case, half the comments are, ew, no, please stop. And half the comments are, can we get more Diddy coverage? But we will put that up there. So with the Verdict Watch, Monday, I will be keeping a close eye on this, as will Team Baker. If we need to go live, we will go live. We will let you know in the app first. I will try to notify elsewhere on social. It just depends how much time we have. So Monday, we will have a new episode of The Emily Show, and then we will go from there. I might move the members only to Monday. It's just going to depend on where we're at. So there will be a new Emily Show podcast. I will be recording it this weekend. I'm not quite sure when yet. Melanie, thank you. And everyone who gifted memberships, thank you for the gifted memberships. Jade, thank you for the gifted memberships. I appreciate y'all. Liz said, your coverage is the best, and my wife agrees. Liz, thank you to you and your wife. I appreciate it. Because, look, we try to break down the law with the law nerds, best chat on the internet, have a conversation about what's happening, have a conversation in court, while remembering that for us, we are watching this unfold. It can be stressful watching these cases when you are not connected to it. One of the things that I really appreciate about the law nerd community is that the community remembers that there are people involved that are very stressed. So many of you have been impacted by cases yourself, yours, a loved one, something that's happened to you, cases that you've sat on, friends that you've stood with, family that you've walked with. And so keeping in mind that the way we talk about the cases, we talk about what the lawyers have proven, what the lawyers haven't proven, how the lawyers are doing their job, what is happening in court, how the witnesses are testifying, and keeping in mind that, again, these are all people. And they are incredibly stressed. And the O'Keefe family is incredibly stressed. Reed's friends and family are incredibly stressed. The attorneys are probably the least stressed, and they're very stressed too. But the attorneys are used to it. It's not the most helpful to be used to, but anyone who works in a high stress field kind of gets that little bit of a numbness to your high stress job. So the attorneys, I would imagine in this case, are also fairly stressed, because it does seem that the defense team has been walking through this for 3 years with Karen Reed, and you can tell that they are invested in this case. Every case is not the same, and you can see the different investment here. So with all of it, in the chat, I think ex-piano player said, I just realized Brendan never brought up the hoodie. Oh, not once. Oh, not once. Oh, not once. I'm going to have to go back and count whether he said Proctor more or called Jen McCabe a soccer mom more. But the amount of time the defense talked about Jen McCabe was like this. The prosecution talked about Jen McCabe a whole bunch, didn't they? It was interesting to me. Casey Cat said, Happy Father's Day to all our law nerd dads and spouses. Absolutely. I know we will be spending, well, I might end up recording on Sunday. I don't know. It is going to depend on timing, but I'm trying not to, because I want to spend Father's Day with Dr. B. and do some gardening that we want to do. Why? Because we're nerds. And I very much like to garden. Jillian said also that boulder analogy. Oh, it was not good. It was not good. It was not good, the boulder analogy. Also, the boulder analogy was not thoughtful, and I don't think you need a boulder analogy like that. So for all of you asking, and I've seen some others coming in and asking, the jury's been dismissed for the day. That's why the attorneys were there. The attorneys were there so the jury could go home for the weekend, and the jury went home for the weekend. So Johanna said, do you think they have a verdict or want to sleep on it? Generally not in the amount of time they had. They might have a verdict. They're not going to have all of them. It's going to take them time to go through count 2. It really is. Count 2 is not easy. The jury instructions on count 2 are pages and pages long. The verdict form on count 2 is thick to parse through. And at the end of a day and hearing all of the closings and then trying to sit down and be like, okay, now what do all these say? They might just need a minute to breathe. Ava said the Star Wars analogy from Sarah Boone trial was better than the Boulder one. It was. We definitely got to use the Force in that. I mean, no one said distributed loads in closing, though. No discussion of distributing loads at all. Aaron, what happened to Donna Adelson's trial being this summer? It got pushed back till August. I will give an update on trial timing in Monday's episode for a few trials that I'm tracking. It might have gotten pushed right into the time that the Koberger case starts if Koberger doesn't get pushed. So it's just going to depend, which is why I say, what is the next trial? I think it's Koberger, but it's trials. Trials are dynamic and shit happens. So I don't know. Salty old guy said court asked them to come in early, late start, and then asked to stay late, dismissed early. I don't think it's shenanigans. I think the jury's tired and is ready to go home. And on a Friday, I don't blame them. So yeah, I get it. Right? I get it. Claire said, as the child of a lawyer, I was raised on analogies. There are times that my youngest looks at me and he's like, I've got it, Mom. You don't have to explain it again. I'm like, right. Because it's a fear for attorneys. Like, what if I just explained it this way? What if that's what resonated with someone? What if I explained it slightly differently? What if that's what resonates? It's hard to stop because it's like, but maybe that one more sentence will help. And it's one of the things we talk about a lot here is knowing when to stop and knowing when to sit down. And I think we've seen a couple times in this case where Brennan pushed that one question too far, which one question too far as a defense attorney is different than one question too far as a prosecutor. But the one question too far as a prosecutor, he got some answers that he did not know the answer to and should have seen coming. He should have seen coming. He knew those experts were going to give it to him. Like X going to give it to you. He knew those experts were out for him more than DMX is out for Diddy. Like, or 50 Cent is out for Diddy. Or both. We knew he was going to give it to him. And he just kept asking. Just kept asking and asking. Just kept asking. I went from DMX to 50 Cent. I know. 50 is, yes, I think DMX is haunting Diddy. Yep. I hope Diddy hears it. I'm teasing. No, 50 coming for Diddy. My brain is so tired. But DMX is great. Should be haunting Diddy. Diddy, what'd you do? Emily, we're not talking about the Diddy case. We're not talking about the Diddy case. We will a little bit on Monday. We'll do an update. But that case is tough. It is a difficult case. TKC said, did they use their allotted time? Not today. They did not use it today. But they were done. And when the jury's done, they get to say that they were done. So I think taking the weekend and coming back in Monday and then deciding, I would imagine the jurors probably expect that whatever they do, this case has a lot of attention. It's going to be like a thing. So the jurors are home for the day. Law Nerds, we have been streaming like 7.5 hours. There have been Well, 60,000 plus of you here today. Some of you are asking about when's the Corey Richards case. There's a hearing on that today. I will update you on the podcast. So there are still some outstanding appellate rulings in the Richards case that I am waiting on. Don't worry, we'll have all the case updates in the Emily Show. I need to prepare for that. I'm going to try to record tomorrow. Members, I will send it out. If we don't come back on Monday with Verdict Watch, we will try to do a members only live, but don't worry, we will get to them. When, I'm not sure. It will just depend. It will just depend. But for now, Law Nerds, I know we didn't get to all the questions. We had so many of them. You guys are the best. I appreciate you. Thank you for being here with me. One last reminder that if you are going to be on Jury Watch, Verdict Watch with us, make sure you have the Law Nerd app. Also, we have some exciting stuff coming for you, things you guys have been asking to restock. If you are interested in restocks in the Law Nerd shop, this is where we will let you know first. So, in the member spaces and in the app is where you're gonna stay in the loop. So make sure that you have the Law Nerd app. If you have shit you've got to do on Monday, make sure your notifications are on. Sometime this weekend, I'll send you out a message to be like, hey, keep your app open, keep your notifications on. When we go live, we will tell you. Because we are going to watch this verdict come in together. And so help me, if they try to bring this verdict in while I am on a plane to go see the Dave Matthews Band, I am going to lose my fucking mind. No, I cannot. I have travel. I have concerts. But a lot of you thought this verdict will probably be back Monday or Tuesday. I don't disagree. We will know more as we get into the day on Monday. We're not doing it. We have to travel. We must travel. Law Nerds, you are the best. Thank you for being here. Huge thank you to the mods and everyone who has ridden with us this trial. Remember, last trial, it took more than 5 days for them to come back with the non-decision. I think the jury instructions were clearer this time. I think the verdict form, though not ideal, is clearer this time. Get some rest this weekend. Nothing is going to happen this weekend. The jury isn't deliberating. Catch up on your life stuff. So if Monday you are going to be like, I need to know, get your shit done this weekend. If you are celebrating Father's Day, enjoy it. And I will see you soon. Get the app. Thank you again to the mods and Team Baker. New Emily Show on the Emily Show YouTube channel on Monday. I'll also tell you about that in the app. You'll know your notifications are working when you get a notification for the new episode of the podcast. That's how you'll know it's working. That first notification you get on Monday is not going to be for a verdict. It's going to be for the podcast. And then you'll know your notifications are working. With that, I will see you soon. Law Nerds, you're the best. I think I'll probably see you Monday, but who knows? Bye. Thanks for joining me on this stream. If you don't want to miss a moment in court, you need the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android where I can keep you in the loop with everything happening in court and, of course, when the jury has a verdict. So if you don't want to miss a moment of this trial coverage, make sure you get the Law Nerd app. Thank you for being here, and thank you for being a Law Nerd.